Good morning. It is Thursday, day 23, the last day, the final countdown, if you will, of the Depp versus Heard trial. It is our last day of witnesses. We are going right into the court. The microphones are not on yet, but we can see Johnny Depp just coming into court. We will probably have a few rebuttal witnesses left, but the most important thing we can do right now is a time check. We have Johnny Depp at 7 hours, Amber Heard just at an hour. And with that, we are going to roll the intro and get into your questions. Thank you so much. All right, let's roll. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. And you guys, it is so good to see all of you. Again, this audio is not on. Let me know where you are coming in from. I am not, don't do that. Don't go and show the arrivals. We're already in court. Back to court, back to court. I can't tell what song that is yet. So we are just being able to see comments. We were having a little bit of a tech issue this morning. I just got coffee from above. Let me know where you're coming in from, what you're drinking. Ouch, ouch, that hurts, that hurts. Sky News. This court, I mean, there's only one more day for people, so I am sure that waiting for court got absolutely wild. Hopefully they will go right back to court as we watch it come in. So good to see all of you. So it's just, you guys are coming in from all over the world, and we already have over 50,000 of you in here. What do I expect from today? I don't know. What do you expect from today? I think we will see a doctor, a forensic MD, to talk either about Johnny Depp's finger or about Amber Heard's testimony and what injuries she did or did not have. Because the jury doesn't know, what does a normal, or what does a broken nose normally present like? I'm going to turn this down just a little, it's so loud. What does a broken nose normally present like? What does swelling look like? How long do these conditions last? What was Amber Heard's testimony about that? Is it consistent, inconsistent? Again, Team Heard only has an hour left. We know that there was we think it's the MDMA flight attendant, which is probably not fair to call it the flight attendant because they probably weren't doing MDMA with Johnny Depp.
Do you have any preliminary matters at this time? Okay, sure. You want to come forward?
So they're approaching on a brief matter. So we might see the flight attendant for Team Depp, and then we will see Team Depp rest their rebuttal, and Team Heard will have a chance to bring rebuttal witnesses. Will they bring rebuttal witnesses? I don't even know if they're going to have time to bring rebuttal witnesses. It might be opening a door that they can't close after yesterday. Will we see them bringing up the text messages that we know, because we look at the internet, that looked like they were, incoming and not outgoing? The ones Depp said, these don't sound like me. It didn't seem to get caught in court. I don't know if it will come up or if it will just wait for argument. I'm sure they found it. I'm hearing Amber Heard is taking the stand again. I can't imagine. I can't see how that's a good idea. But this might have been part of the strategy. Look, this is all strategy at this point. This is strategy and time management. That might have been part of the strategy of putting Depp on the stand, is forcing Heard onto the stand when there isn't enough time for her team. I mean, the hair is a little bit more down and a little softer, which we've seen other days that she's testified. It's, isn't it? I'm going to get to a few questions. I thought Amber's team didn't get a rebuttal since they rested. They are getting a rebuttal because there is a counterclaim. Judge A said that yesterday. I thought we were going to see rebuttal witnesses just from Depp, and then rebuttals, two rebuttals in the in the closing. But Judge A said there will be time. There will be time for Amber Heard's team to have a rebuttal. So that will be very interesting. So we've got two attorneys up here, Rottenborn, I don't know who this is, and Camille Vasquez up there talking about who knows what. Shout out from Scotland. Thank you, Scotland. Camille, please show photos from the L'Oreal event. We will see. Let's see. I'm seeing some issues that I'm echoing. I'm not seeing those on my end, but I know that our audio crackling. All right, give me a second, you guys, and let's see. Thank you, chat, for letting me know. Hopefully that will fix it. Sometimes you just have to turn things off and turn things on. It's just been a tech day already, and that happens again. So thank you. Sounds good. Thank you, guys. I'm so excited for closing tomorrow. So we'll see who the next witness are. Are closing arguments included in the time limit? No. Oh, that was a user error. No, they're not. And then once we get the closed captions up, I'll pull it up. My brain stopped after this week? Yes. Testified the op-ed was not about Johnny. She actually ended up saying on cross it was about him and others. And so I don't know if that will come up again. Let's see. Let's have a fun time today, Emily. I'm here for it. It's closing tomorrow. Yes, closing time. Mercury retrograde definitely entered my morning today with all the tech stuff. Yeah, it is closing time tomorrow. Each team will have 2 hours to close.
All right, have your seat.
All right, court is
All right,
resumed.
your next witness,
We call Dr. Richard Gilbert, Your Honor.
All right.
Gilbert.
This is, I don't know the name of this attorney. We haven't seen him. We've seen him, but we have not seen him questioning witnesses. This is likely the forensic MD.
Testify truthfully in this case under penalty of law.
All right, Dr. Gilbert, let's take our time. You've got plenty of it.
Good morning, sir. Good morning.
All right, day 23. I forgot to text the text crew. It's going now. I'm sorry.
Would you please state your name for the record?
Richard Stephen Gilbert.
And what is your occupation?
I am an orthopedic surgeon and I have a subspecialty training in surgery of the hand and upper extremity.
Might just go to Depp's hand then.
Dr. Gilbert, where do you work currently?
I currently work in New York and Long Island at Northwell Health.
And you mentioned you have a specialty. Can you tell us a little bit more?
He said
about
specialty
your
and subspecialty.
specialties?
So after medical school, I trained in orthopedic surgery and I did an orthopedic surgery residency. And for a year thereafter, I did a hand and upper extremity surgery resident fellowship. And so my practice for the past 22 years has been limited to surgery of the hand, wrist, and elbow.
And I think you may have gotten ahead of me there, but how long have you been practicing?
Then don't ask the
22
next
years.
question. Just move on.
What percentage
He told
of
you the
your
things.
practice over the past 22 years has involved surgery?
Approximately 1/3 of my practice.
Okay. And other than that 1/3 that involves surgery,
Let me make
what
it
does
bigger,
the rest
sorry,
of your
yeah.
practice entail?
The rest of my practice entails some academic work, but mostly seeing patients in the office, seeing them either pre or post-operatively.
go.
A large portion of hand surgeons
Better.
treat patients non-operatively.
In terms
better,
of the
better.
surgeries that you do, can you describe for us the types of surgeries that you will perform?
So again, I
No.
limit my practice to hand,
talk
wrist,
about that
and
at the
elbow. I would
break.
say approximately 75% or so of my practice is limited to the hand itself. And this really varies from anything from conditions like carpal tunnel syndrome to
Carpal tunnel's
tendinitis
the worst.
to injuries such as amputations, fractures, sharp lacerations.
I don't
etc.
think today will be a full day. I think they might run out of
Over
witnesses,
the
but
course of your
there's 8 hours of
22
court time
years of
between the two
practice,
sides. It's
how
possible,
many
but
surgeries
unlikely.
would you estimate you've performed?
I perform about 300 to 400 surgeries a year, so a rough estimate would be approximately
surgery.
10,000, maybe a little less.
Don't know.
Where are you currently licensed?
In New York.
And how long have you been licensed in New York?
I have been licensed in New York since 1994.
Are you board
That would be,
certified?
28 years.
And do you have any certifications?
Yes.
And can you tell us about those?
I am board certified by the American Board of Orthopedic Surgery, and I have a certificate of added qualifications in surgery of the hand from the American Society for Surgery of the Hand.
When did you receive your board certification?
2002.
And can you describe for us what current positions you hold?
I am currently an assistant professor of orthopedic surgery at Northwell Health, and I'm also the president-elect of the New York Society for Surgery of the Hand.
After Depp's witnesses are done.
In what professional organizations are you a member?
I'm a member of multiple orthopedic organizations, including the American Board of Orthopedic Surgery, the American Association of Orthopedic Surgery, and the American Society for Surgery of the Hand, as well as the New York Society for Surgery of the Hand.
Unlikely that Amber Heard gets
Have
extended
you
time.
published
Very
any
unlikely.
articles in your field?
Yes, I have.
Have you testified as an expert before?
Yes, I have.
Can you ballpark for us how many times?
Certainly less than 10 over the past 22 years.
This is not his.
Your Honor,
This
at
is
this
not what he
time, we'd like
does
to offer Dr.
regularly,
Gilbert
which is
as an
really
expert
nice.
in the field of orthopedic surgery, specializing in the hand.
Yeah,
Any
there will
objection?
there
No
will
objection,
probably
Your
be
Honor.
finger
So moved.
pictures.
So, Dr. Gilbert,
There will probably be finger pictures.
what work were you asked to do in connection with this case?
So I was asked to review medical records, radiographs,
So far,
pictures,
all
as well as
Johnny Depp witnesses this
testimonies and
morning
depositions
until they
related
rest.
to Mr. Depp's finger injury.
Okay. And to your understanding, what is Mr. Depp's explanation of how his finger was injured?
He describes that he
So just
was
to Depp's finger.
in Australia and his right hand was over the side of a bar when a vodka bottle was thrown at his hand, injuring his right middle finger. And he describes that the vodka bottle exploded.
Was it possible the finger was injured that way?
Are you aware of other explanations for that injury?
There have been multiple other explanations, but I think the one that was brought out was by Ms. Heard, who believed that Mr. Depp was holding a landline and out of anger was punching it against the wall, and this resulted in his right middle finger injury.
Based on your review of the medical records and other documents in connection with Mr. Depp's finger injury, how would you describe the nature of the injury to Mr. Depp's finger?
High velocity. I'm waiting for the words high
Well, the
velocity.
nature of the injury was he had what we describe as a comminuted fracture of the distal phalanx, meaning there was a fracture of the tip of the finger, and comminuted meaning that there were multiple pieces. So this is some type of blunt force with a high mechanism of injury. He also sustained loss of the tissue along what's called the ulnar side of the finger towards the little finger. And this appeared, based upon my review of the pictures, to be some type of sharp laceration because it represented a clean edges of the wound.
So not a door if it's a sharp laceration because of the clean edges.
Can you take a look at Plaintiff's Exhibit 60?
Warning,
And
warning,
to go
warning.
to page 3.
We might get into bloody
And
pic,
Dr. Gilbert, are
bloody,
you familiar with this?
bloody fingy
document?
pics.
Yes.
And,
This
and
is
what
a
it?
new witness.
So these are two radiographs, x-rays,
good x-rays.
of Mr. Depp's finger, his middle finger.
Okay. Sorry, just to stop you, but Your Honor, may we publish this to the jury as a demonstrative?
Any objection?
The x-rays should be in evidence.
All right, we'll identify it as 60, page 3.
I thought the
and
x-rays were in
published to the
injuries.
jury.
And Dr. Gilbert, sorry to cut you off there.
An injury.
Can you just tell the jury what we're looking at here in
So
this
we're looking
X-ray?
at two x-rays of
we'll
Mr.
probably
Depp's
see
right
it.
middle finger after the injury. And towards the tip of the finger, there's a fracture, again, what I described as a comminuted fracture, meaning there are multiple pieces at the tip. There's also a transverse component to the fracture closer to the joint.
I think he means there. But not
In your
a
view,
doctor.
what types of mechanisms can cause this sort of injury?
So this is a mechanism of injury that has high velocity or force, generally a crush type injury. A simple
the high
fall
velocity.
would not result in a comminuted fracture such as is seen in these x-rays.
And we're using the term comminuted fracture. Can we just define that quickly
He already
for us?
defined it. Were you
So
not
again,
listening?
comminuted, and it's not
He said-
particular to a finger,
didn't say again, which was
is
nice.
a medical
We've already
term
defined this,
for
sir.
a fracture that has multiple fragments.
In your opinion, could this injury have been sustained in the manner Mr. Depp described?
I do believe so.
And how might that work? How might a thrown vodka bottle produce an injury like this?
So a vodka bottle, which is a hard object,
Surprised they didn't object to
would have
foundation.
crushed the tip of the finger, resulting in the comminuted fracture. And in addition, as the vodka bottle broke, the glass would have lacerated the finger, resulting in the soft tissue loss that was also seen
Always
with this
possible.
injury.
You won't
What's
know.
your assessment of the description of the cause of the
This is
injury
another
offered by Ms. Heard?
Team Depp lawyer. Don't know who
I
it
think
is.
that's highly unlikely.
And why is that?
Because one, in general, when an injury is caused by punching against a wall or a hard object, it is extremely rare to see an injury to the tips of the fingers, which is seen with Mr. Depp's injury. Generally, you're holding something with a fist, and that in general leads to injuries most commonly of the knuckles here, or fractures of the metacarpals. We call these boxer fractures. Second most common after those would be injuries to these, but as you can see, if
It's
you're holding
surprising
something
to
and
me.
hitting against something,
Heard's witness
it is
didn't get into
very
this at all.
unlikely that the tips of the fingers will be injured. In addition, just taking into account the radiographs and the pictures of the injury, I would not believe that a blunt force, solely a blunt force against a wall would result in the soft tissue loss.
What other injuries, if any, would you expect to see on Mr. Depp's hand if the injury had occurred as Ms. Heard described?
So if that were the cause of the injury, you would certainly, that would be a dorsally directed. So this is the dorsal in the back of the hand as opposed to the palmar side. So if you're punching against something, you would certainly expect an injury to the nail bed. And those are always seen in those type of injuries. If there is an injury to the tip of the finger, which again, I said is rare. So you would see either a loss of the nail or blood underneath the nail called a subungual hematoma.
What if everything under the nail's
In
gone?
your review of the medical records, did you see any sign of anything like that?
None whatsoever.
I guess both doctors agree there's no bruising under the nail.
In your view, is the injury, can you explain to us exactly why you think the injury is consistent with Mr. Depp's description?
Well, again, his hand, he describes his hand being held over a marble bar, which is a firm, something firm, unyielding, and the bottle hit against the finger. So basically the finger was crushed, resulting in, again, what I described as a comminuted fracture. And as Mr. Depp described, the bottle exploded, so
I don't know how much more they can ask him.
it's certainly reasonable that the glass that exploded as well led to the soft tissue loss along
won't
the
tell
ulnar
Jessica.
aspect of this finger.
Now, did you observe the testimony of Dr. Richard Moore?
Yes, I did.
And he testified about Mr. Depp's finger injury as well?
Correct.
Right. Did you agree with Dr. Moore's testimony?
Certain parts of his testimony I did, yes,
Fair.
but not all of it.
Focusing on the parts that you, well, first of all, why don't you tell us what you agree on?
Well, I agreed in terms of his
a
interpretation
comminuted
of
fracture.
the x-rays, saying that he had a comminuted fracture and this was some type of high force injury.
Okay. What did you disagree with?
Well, I disagreed
Everything
with
else.
several things that he said. He first said that he does not believe that the mechanism of injury could be, as described by Mr. Depp, holding the hand on the side of a marble
Closing will be
bar,
tomorrow.
because he said it was all a palmar injury, and there was a palmar component to the injury. I'm talking about the soft tissue loss, but there was also a dorsal, meaning the back of the finger. So the soft tissue loss was actually, if you looked at the pictures which were shown when Dr. Moore testified, the injury goes like this. So it's an angled or an oblique type injury. And there's no way that anybody could determine whether or not it was a palmar directive force, meaning from the palm side, or a dorsally directive force. But certainly either are plausible.
So that makes sense that the injury
Anything else
is
come to
coming
mind that you disagreed with?
this way or this way.
Well,
Makes sense.
he also described that this was definite. Well, he thought that this was a pinching or what he described as an avulsion type injury. And that's referring to the soft tissue loss. That's certainly possible, but if you look at the pictures that were shown when he testified, the laceration looked fairly clean. There were clean edges, it was not jagged. And generally when you have an avulsion or a pinch type injury, you see a very irregular border to the skin. It's pinched off, you can imagine, as opposed to something that's cleaner that would be lacerated by, let's just say, a piece of glass or a knife or whatever. And that's more consistent with the pictures of Mr. Depp's injury.
Expert witnesses are there to
And we
review
were
other
using the
testimony.
term soft
So
tissue
they are a
loss,
bit
and just to
different.
make sure we're on the same page.
That's why.
Can
No,
you
don't
just
show the
tell
picture.
very quickly what you're referring to there?
Right,
Vesuvius.
so there were two components to this injury. One, the fracture of the bone, and two, he had loss of the soft
Monica,
tissues
exactly.
so that the bone was exposed. So that amputated part that was found at the bar.
I hope someone asks him if he's an expert on vodka or vodka bottles.
Now, you were saying that Dr. Moore testified that this was an avulsion, meaning a pinching injury, right?
Correct.
Why do you believe it's more likely that it was a laceration?
Because the edges were
Well,
clean.
again, in general, a pinch type injury results in one, much more damage to the remaining tissue, but the remaining tissue is usually very irregular. The borders are jagged.
I think at this point
and
we're
that's
all
not what
rooting
was depicted in the pictures.
for them not to show it. We're all rooting for them not to show the picture.
Dr. Moore also testified that he thought a vodka bottle might not have sufficient force to cause the injury here.
Here we go with the
Is
vodka
that your
bottles.
understanding of his testimony?
Correct.
What's your response to that?
Such an
I
easy,
certainly
natural
believe that
questioning.
a vodka bottle that was thrown from a distance against a hand that was resting on a marble bar is more than sufficient force to result in this fracture and soft tissue loss.
No further questions.
Now, in looking at the medical records and the pictures of Mr. Depp's hand, what was the condition of his nail?
There was no injury to the nail.
Oh, they have to get into this.
And other than what you've already told us, how does that factor into your analysis, if at all? The fact that there was no injury to the nail?
Well, it makes it highly unlikely that the mechanism of injury described by Ms. Heard resulted in this injury, because you really would always see an injury to the nail and or nail bed.
Do you have any opinion regarding the direction of the injury?
Well, it's certainly based upon the soft tissue loss. It's an angled injury, or what we call medically an oblique injury, because the soft tissue loss is at an angle. He lost some of the tissue on the back of the finger as well as the palm side, primarily along the palm side. But other than that, you can't make any assumptions. Unless you saw a videotape of this injury, nobody could tell you definitively what the direction of the injury was.
Dr. Moore also commented on the absence of fragments of broken glass in Mr. Depp's injury. Do you remember that?
Yes, I do.
And how does the absence of glass fragments factor into your analysis?
It really doesn't. I've seen hundreds, if not probably at least 500 or more glass injuries, and I would say probably the majority, you don't see glass in these injuries.
Oh.
It is much more common to see glass embedded in the wounds when you're talking about very fine glass. So if, just say a wine glass would explode or something of that nature where you get little tiny shards. But in general, when you have thick glass, such as you see in a bottle or a pane of glass, you generally don't see, because they break into bigger pieces, and you generally don't see the glass. But you certainly can, but it's not surprising that you don't.
Interesting.
Can you definitively state how this injury occurred?
No, nobody can definitively state.
I have no further questions, Your Honor.
All right, cross-examination.
And that's what the doctor said. If he was
Thank you, Your
doing
Honor.
damage the way
Good
described,
morning, Dr. Gilbert.
Good morning.
he would have had other
Now,
injuries.
You're being paid $1,000 an hour for your work on this case.
How much are you being paid,
Correct.
Rottenborn? Are you here for your
And
15 minutes
you
of fame?
agree, just to sum up how Mr. Moniz finished, you agree that the finger injury could have been caused by any number of things, right?
Yes,
And you're not offering an expert opinion on what you believe caused the finger injury, correct?
correct.
And you're aware, you said a few times Miss Heard's account or Miss Heard's explanation, right? You remember saying that?
Yes,
You're actually aware that Amber has said she doesn't know how
first
he
name.
lost his finger. You're aware of that, right?
yes.
What?
So when you were just talking about Miss Heard's account or Miss Heard's explanation, you're aware she's never actually given an explanation for how she thinks he lost his finger,
Wait, what?
correct?
No,
Wait, what?
You're aware that Miss Heard testified, and this was from your deposition, you're aware that she testified she doesn't know how he got his fingertip chopped off.
Wait, what?
You're aware of that, right?
Asked and answered, Your Honor.
Overruled.
no, I'm not. I reviewed the records, and in one of the testimonies depositions that I reviewed, it was described that that potentially it was lost when he was punching against the wall with a phone.
That's what she said in
And
court.
on that, the last point there, I think we agree. Miss Heard's testified in this trial and previously that she saw him smash a phone to smithereens, a wall phone. You'd agree with that, correct?
Correct.
But she doesn't know if that was what caused him to lose his finger. You agree with that, correct?
I agree. I cannot speak for her, but yes.
Okay.
Congratulations.
May I approach, Your Honor?
Yes, sir.
Do you have to? Congratulations, Phoenix 23, on getting into university. Get it. Rottenborn's not lying. He's allowed to ask questions like this.
Dr. Gilbert.
It's cross-examination.
You gave a deposition in this case on March 17th, correct?
But if all of us went
Correct.
no
You
fucking
were under
way,
oath in that deposition, you swore to
Correct.
tell the truth,
you
correct?
run a risk.
Correct.
Okay, if you could turn to page 61, please.
He's trying to go quick.
It's either four pages per page of paper.
Again, if the way y'all are feeling, there are jurors who might be, that's
page
not what I
16 of the
remember
document.
either. And that strategy can
Okay,
backfire.
line 9, you're asked a question, and then Amber's response to that question,
His
that's the
pacing
line
is just-
9. Can you read that, please? Answer, I do not know. I did not see his finger go off. Question, and Dr. Gilbert, are you aware that Amber did not see Mr. Depp's finger go off? Answer, I mean, I'm aware that, well, I am from reading this. I'm aware of the mechanism that she claimed would cause the finger injury. Question,
told the
but
acting
have
coach
you
it was
read
a bottle.
anything so far that indicates she doesn't know how the finger injury happened? Answer, so far from what I'm reading here, yes.
And
Did I
since
read that
then-
right?
She's testified in
Yes.
court.
And you've heard no testimony in this trial from Ms. Heard that the finger injury was definitively caused by the phone, so that she doesn't know, correct?
Correct.
And you'd agree that the fingernail was uninjured, you said that, right?
Correct.
And the nail bed was uninjured,
Correct.
correct? But the area under the fingernail, in the pulp of the finger, that's where the injury took place, right?
Oh, is that needle Huff?
It was not isolated to the pulp, no.
But it didn't injure the fingernail, that's my question.
Correct,
Okay.
yes.
And under Mr. Depp's alleged theory, Amber threw a vodka bottle at him from 10 feet away or so, right?
Correct.
And you testified you have no way to determine the angle that the bottle was coming from, right?
Correct.
But she threw it on a downward trajectory, correct? She didn't, there's no allegation, you've never read anything that she somehow underhanded it so it came up to his finger, right?
Correct.
And there's no way to tell, as you testified, what exact direction it came from, right?
Correct.
And the glass exploded, but you've already testified there was no glass in the wound, right?
Correct.
You haven't read any record of that in any medical records, correct?
Correct.
You also haven't read anything about there being cuts on the rest of his hand, right?
Correct.
And there was no glass found anywhere on the rest of his hand, correct?
Correct.
No bruising or injury
If
on
he
any other
moved
part
his
of his hand
hand-
other than the tip of his middle finger.
Correct.
If
And
he
somehow,
moved it away, there would
Under
not be
Mr.
any more
Depp's theory,
glass.
that bottle hit the bar and his fingers, but didn't damage the fingernail while it amputated the area under the nail, correct?
Correct.
And your explanation of that is that you believe that his hand must have moved at some point during the force of the injury. Isn't that correct?
No, I said it could have, but I did not say that it did.
No, you believe that it did, don't you?
I said that it likely did, but I was not there, and I don't have videotape of the injury, so I can't determine that definitively.
Okay. Well, let's turn to page 25 of your deposition, please.
Yes,
On
let's.
Page 7.
You go ahead and spend your money, sweetheart.
Sorry, page.
Page 25 and 26.
morning.
So it's page 7 of the document.
Okay.
Sorry if I was unclear on that.
No problem.
Why give Johnny Depp's team 6 hours to cross Amber Heard? Yeah, I think when you're on limited time, you don't bring your client
Okay.
back on the stand because you don't have
Line
time to fix
18,
it.
question, and to be clear, by, quote, sitting in that position, you mean hand down, palmar side down. Answer, that's what he claimed. I mean, according to the history, yes. Question, and would it matter if Mr. Depp's hand was palmar side down? Answer, not really, because it really, and I discussed this, it really just depends upon the angle at which the injury occurred. And as well, you can't determine if his hand had moved at some point during the force of the injury, which I believe it probably did, which I didn't get into in my note here. But, question, and why do you believe that? Have you read anything in any of the materials to suggest that? Answer, no. Just that if it completely hit on the back of the finger, then he would have had a nail bed injury, which he did not. Did I read that right?
People are
Correct.
That
saying
was
your
testimony
ambition
you
broke a
gave
girl's
under
leg.
oath a month or two ago,
When
right?
really
Correct.
it was the angle
So
with which she
even though
hit the
you have
ground.
never read anything that suggests Mr. Depp's hand moved, his hand moving is the only way that you can fit your testimony into what Mr. Depp wants you to testify to about how the injury occurred, isn't it?
No, that's
Compound.
incorrect.
Okay, that's what you testified to, that if his hand hadn't moved, that there would be a nail bed injury, correct?
on.
That is incorrect. That's not what I testified.
In
That's not
fact,
what.
Dr. Gilbert, there's another explanation for how Mr. Depp somehow suffered an injury that didn't injure his nail one bit, but injured underneath the
Rottenborn's
nail.
doing his
And that
job.
explanation is that it didn't happen how Mr. Depp says it did, correct?
No.
I cannot make that assumption, nor can you.
No further questions.
All
Thank you.
right, redirect.
Sit down, Rottenborn. Look, that is a solid cross. I don't think
Dr.
it moved the
Gilbert,
needle.
Just very briefly.
I don't like his style,
The absence of other cuts on Mr. Depp's hand.
but he's doing his job.
How do you factor that into your analysis?
I don't like his style.
You certainly can see an isolated finger injury with any type of injury, and I would say any other host of mechanisms of injuries, you'd more likely see other. So again, if you're, I'm just using this as an example. If you're punching against a wall, you would more likely see multiple injuries to multiple fingers. It really just depends upon how the bottle or how the mechanism of the injury
Happy birthday,
impacted
Jessica.
the hand at
Quickly,
that
I
point
think
in
today will
time.
be quick.
Ms. Heard's counsel made a point of emphasizing that there were no bruises or other injuries on the hand, right?
Correct.
And how does that fact affect your analysis, if at all?
The hair splitting
Well,
is annoying. It's part of
It doesn't
being a lawyer,
discount
though.
anything, but it certainly makes other potential causes of injury more unlikely, meaning punching against a wall or getting the hand slammed in a door or something like that.
I think it's very likely Depp's team doesn't use all 7 hours.
And your discussion of Ms. Heard's explanation of the alternative cause of the injury, was that based on anything other than Ms. Heard's statements?
No.
No further questions, Your Honor.
All right, thank you. Doctor, you can have a seat in the courtroom or you're free to go. Thank you.
There
Oh,
is
you
a
can just
tape
leave it there.
recording
That's
that
fine.
is
Thank you,
not
sir.
in evidence.
All right. Your next witness.
Who's going to say no further witnesses?
Plaintiff Rests, Your Honor.
All right. Plaintiff rests the rebuttal case. All right.
No further
Defendant,
witnesses for Johnny
counterplaintiff,
Depp.
Rebuttal case? Sure.
If they all finish, this judge is going to lose her fucking mind. I'm going to answer questions in just a sec. If they all aren't ready for another witness, Judge A is going to lose her mind because they could have done closing today. Okay, there is a tape recording going around of the aftermath of the finger event. Amber admits to it. Why is this not played in the U.S. court? This is going to go to a ruling from the judge, potentially the stipulation on how audio is coming in. It seems that there are potentials about how that was recorded, but there are third parties on there that can't come into court, including Jerry Judge, who has passed. So there are reasons it's not coming in, but this is the part of watching a case unfold on the internet too, is that y'all have a lot more information than these jurors do, and that can be very, very frustrating. It's like, let it all in. With a jury system, that is not what happened. In other judicial systems where jurors aren't just people off the street who are coming out of their lives, who are not trained, you have different rules of evidence where more stuff comes in because reliability can be determined. I think a recording in the aftermath is highly reliable, but it depends on how it was obtained, and it has been kept out of this trial. I'm sure someone tried to get it in, but it has been kept out, and the judge has not said why. How much time does each side have left? Well, before that exercise in cross-examination, we were at 7 hours for Depp and an hour and 15 minutes for Heard. So they're trying to figure out what they're going to do. I liked the last answer. I cannot make that assumption, nor can you. Yeah, it was the right level of holding the line without being flippant or rude. Rottenborn's style of cross-examination is rude. I do not like it. He can have effective cross-examinations. He asks better questions than anyone else on their team. He gets to the point better. His style is off-putting to me. It doesn't mean he's not good at cross-examination. I just don't like it. And if the jury doesn't like it, that becomes a problem. But I have not seen as much talk about the jury kind of checking out when Rottenborn talks as they do when Elaine talks. She is also off-putting. Emily, something about you just soothes my soul. Texas Nurse Patriot. That's the nicest thing anyone's ever said to me. Thank you for your awesomeness. You're welcome. A high-velocity vodka bottle would cause a hand to move upon impact, whether JD moved it or not. Also, shattering glass flies in all directions. Yeah, and again, if you're moving the hand out of the way, one can assume if you're moving the hand out of the way that the glass, if there was glass, big pieces of glass on the hand, they would also move. They wouldn't stay on your hand. Who is this lawyer? No idea. Didn't introduce himself. The judge has to be super annoyed that they're talking about scheduling right now and wasting court time. My husband broke, fractured, and dislocated his hand when he punched a wall, former alcoholic, and I bet if Johnny did that, he would have as well. My brother had a crush injury playing water polo as a goalie between a water polo ball and the back of a goal. The back of the goal is pretty hard. He had put his hand up in the ball and the goal and crushed some of his knuckles. Crush injuries happen. I mean, from all kinds of things. And glass injuries happen from all kinds of things. But that doctor seemed credible to me, and his explanation made a lot of sense, especially when he talked about clean margins. If you take nothing else away from that, when he was talking about clean margins and it being a sharp-edged injury, that makes sense. We also, going to the finger injury, was the hair moving when it was split? I think it was dancing. It was doing TikTok dances. It was doing about damn time. It was Lizzo dancing. The hair, that's what the hair was doing. Can you please shout out my mom, Maureen? Maureen, hello. We love your commentary and think you're amazing. Thank you. Today's my birthday. Can't wait to watch. Happy birthday, Anne. Hello, Maureen. If it's blurry ever, Go ahead and just
All
refresh
right,
the stream.
rebuttal evidence.
Yes, Your Honor.
Mr. Murphy?
We call Mr. Julian Ackert.
All right. Mr. Ackert?
So they were probably going up to talk about what he's talking about. No idea who this is. We're all going to find out together. Don't we love learning things together?
Do solemnly swear or affirm
Let's all learn
to testify
together.
truthfully in this case for penalty of law?
Why are there no exhibits on the court side after 5/18/2022? I'll go look. So now they're calling their own expert into question. She clearly implied he hurt his finger with the phone.
Good morning.
Yeah, Natalie.
Morning.
Can you please state your name?
Julian.
And she told the acting coach it
Can you please
happened
describe your educational
with
background following high school?
a bottle.
I have a Bachelor of Science in Computer Science from the University of Virginia.
Oh, another tech dude.
What is your profession?
So Natalie, yes.
I am a computer forensics investigator.
Where are you employed?
I work for a company called iDiscovery Solutions, or IDS.
And what is your title?
I'm a managing director at that company.
Are you board
What
certified?
services does IDS perform?
IDS provides consulting, expert testimony, forensic analysis, data analysis, electronic data review and production services, all to the business and legal community.
What, if any, of those services performed by IDS have you performed?
I perform all of those services.
How many years of experience do you have in computer forensics investigation?
Yes.
I've worked in the industry for 20 years.
Can you please describe that experience to the jury?
I have experience creating and implementing data
objections can be
preservation
made.
and collection
Kind
strategies.
of bad form.
Doing data collections in a forensically sound manner, extracting data from collections, as well as analysis and metadata analysis of the evidence that I extract.
I heard
You
metadata.
mentioned collecting data from forensic
Oh, boy.
collections. What material are you forensically imaging?
This would be any type of material that stores digital evidence.
Are
An
you the one
iPhone,
who
an
imaged it?
iPad, a tablet, laptop, a cloud account, your Gmail account, anything that has digital evidence.
Have you published in your areas of expertise?
Yes, I've published on data preservation and collection and analysis strategies.
Then why was your
Have you ever
data
given any
extracted
trainings or
weird?
presentations to other individuals in the e-discovery area?
Yes, I have. I do trainings and presentations to lawyers through continuous learning education.
What, if any, professional certifications do you have?
I have a GIAC GCFE, that's the GIAC Certified Forensic Examiner certification.
And what were the requirements of obtaining that certification?
To obtain that certification, you need a minimum number of hours in the field, as well as you need to pass a test with a certain degree of, a certain percentage of passing.
Do you belong to any professional organizations?
Has the
I do. I'm
metadata
a
in this
member
case been
of a
destroyed?
conference called the Sedona Conference. It's a conference that
I love Sedona.
is a group of legal professionals, judges, and technologists, and we discuss the intersection of law and technology issues in the legal
I
community.
want to do that. Do you meet in Sedona?
Have
I
you
want to do
previously
that.
served as an expert witness?
Yes, I have.
And when did you first
My
serve as
next
an expert
calling
witness?
is dealing with digital.
I believe that would have been around 2009 was the first time I served.
How many
Have you
Emmys do you
previously
have?
been qualified as an expert witness in the field of computer forensics?
Yes, I have. I've been qualified probably a half dozen to a dozen times in both federal and state court, including this court right here.
That's for
And
closing.
has a court ever
Closing?
declined to qualify you as an expert witness?
That's
No,
for
they have
closing.
not.
Your Honor, I offer Julian Ackert as an expert in the field of computer forensics.
They're allowed to bring
No
bottles.
objection, Your
All
Honor.
right, so moved. Could you just spell your last name for me, Mr. Ackert?
Ackert, Ackert.
Oh, I spelled it
Thank you
wrong
so
on
much,
Twitter.
sir.
No edit button.
Mr. Ackert, what is forensic imaging?
You should have
Forensic imaging
asked
is
to
the
spell.
process of capturing the data on a digital
Oh,
device.
don't
in a
have Dennison do
forensically sound
cross.
And how is a forensic copy created?
Using specialized software that's available to forensic investigators, we're able to collect the data from devices.
Did you use
and that
Cellbrite?
software may vary depending on the device.
Or
like
did
a
you use the old
phone
one?
Or a laptop.
What type of information does a forensic image collect?
It's meant to really collect everything on the device. So for example, on a laptop, it's going to collect your documents, your emails, your photographs, your documents like Excel spreadsheets,
Shit you
PDF
think you deleted.
files, any applications that you ran, the history of what you've opened or looked at on the laptop,
100%
as well
sure.
as all
Not
of
sure.
the metadata for these different types of electronically stored information files.
And does any other information accompany that information that's collected?
Typically with a forensic image, you're also going to get log files. Log files are files that help you validate the forensic image
Rebuttal
and verify
and
that it was a
closing
forensically sound data.
Goes to the
collection.
counterclaim.
And how do log files enable you to do that?
Log files list
they have a
information
counterclaim,
within
they're
the
allowed to bring
files.
rebuttal witnesses.
Sometimes they're even embedded within the images themselves, but they provide verification information that allows you to authenticate the image and the data on the image.
What is the purpose of creating a forensic
might
image of devices or
Be
data?
saying that the
In order
EXIF
to
data wasn't
extract
altered.
and analyze data
Or was altered.
forensically for the courts, you need to create a forensic image of the data first and gather the data from the
Why it's
forensic image.
resonating.
And what, if any, specific types of data are collected in
I
that
think so.
image and extraction?
It's going to be any type of data that comes from
Yeah, the mic's
image,
resonating.
whether you're extracting photographs
sucks.
or documents or spreadsheets or anything of that nature.
Do you recall Mr. Neumeister mentioning the term hashing yesterday?
Yeah, they don't have a ton of
I
time.
do.
What is that?
Hashing is essentially a digital fingerprint of a file. It's a evaluation of the binary ones and zeros, or how the file is stored on a hard drive, and it examines the ones and zeros in a manner that gives every file a digital fingerprint, essentially, and identifies the uniqueness of the file.
That's a good explanation.
And what, if any, applicability does hashing have to the visual appearance of data?
Hashing has nothing to do with the visual appearance. For example, if I had a Word document that I printed and then saved, therefore I haven't visually changed the
didn't
Word
imply
document.
it
The
had to
metadata of that
do-
Word document indicating that I printed it would be different, and therefore that Word document would not hash to the version that I used before printing.
Can
That's
you
not
give
what he
any
said about
examples
hashing.
of digital photographs that visually appear the same, not hashing?
I believe Mr. Neumeister included 3 of those in his demonstratives yesterday, 3 side-by-side photographs
He
that
did.
Looked visually the same but did not hash. It made sense that they wouldn't hash. Each of them had different file sizes. And a file size can change for a photograph depending on what you do with the photograph. So for example, maybe you want to take that photograph and email it to somebody, and on your phone, you choose to use a small, medium, or large, or different size of the photograph when you email. When you send that email with that photograph, you've changed the hash value because you've changed the ones and zeros because you've changed the size of the photograph.
And what, if anything, do you recall from Mr. Neumeister's testimony regarding Photos 3?
Mr. Neumeister was concerned about a particular metadata field, EXIF metadata, which there's 2 types of metadata for files. There's the embedded metadata, which is what we're discussing here, the EXIF metadata, and external metadata. And
I
Mr.
wonder if he's
Neumeister
gonna
was
be as
concerned
tightly
with
bound.
embedded metadata within the file that indicated that the software version that the file last ran through was Photos.
What is Photos 3.0?
Photos is actually the software application that's built into the Apple Macintosh
What year
operating
was
system
Photos
for
3.0?
laptops.
It seems like ages
This
ago.
is the application that launches by default when you're on an Apple computer and use Photos.
What are the capabilities of Photos 3.0?
There's multiple capabilities for it. You can, for
So far, I
example,
like
create
this
an
witness.
album with it and put multiple photos within an album. You can organize or sort your photos by date and time taken or place.
Yeah.
You can also use that to edit photos.
You mentioned metadata earlier. What is that?
Metadata is information about a file. For example, with a document, it could be when was the document created or last saved, or who saved it, who was the author of the document. For photographs, metadata includes information that you've
I don't know if it'll
seen
come
on
up.
demonstratives before, including when was
thank
the
you.
image taken, what kind of phone took the image, what software was originally used for that image. Any type of information inside the photograph, the EXIF data that you've heard, is metadata.
Did you form any opinions in response to Mr. Neumeister's testimony regarding Photos 3.0 appearing in a software EXIF metadata field?
Yes, I did.
And what are those?
My opinion is that for each of the photos that he identified, for all but one in his demonstrative, I actually found the equivalent original photo that did not have photos in the EXIF metadata. In other words, those are the photos that he was indicated he would have expected to
Where
see
did you
the
find them?
iOS or the phone software version on those photos.
And where did you find them?
How do you know it is an original version of the photograph?
This is a little bit dependent on the Apple ecosystem. Amber uses Apple devices, and those devices, by definition of how Apple works,
That goes to things that
synchronize
weren't
your
on
information
Windows.
from device to device. So, for example, if you take a photo on your phone, you see that same photo on your tablet or your iPad or your iCloud account,
don't know.
or even your MacBook. And that's all because of user experience. Apple wants you to be able to see and visually have the same experience on all your devices. So
Tell me
the
more about
photo that
Apple.
was originally taken traverses or gets synchronized to other devices by design of Apple, and that synchronization process does not affect the metadata that we're talking about here, which is the embedded metadata.
When you say that a version of iOS software was listed in the software exif metadata field, what does that mean?
That means that the photo was not saved using the Photos application.
And what, if any, data sets did you use to come to that conclusion?
I used all of the data sets that I collected or were collected for Amber, including mobile devices, tablets, laptops, et cetera.
How did you have access to those, and why weren't
Michelle,
they
can you
turned
please pull
over?
up Defendant's Exhibit 1671?
Thanks, Michelle.
Do you recognize this chart, Mr. Ackert?
It is weird that he calls her
I do.
Amber for
What is
me
it?
and not misheard.
Without yet saying the contents, just generally, what is it?
This is a chart I created as part of my report.
Dennison,
Your Honor, permission to publish
Is
Defendant
there
671
expert
is a demonstrative.
lawyer that does
Any
experts.
objection?
No objection, Your Honor.
All right.
Team decision.
It'll be published as a demonstrative.
So,
Mr. Ackert, can you please describe in more detail what the information in this chart is? And Michelle, if you could just stay at the top for a quick second.
that's a really helpful demonstrative, my
A little further
guy.
up.
Michelle's like, what do you want?
Great.
Thank you.
Me.
This chart represents for each of the items in Neumeister's report, which his demonstrative was based on, the page number of the item on his report and the items that I found on Ms. Heard's devices that did not indicate the software metadata field showing photos. Rather, they indicated
Does
that they
look a
were
little
the
like Jimmy
original
Kimmel.
software metadata field of iOS.
But did he
And
eat the
do you see
bacon?
the second column titled Neumeister Report Date Captured?
Yes, I do.
What does the information in that column mean?
This is the date time metadata of the particular photo
It
on
looks like
Neumeister's
Runkle's in
report.
court.
So for example, the first row, 23, the date time captured, or the date captured is December 16th, 2015. The second row, 24, you see that the date time is May 21st, 2016. Third row, May 21st, 2016. Fourth row, May 21st, 2016.
Can you just scroll to the next page?
I
please,
can't read
Michelle?
any of that. So if you're looking at your screen going, I can't read that,
Please continue
seems.
for the items on this page.
The top row of this page, the one that came from Neumeister's report, page 30, shows December 16th, 2016. And then finally, 32 shows March 23rd, 2013.
Do you see, can you scroll back to the top, please, Michelle? Do you see the, all the way to the top, I'm sorry.
So rebuttal
The
and
right-hand
closing
column
to
of this
counterclaim
chart.
only.
Yes, I do.
And where it says
Rebuttal
device ID and
witnesses
file name?
are open.
Yes.
Can you please explain what the information in that column means for each of the items identified from Mr. Neumeister's demonstrative?
So these are the evidence IDs, and evidence ID is the ID value I give to a particular piece of data that I collect.
And if
for
you guys are
example, a
super
phone
chatting
or a laptop.
questions,
And the matching
just put
file
question.
names
Like,
found
grab it
on
and get
that
to it
evidence ID
when we have a
that
break.
indicated the original version of this same photograph that Neumeister identified that did not show photos in the software metadata and rather showed the iOS version in the metadata.
And what do the little A's followed by numbers back up, what does that mean?
Those are evidence IDs. Anything with an A number is the evidence ID of an actual device collected. Anything that starts with a backup and follows by another number is an iTunes backup.
So what if
The
any-
expert tried to
what
say that yesterday and they
items
cut
in
him
this
off.
right-hand column,
So-
based on the coding you have here, are iTunes backups?
Only the ones that start with the word backup. Even the ones that start
Yep.
with an A number are actually an iTunes or an iOS backup in iCloud. So your phone can actually be backed up
I'd
to
be so
iCloud,
pissed if I was Team
and
Depp.
those are coming from an iOS backup in iCloud.
Their expert
Everything
tried to
else
deal
is
with that
coming from an
yesterday.
actual physical device.
Can you just take this down for a second, Michelle?
They
And
tried
pull
to
up
get to it yesterday.
1675, please. Defendant 1675.
So it'll be interesting to see what happens on cross.
And
Somebody's saying
You
that they
recognize
saw
this
Dr.
chart, Mr. Ackert?
Hughes Is
Yes, I
Hughes
do.
in the
Without
court?
yet getting into the contents,
would
can you
be
please describe
interesting.
generally what it is?
This is a chart that I prepared as a summary of my findings.
Permission to publish defendant 1675 is a demonstrative, Your Honor.
Any objection?
No objection.
All right, 1675 will be published as demonstrative.
Can you please describe in more detail what the 3 columns you can see in this chart represent?
Sure,
The
this
jury-
starts
this
to give
demonstrative
some
does not help at
detail
all. It's too
about the
detailed.
Particular evidence ID. So for example, A001 was an iPhone X of Amber's that was collected. A002 was an iPad of Amber's collected.
How did you get it?
A11, 12, and 13, slightly down, are 3 different laptops that were collected for Amber.
And were they given to anyone?
Do you see the IDS evidence number
I have
column?
so many questions.
Yes, I do.
Do you see the source type column
Yes, I do.
and the source details column?
Yes, I do.
Can you please describe what those columns mean?
Generally, the IDS evidence number is the evidence number that we assign to a particular piece of evidence, and the type and details come from a description of that type of evidence based upon the collection set.
And Michelle, can you please do a side-by-side of 1675 and 1671?
So this is Amber Heard's rebuttal witness. She gets rebuttal witnesses because she has a counterclaim. I didn't know the judge was going to allow them. She
So,
did.
Mr. Ackert, can you please
And
describe the relationship between these
The
two?
rebuttal and
demonstrative
closing
exhibits?
will only
Certainly.
go to the
If you look at
counterclaim. These can go to
1671, the
anything.
one on the left, you can see in the 4th column the different evidence IDs
can't
where
see
I
shit, my
identified
guy.
the original versions of those same pictures that Mr. Neumeister had specifically identified and the sources of where they were identified. So if you look at the first one, for example, the picture Neumeister referenced on page 24, or I guess that's the second one, there are equivalent versions or original versions of those that do not show the software EXIF metadata field of photos. Rather, it shows the original iOS version on A001, which was Amber Heard's iPhone X, A002, which is Amber Heard's iPad Pro. Scrolling on down through there, you see it on A0011, which is Amber Heard's laptop, same with A0012 and 13. You can see this again with the next row that's visible at the very top. Neumeister identified a photograph on page 30 taken
I
on
can't.
December 16th, 2015. He was concerned about the
They should have had the same
EXIF
data,
metadata of that, showing
but I have
the
questions.
software version of photos. The original versions of those were found again on A001, that's her iPhone X, A002, her iPad. And it's not surprising to me that I found all these on all the devices because that's how the Apple ecosystem works. It replicates your pictures or synchronizes your pictures across your devices when you take them.
Hi.
Mr.
Was
Ackert, you can
iCloud
take
doing
this one.
autosync in
Do you recall Mr.
2017
Neumeister's
across
testimony
devices?
regarding what he claims of EXIF metadata
I
modification?
feel like that came later, but I
Yes,
could be
do.
wrong.
This is
I'm
a
open to being
completely
wrong.
hypothetical scenario. Mr. Neumeister
Oh,
never
that's
specified
Dr.
any
Hughes right
pictures
there. Oh,
with
fucking
specificity
hell.
That had EXIF metadata modification, and it's a hypothetical in my opinion.
Mr. Ackert, did you form any overall conclusions in this case?
Yes, I did.
And what were those?
The images that were created in this case were included log files that allowed me to validate and verify the evidence collected. I validated and verified the log files of the evidence for which I found Mr. Neumeister's original photos that he had concerns about, specifically the ones that had iOS in the software metadata field. I validated that those came from devices that had log files that were validated by me. In other words, they came from original
How?
evidence files, and in most instances, they came from more than one file.
Mr. Ackert, the opinions you have testified to today made to a reasonable degree of forensic certainty.
I'm more excited
Yes,
about
they are.
Cross.
No further questions, Your Honor.
He didn't ask about anything other than,
Cross-examination,
do
sir?
they have original log files, really? And then
Thank you,
Dr.
Your
Hughes
Honor.
is probably next.
Good morning, sir.
Yikes.
Good morning.
You've worked with opposing counsel's law firm approximately 20 times before,
Give or take, yes.
for more than a dozen years?
Those 20 probably would have been spread out over more than a dozen years.
Okay. As you sit here today, you cannot testify that all of the photographs produced by Ms. Heard are authentic originals, correct?
Now, I can testify to the ones that Mr. Neumeister identified with specificity.
That
Right,
are
but there were thousands of photographs
originals?
provided that Mr. Neumeier didn't testify about, right?
I have no opinions on any photographs that the opposing expert has no opinions on.
My question to you, though, is, as you sit here today,
fair.
can you testify that all the photographs produced by Ms. Heard are authentic originals?
As I sit here today, I cannot opine to photographs that have not been presented to me that are not authentic originals.
All right. You'll
What?
agree with me that in some instances, Ms. Heard produced multiple versions of the same photograph, right?
Yes,
Yeah, you just talked about it, right?
yes,
That was funny. I agree.
And you'll agree with me that the XF data of some of the photos produced by Ms. Heard reflect the use of a photo editing application.
no.
No?
What?
I'll agree that they show the use of the Photos application, which is a sorting and editing application.
Okay, so what you
Also
were
fair.
quibbling with is that it will both sort and edit.
That is correct.
Okay.
Quibbling.
Are you prepared to swear under oath that each and every photograph provided by Ms. Heard and entered into evidence in this court is an authentic original?
Based on the metadata that I have reviewed of the specific photographs I have reviewed, I can confirm that those are authentic original photographs. For the ones that Mr. Neumeister identified, I identified photos that were authentic originals.
No,
So
I'm
he-
asking you a broader question than that.
So he found underlying authentic
There were
originals where?
Multiple.
And are those the ones in
photographs that
court?
Ms. Heard
And how do you know if
provided
those are the
were
ones in court?
entered Into evidence in this court.
Yes.
Are you testifying that those are each authentic originals?
I have no testimony or opinion on those because nobody's provided me opinion that they're not.
Okay. Mr. Gibson, will you pull up Defendant's Exhibit 712?
How, I want to know if he knows
713
that the things that are in
next to one
evidence
another.
are authentic
Your Honor,
originals.
these
And
have
I don't know
already
how
been
he's not
admitted,
going to know
and
that.
I ask that we publish it.
I am so
Okay,
confused.
they're admitted, we can publish.
Yo, there's a lot of negatives happening. It was not
Can you see
not
this, sir?
the not
Yes, I can.
of a not. Because not.
You'll agree with me that those are different pictures?
Visually, they look different to me, yes.
All right. We can take that
Yes.
down.
The coloring, correct, sir? The coloring looks different. And the thing with Dennison is he has all the time in the world. No need to rush. Just keep asking questions because Team Heard doesn't have much time to fix
Mr.
it.
Gibson.
And we've
can
seen
you
Dr. Hughes sitting in
pull
the
up
gallery.
Plaintiff's Exhibit
The clock
1308.
is also a player today, a big player today.
This has not been admitted, Your Honor, and I propose to use it as a demonstrative.
Great.
Any objection?
Not as a demonstrative, Your Honor.
All right. Be identified and published to the jury as a demonstrative.
Oh,
Any objection to entering it into evidence?
I would object it's cumulative, Your Honor. Actually, no, no objection, Your Honor.
No
they
objection,
wanted the
all right, so that
metadata.
makes
All right, 1308 is in evidence.
They want the
Mr. Gibson,
metadata
can
that
you
was
blow
kept
up
out
the
earlier.
Time, date, and file name.
Oh my God, Natalie, he's so boring. Huh. So they're now admitting metadata into these.
Sir, you just agreed with me that those two photos are different photos, correct?
I agreed that they were visually different, yes.
He did agree that they looked
So they are
different.
two visually different photos that were created at the exact same hour, the exact same
Just stick
minute,
to 713 and
the
712.
exact
Just stay
same
here.
second
This is where you live now.
as each other,
You live right
correct?
here. This is where you
And
live.
that's what the daytime metadata shows, yes.
Now we have
The
metadata.
Metadata shows something else too.
Amber
They have
Heard
the
testified
exact
they were
same
different.
file name, don't they, sir?
Yes, but that's not embedded metadata.
Right.
So who would have changed
How
it?
would you have this jury decide which one is real?
I think you would need to look at the software metadata field, which I haven't looked at. I don't recall if I looked at for this particular field, but I think that's what even Mr. Neumeister said, that you need to look at the software metadata field.
But we have two photographs entered into evidence in this court that have the same identifying information, but in your view,
I wonder if this
look
is why they
visually
kept that
different,
metadata
correct?
out till now.
I don't agree that they have the same identifying information. I don't see a software metadata field here.
So what's identifying?
The identifying information includes the hour, minute, and second they were taken, this picture were taken.
I see that.
This makes more sense to the jury. Yeah,
No
Dennison's
further
actually.
questions.
Yes,
And just for the
Dennison.
record, since we already have 712 and 713 in evidence as redacted, now this will be 712 and 713A. So 712A and 71213A are now in evidence, just to keep the record clean, okay?
And the jury might understand that more
Redirect.
because that was easier to
Mr. Ackert, you
understand.
just mentioned embedded metadata. What is that?
Embedded metadata is metadata inside a file. I talked earlier about the date printed of a Word document. That's embedded into the file, and that traverses with the file wherever it goes.
And based on all of the photo metadata you have reviewed, do you have any reason to question the forensic authenticity of any photos Mr. Neumeister testified to for which you were responding to?
Not enough.
Can you repeat that question, please?
Yeah, based on all of the photo metadata you have reviewed, based on the photos Mr. Neumeister testified to, do you have any reason to question the forensic authenticity of
Yeah,
those
it's
photos?
early in today's.
I do not.
Following your cross-examination, Mr. Ackert, have any of your opinions in this matter changed?
They have not.
And is it still your testimony that the opinions you testified to do today are made with a reasonable degree of forensic certainty?
Yes.
No further questions, Your
All
Honor.
right, thank you. Sir, you can have a seat in
Runkle
the
did
courtroom. You're free
this.
to go.
Runkle of the Bailey, who has
All right.
been on the channel,
Did
who's
you
a
wanna
friend who's
approach
in
just for a
court today
moment?
right here. He has a video doing this. They are, Amber Heard testified, they are different photos taken at a different, with different lighting. And so what they're showing is I think this is the point. If this one photo is not different, then, this false as to, oh, they're going to time check. This is the timekeeper in court. I think they're going to a time check. They have a witness in court, but I think they are going to a time check. So we are going to do a quick check here as well of your questions. I think that was one of Dennison's better crosses. How can ethics be considered when past testimony of litigants conflicts with the lawyer's questions? A few instances involve the lawyer not remembering his own client's testimony. Nothing so far outside the bounds. It's a question. So the witness can say that's not right, or that's not true, or that's not what I saw. So I think it's disingenuous in front of the jury, but it is a question. I don't think at this point the zealous advocacy is crossing ethical boundaries. It stylistically is not my favorite. So there's a big difference between the two. Can Depp's team recall their expert back following the photo expert? No. This is it. Once we get done with the witnesses today, we are done. This court might end very early. We might be out by lunch today, people. And if we are, they will finish up the jury instructions in court. It's like, this is not a drill. They will finish up the jury instructions in court and then be back in the morning for closing. Jen started a new job this week, been catching up on court videos, saw you hit 500K. I did. Congratulations. Thank you. I think we are over that now. I'm going to have to go look and see where we're at. I think we are well over that now. I meant to do a check this morning to see we are on the back end almost at 5:39.
All right, your next witness.
Your Honor, we would like to call Dr. Don Hughes.
Please
to his
don't.
All
name
right,
again.
Dr. Hughes.
No, why? No. Do you have your notes, Dr. Hughes? A Post-it, perhaps? Have you realized that this is actually a memory test?
Thank you, doctor. Just a reminder that you're still under oath, okay, ma'am?
What, if any, bruising do you have from your last cross-examination?
And could you please just remind the jury who you are again?
Sure, I'm a clinical and forensic psychologist. I am board certified in forensic psychology. I am the president-elect of the trauma division of the American Psychological Association. And I evaluated Amber Heard over 6 visits for approximately 29 hours.
And why are you here today?
To offer rebuttal testimony to Shannon Curry's testimony of yesterday.
I'm offering a
Now,
rebuttal to Dr.
said you
Curry's
used
rebuttal of my
improper
testimony.
methods. Would you agree with that?
No, I would not.
Why? Please explain.
As I testified to you all several weeks ago, I used a standard forensic procedure that is well established in our field. It is a multi-method, multi-hypothesis-driven procedure where you're looking at a variety of different details and tests and external data to arrive at an opinion, and you're looking at the consistency across that data. There are three sort of sets of tests that we use as forensic psychologists, and I think that's where it seems that Dr. Curry
Is she
seems
looking
confused.
down?
We have forensic assessment instruments. Those are instruments that are very neatly tied to a legal criteria. Those are most notably done in a criminal court for competency. If someone has competency to stand trial, we have very clear measures that can
This is
track
so different.
that
This is
legal
not
criteria.
competency to stand
The
trial.
next level are forensically relevant instruments. And those instruments are not linked to a specific legal criteria, but they do have information that's germane to that finding. And that can be an example of a risk assessment measure and a malingering measure.
I'm surprised they're
the
using
malingering
their time for
measure
this.
that I utilized was the MFAST, and that was the only malingering measure in this case. The third category are clinical assessment instruments, and those are instruments that are validated and well-researched and used in the clinical realm as we understand people's symptomatology and diagnostic and functional capacities. Those are things like the MMPI, the PAI, the CAPS, the TSI, because they are
So much
clinically
psych
relevant
battle.
and they still give us very valuable information to individuals who are involved in a court case.
It doesn't make
And the
sense
reason that we do that
that
and
they
we
bring
use
her
these
back.
clinical measures is because the majority of the people that we see are in a clinical realm.
I
They're
think
not
this is
in
a waste of
courtroom.
time.
So they're well-validated and well-researched methods. What we also do is use a very different types of tests within that category. We use some checklists, some face valid checklists. We use some tests that are those broadband personality inventories. We use structured clinical interviews. And then we look for the consistency across those data points. And when we use different types of tests, it gives us information about the individual, how they go about these tests in these different modalities.
The thing is, we had
Dr.
Dr.
Curry seemed to suggest
Beagle
that
undercut
Amber
Dr.
Heard,
Hughes, and then Dr.
tested
Curry, and now
the
Dr.
most
Hughes is back. It's
extreme
just
category
too
in all
much.
of these different tests. Is that accurate?
That is-
Objection compound.
Overruled.
That is not accurate. They were not on the checklist. I mean, people sometimes do. They go, all the time, this happens to me all the time, frequently. And that is not how she endorsed these tests. She endorsed them in a very moderate way, in a very nuanced way, describing her symptoms that I determined was accurate and reliable.
Now, Dr. Curry
Based
also
on-
suggested that Amber Heard was tested very, very high, 98 percentile, I think, on malingering and feigning. Could you speak to that, please?
Sure. So, I mean, she said a lot of things. So let's go through those tests. The first was the PAI, and that's that other broadband psychological
Objection
measure.
non-responsive.
I think it's very responsive.
Sustained.
Okay. Could you tell the jury about the PAI?
Your
test that Dr.
thoughts,
Curry
Elaine,
suggested?
are not
Yes,
the standard
thank you.
for that
So that's
objection.
the broadband measure that has validity scales built into it that gives us indications
gonna run out of
about
money-
how the
money,
individual
time.
goes about the test. I told you last time that there was no evidence of malingering or exaggeration or feigning on that test. What Dr. Curry was talking about was this tendency to put your best foot forward to minimize faults on this PAI. That scale was right at the cusp. And then there are two other measures that we look at that to say, you know, is this enough for an elevation for me to consider that as a serious response distortion, of which Dr. Curry was saying, and it was not. What was relevant on this test was there were elevations on anxiety, on affective anxiety, meaning anxiety, tension, worry, on traumatic stress, on hyperactivity.
If the jury is
and on
already out,
affective instability.
this is not going to
Those
help.
were the four
If the jury
scales
was
that were
on the
elevated
fence,
on
this
this
might
test.
help a few.
The borderline scale was not elevated on this test. And this test,
Objection, Your Honor.
Specific-
May we approach?
Yes.
Okay. Well, I mean, if I'm Dennison, I would be using the clock to my advantage. I would object. I would break up time. I would just, I would absolutely be breaking up what's going on here. I'm going to answer a few questions as we get into this rebuttal. I don't know if this is going to help. Dr. Hughes, I don't know if she seemed nervous or agitated. There's something, but also Elaine's pacing is off-putting because Elaine's pacing is amping up because she doesn't have a lot of time left, and that's a huge consideration. The camera is back. I wonder if some of these experts want to record themselves. I don't know why. Rebuttal, like siblings arguing for the last word. That might feel that way to the jury too. And after yesterday being very interesting, this might just be like, okay, you did this test. She said this about this test. You're saying this about this test. Don't care. The issue is the lawyer was aggressive, disrespectful, and arrogant to plaintiff's witness.
So Dr.
So
Curry,
he has to
let's
recover
move
from that
to
impression.
the TSI 2.
That's fair.
Dr. Curry
Oh,
testified
and they're moving on.
about your findings on that.
Maybe
Did you
outside the
agree
scope
with
for
her
rebuttal.
testimony yesterday?
No,
Please
again,
describe why. Explain why.
what Dr. Curry went back to.
Rebuttal can only
which
go to
is
the testimony
this
that was from
98th
yesterday.
percentile, which I told you in the manual. All you have to do
you.
is read the manual.
Just read the
It
manual.
says specifically that we do not use the percentile ranks for this test. That indicates to me that, Dr. Curry does not know the psychometric properties of this test, and then she then is therefore not qualified to interpret it.
Thanks, Kara.
That
I
score,
can
the
imagine.
one that's elevated, which she's talking about, that percentile rank, has a raw score. Amber's raw score is a 10. The cutoff score is a 15. She's nowhere near that level of
didn't hear that.
exaggerated symptoms where I can't further look at that test.
I didn't hear that.
Secondly,
Damn it.
there are 3 scales out of maybe there's about 20, a little more on the TSI that were elevated. Intrusive experiences, that's when thoughts and memories of the trauma come into your mind when you don't want them. Defensive avoidance, sort of behavioral ways that we try to push out those memories
Are
and
you
not
having
think about them.
defensive avoidance
And
right
then
now?
relational avoidance, a way of having difficulty in interpersonal relationships. Those are all trauma-based symptoms, and those were elevated on this test.
Thank you. Dr. Hughes, the MFAS, Dr. Curry addressed that as well.
She
and
did?
had criticisms for your interpretations. Do you agree with that?
No.
Please explain to the
So
jury.
the MFAST, as I told you last time, is a measure of malingering. It's the only measure of malingering that was done in this case. Dr. Curry did not independently administer a measure of malingering, and there are other ones that she could have done to augment her evaluation. And
No.
she kept saying something that
That's outside
MFAST
the
is not
scope.
for malingered PTSD. That's wrong on a couple of levels. People who are going to malinger and feign don't only feign one diagnosis. They sometimes talk about all different symptoms that they have, and they exaggerate and they make themselves
This
seem
isn't
much
answering the
worse than
question.
they are. So when you're doing an evaluation, you're giving a malingering measure to get a sense of how this person is responding to this evaluation. Now, what you do is you take those 3 tests that I talked to you about, the PAI, the
Oh, they're not gonna ask
TSI,
about
and the
that.
MFAST,
That's gross.
all with valid validity scales, you have greater confidence in your results. And that
I
is
feel like I'm
in the
being
literature, and
lectured
that's
at by a teacher I
literature
don't like.
that Dr. Curry cited in her report.
They can't bring
That
Dr. Curry back.
bolsters the methodology that I used. That in a study that had the
the
PAI,
high-
the
the pitch
MFAST, and
going
the
up?
TSI in the title of detecting feigned from bona fide PTSD.
Yeah, she's totally yelling at the jury. I would
Thank
feel like
you.
I was being
Now,
lectured
Dr. Curry
at.
also talked about the danger assessment scale and suggested that you had inappropriately interpreted that. Do you agree?
That's also incorrect.
Please describe for the jury.
Which I told you last time, the danger assessment scale has statistically validated risk factors for serious or lethal domestic violence. Those risk factors exist whether we go forward, we're sitting with someone in an acute setting and assessing them right now, or if we look backward and we look retrospectively about what factors may have been present in a case that indicated severity. That instrument is used in what we call, there's called domestic fatality review boards. Those are boards after somebody has been killed, a homicide has occurred in a domestic situation. They look at these risk
Dennison.
factors to see what was there and what could be done.
I feel like
Dr. Curry also.
We've gotten far afield of
criticized
rebuttal.
your, administering of the CAPS 5. Do you agree with her criticisms?
I do not.
Will you please explain to the jury?
So the CAPS 5, as
Will you
you
please
all
stop
have
yelling
heard
at the
multiple
jury?
times, is a
We're
structured
all-
clinical interview.
we all feel like we're being
in
yelled at.
determining PTSD according to DSM-5 criteria. On this measure, Amber Heard scored in a moderate range. She did not over-exaggerate on this test. She could have said no, mild, moderate, severe, and extreme. All of hers were either 2s or 1s or 0s. None above that. So she's scoring in the moderate range, which still has functional impairments. I mean, we don't want someone to be having moderate PTSD, but that's not an exaggerated profile or exaggerated response style of someone who's answering an instrument.
And the last of these Dr. Curry referred to was the PCL-5. Do you agree with her criticisms of your administration and interpretation of that?
No, so the PCL-5 is a checklist of symptoms of PTSD. It is, as she said, it is a face valid instrument. It means it's very clear about how you can endorse this. But what the person has to do is say, how disturbed am I by these symptoms? And when you have face valid measures with these other measures that have the built-in sort of ability scales, you're sort of controlling for that response bias error. You're controlling for that individual to sort of over-exaggerate. But then what you do with that test, because this is, we're not just administering them like robots, is you go and you do a clinical assessment.
The camera is
and
back.
That's what I did. I took what she wrote, what she endorsed on that test in January of 2021, and I did a clinical assessment of those symptoms to see if they meet criteria.
I don't know if this is going to move the needle at all.
That is something we do clinically, and I do in my office all the time. And yes, she did meet PTSD from that in January 2021.
Yes, not everything is a nail.
Now, Dr. Curry said you misinterpreted her test results. Do you agree with that?
Yeah, I agree that I agree that I interpreted them, that she misinterpreted them.
No, I feel like I'm being lectured.
So
I don't like
said
it.
that before.
I find it off-putting.
My stance on the MMPI and how she interpreted it is, I believe, wrong, and I think
Objection, Your Honor.
All right. Instead of
That's
your
the issue we
belief,
just addressed.
I don't.
If you want to approach.
Elaine. Though they did go through this with the expert yesterday when Depp's team kept getting into stuff. Well, they kept trying to ask questions around, but they hadn't had a chance to tell their expert what they were trying to avoid. Besides having a woman's perspective on this trial, I subscribe to you because of your hair. Thank you. Hi from Brazil. Thank you. I love getting to have fun hair. We started the hair at 100,000 subscribers. We're going to get to a few questions. If you are new here, hi to the 164,000 of you.
Now,
do the YouTube
Dr.
things.
Hughes, Dr. Curry also testified
I thought we would
that
have
a
a
victim
longer
of
break.
PTSD has to effectively be prone and unable to function at all. Would you agree with that?
That's not what she said.
Objection misstates the evidence.
Thank you,
She
Dennis.
said they couldn't hike, they couldn't
No.
move, they couldn't
No.
function in any shape,
No,
way,
this
shape,
is
or form. Thank you.
improper,
No,
Elaine.
that is not correct. That is often actually a myth and misconception about individuals who were struggling with PTSD or trauma-based disorders. And I'm often called to answer that and speak to that.
Not what she said.
People who are struggling with trauma and PTSD are very strong, courageous, resilient people, even though that they're struggling. They get up, they have to go to work and drop their kid off at school and go to the market, even though they're struggling with these symptoms. So I often talk about it as this sort of walking around with a 50-pound bag of flour on their backs, just sort of trying to get through the day, where sometimes that button's going to press play and the trauma's going to start activating in their head, and then they're going to be having to think about it and have startle and have physiological reactions until they can find a way to hit that pause and shut it off again. So they still have, impairments in other ways, but they go about their lives. They're not, totally debilitated. If you have someone in that high range, the highest score is an 80 on the CAPS, Ms. Hurd had a 28. If you have someone in the higher range, we have seen people who are, severely disabled because of it, but that's not the norm of people who have this moderate PTSD.
And did you find functional impairment with Amber?
Yes, I did.
Now, Dr. Curry also said
Did she testify to that the first
it's
time?
not within the scope of a psychologist to evaluate domestic violence. Do you agree with that?
That's not what she said.
Of course, I don't agree with that. This is what I do for a living, day in, day out,
That
for
is not
25
what she
years.
said.
We are specifically trained to understand the profound impact that trauma has on people's lives. That's what we do in the
She
trauma
said it's
division of
not
the
yours
American
to determine
Psychological
the
Association. We disseminate that
facts.
knowledge. And domestic violence is one of those profound traumas. Domestic violence is part of state licensing boards that you can't get licensed in some states unless you take training on domestic violence. You can't renew your license unless you get training on domestic
that's
violence.
not-
So people who have, specialized training in this area, it is, beholden upon them to accurately assess for intimate partner violence and sexual violence. And it's more important to assess for this sort of scientific understanding of what domestic violence is. So you have to assess for the physical violence, the psychological violence, the surveillance, the economic, the emotional abuse, and the sexual violence. That is not gratuitous. That is
Objection.
understanding.
Narrative.
Outside this, it is narrative.
All right, next question.
Thank you. There's the objection, but
Now, Dr.
This is
Curry
the battle of the
suggested
expert.
that
Curry said this, you
made
said
a
this, who's
determination
right?
just based on personal opinion and just
She
on
did.
checklists and a couple of tests that you misinterpreted. Would you agree with that?
I vehemently disagree with that. As I
Right.
stated to you, over 29 hours and
Answered.
12 psychological tests. and
Objection outside
reviewing
the scope.
A slew of documents in this case, and most importantly, therapy records and interviews, collateral interviews with therapists. Using all that data, that is what a solid forensic methodological exam looks like. And then I made my conclusions based on my clinical education, knowledge, and training to come up with a professional expert opinion.
Okay. And just to remind, to make sure we're reminded here, you were qualified in this court, in this case.
Objection
as an
outside the scope
expert, in forensic
of rebuttal.
psychology, in specifically in domestic violence and in
I don't know why he's not objecting.
no, I just lost it. And in violence, correct? Intimate, and in trauma, correct?
But I believe
Objection, Your Honor.
Objection,
Misstates the
misstates.
record.
If you want to ask the question again.
Interpersonal.
Yeah, I
She's like,
probably should
I
do that.
can't, Your Honor.
You were qualified. I gotta find my note.
Is
You
it
were
on a
qualified as
Post-it?
an expert in forensic psychology with a specialty in domestic violence and in trauma, correct?
Correct.
Okay, and that was in this case.
That's correct.
Okay. Now,
Okay.
do you still hold the same opinions you did that you gave the jury earlier?
Yes, I do.
And do
outside
you
the
still
scope of-
hold them within a reasonable degree of psychological probability and certainty?
Yes, I do.
Thank you.
All right,
Stop there, Elaine.
cross-examination.
Yes, Your Honor, but can we approach quickly?
Sure.
Are they approaching to see what they can get into? All right, we're going to get into a few questions. While we're waiting for that, I'm going to remind you to do the YouTube things. Am I missing something, or does this do nothing to prove that the images and evidence were not edited? It doesn't. Just that he had access to the originals prior. It does. It does. And I don't know if it moved the needle at all. It just made me question, well, he said he had access to the devices and others said they didn't, which is strange. Could we see closing today if we finish really early? No. They still have like legal things to do, the jury instructions and finishing up things like that. So the lawyers will still have work to do. So if they finish witnesses, I imagine that they will just be done for the day early. And that happens. I mean, that happens on the last day of trial. So if Amber Heard, if AH testifies, those were two different pictures and the data shows otherwise, is that fact material enough for perjury to enter the chat? We're not there yet, but it's enough for the jury to discredit her testimony. So perjury that gets to the point where it will be prosecuted is what I'm looking at. Not could there be a lie under oath? Saying that those are two different photos may be a lie under oath. Is it to the level where perjury would then get investigated and prosecuted?
Dr. Hughes.
I'm not there
Good
yet.
morning, Mr. Dennison.
The last time you were here.
Yeah, it's just-
I believed that
she's
you
tough.
testified.
Dr.
that you
Hughes is
had
rough for me.
diagnosed Ms. Heard with PTSD before you gave the gold standard CAPS 5
She
test.
did do that.
That's correct.
Right.
Why?
And that diagnosis is actually reflected in the first of the disclosures you put forward in this case.
I believe the first disclosure was February 2021, and at that point, I had done 11 psychological tests. That's correct.
Right. And your disclosure reads, Ms. Heard's responses on the PCL-5 support a DSM-5 diagnosis.
Oh, I'll answer that when I have a chance to chat. But hi, name
Traumatic stress disorder with an etiology of intimate partner violence she experienced by a former partner.
Emily's in the chat.
Remember writing that?
That's correct.
Okay. You just testified that you need to read the manual, right?
Yes?
Okay.
That's my takeaway from today.
Can we
You
put
need to
up
read the manual.
1311 as a demonstrative?
Is it the manual? Please, God, let it be the manual. At least that would be interesting. Please, oh, please, oh, please. Tell me the manual is coming. All right, I'm going to go look to Emily Baker's question. Hello, Emily Baker. When the lawyers asked to approach...
I don't know what it is, Your Honor.
All right, if you want to
Maybe we
leave.
approach-
The manual. You just approached. Isn't this what you addressed when you approached? Can the judge deny? Yes. If so, why would they? Because there would be no point. So if the judge has made a ruling and it's like, but Your Honor, can we approach? No, I've made my ruling. This judge has not denied it. This judge probably wouldn't start doing that because it doesn't seem to be her practice. She has been incredibly patient. She's let the lawyers be heard. She has, not wanted them to do speaking objections over one another. I bet that's the manual. She's not wanted them to do speaking objections in front of the jury, etc. So this judge probably wouldn't, but others would just be like, no, I've ruled. Move on, counsel. Move on, counsel. Next question. Amber's team have to know better than to put Amber back on the stand. I would think the only way they would, they only
They're getting the right one up.
They only would push it. I think
let's
you're asking,
use
Justin, the only way
13,
they would do that is if Amber really wanted to.
12.
I don't think they have the time to protect her as
And
their
that-
client if they put her up. I don't.
Any objection to that demonstrative?
No, Your Honor.
Okay, 1312 can be published to the jury.
Yeah,
Dr. Hughes.
Dr. Hughes sounds mad, but that's fair. I
Do
mean,
you recognize
her
what the
opinion got
National
ripped
Center
on
for
yesterday.
PTSD is?
What it is?
Yeah.
Yes, I do.
And they publish the PTSD checklist for DSM-5,
That's correct.
that what we've been calling the PCL-5.
Correct.
All right.
We're getting into the manual.
Are you familiar with the document that's on your screen?
Yes.
All right. What is it?
It reminds me of
It's
Wally.
the
Manuel.
instruction manual to how to administer the PCL-5.
Okay. I'd like to move for the admission of 1312.
Any objection to 1312 coming into evidence?
Oh, the
All right,
jury
1312
gives.
in evidence.
The jury's going to give zero
Can we go to the
fucks.
second page?
Can we just ask the questions?
Can we blow up the second paragraph on the right?
Judge A has been incredible. Judge A is the type of judge you hope to appear in front of on a trial this long.
The PCL-5 should not be used as a standalone diagnostic tool.
She's gonna say she didn't use it as a standalone.
Diagnosis, the clinician will still need to use clinical interviewing skills and a recommended structured interview, e.g. the CAPS-5, to determine a diagnosis, correct? That's what the manual says.
Always possible.
Right, and this manual
Okay.
also says that this is a screening
that-
instrument, so when you do the clinical interviewing, you absolutely
Dennison.
can determine diagnosis
So the
after
answer is
somebody.
yes.
Don't just
The
let her
manual says
wander.
Still
that
need
the
to use
PCL-5
clinical interviewing skills, which I used.
Well, let me finish my question. The PCL-5 should not be used as a standalone diagnostic tool, and they recommend using the CAPS-5
Dennison didn't
to
come in
determine the
hot,
diagnosis,
so if she
correct?
starts getting hot with him, it's going to
It
get.
does say that, yes.
Yes, and you made your diagnosis before you did the CAPS-5.
I made my diagnosis doing clinical
Dennison
interviewing
needs
and
to hold
11 other
her
psychological
to
tests
the yes,
that
no
supported
answers
diagnosis
and
of
make them
PTSD and
fix
symptomatology
it
consistent
and
with
redirect.
PTSD.
He needs to make them fix it and redirect. He needs
You
to
said
hold
that
her
we should
tighter
read the manual. Would you
because they
also
don't have
agree with
time.
me that we need to read the directions on these tests?
Sure.
Okay.
Always,
Tom, can you
always
pull
no
up
name calling.
1309 as a demonstrative.
Oh, some of this stuff is round and round and round. So yes, I will give commentary over it because some of this stuff is round and round and round and round. This is the last day of witness testimony. Tomorrow is closing. So
Yes, sir. Thank you.
did you hear that? Yes, sir. You may approach. So it looks like they're bringing up another
Any
demonstrative.
objection of 1309 as a demonstrative?
May we approach?
Okay.
Great. Yes, we can talk about what Dr. Hughes is saying, but we're not going to name call and besmirch, just like we do with anyone in the chat. It gets harder when we don't like people. Trust me, it is hard when we talk about James Spears, but we still manage. That's what we do. All right, let's see. Lilani said if it is the same photo through all of the devices, then wouldn't it still be the same file size?
9 and publish the jury as demonstrative.
One would think. But he was giving the
Doctor,
example of
do you
emailing, but that's not what came up.
Recognize the demonstrative that's in front of you?
Yes, but I didn't put the red lines on that.
No, I did.
That's
Yes, I
fair.
know.
Okay.
That's fair for her to say that's not mine.
So this, what do you recognize this as?
Use
I
your error.
recognize that we previously discussed this, and I told you that I oriented Ms.
That's
Heard to a
not
different time frame because she was already out of the relationship.
Non-responsive.
Okay,
Oriented to a
maybe we
different
should back
time
it
frame.
up a little.
Non-responsive.
This is the CTS-2 that you administered as part of this battery of tests that you indicate you did in relationship to your diagnosis.
Right, this is the conflict tactic scale too.
All right. And you'll agree with me that this test specifically asks, in front of every single question,
Oh yeah, he's going
how
to walk right
often
into being
did this
combative.
happened in the past year?
Correct, and I
Right,
oriented
and
the
you know-
individual to not limit herself to the
Correct.
last year to get an accurate assessment of the violence and abuse that
Dennison,
she
cut her
experienced in a
off.
relationship.
Objection, Your Honor, move to strike.
Yep.
All right.
Cut
We'll
her
strike the
off.
last part of the answer. Strike the last part of the answer. Thank you.
Cut her off,
Next
Dennison.
question.
Yeah, and you know that at the time that you gave this test to Ms. Heard, she had been away from Mr. Depp for far longer than a year, correct?
Which is why I oriented her to a different
Yes or no,
time
ma'am?
frame in answering the questions.
Doctor, yes or no?
So, of course,
Okay, you knew she was gone for more than a year.
of course.
All right, let's look at another one of these.
That is powerful testimony, but I think it's going to be lost in the circling.
We talked about.
That scale is not meant to be used to
You talked
orient
about
to
the
a different
danger
time.
assessment test.
That's
It's
correct.
within the last year. He needs to rein this witness in and make them fix it all on redirect. They don't have time, Dennison. You've got 7 hours. Do not. This is the witness that the jury is not going to love. So you are
Plaintiffs
able
1310.
to hold her feet to the fire.
Thank you.
Just do it.
Any objection to 1310 as a demonstrative? Okay.
Reminding the jury that
You published the
this
jury.
test was oriented to a different time is weird.
Dr. Hughes,
Blurry AF.
this is a blank form, but this is the danger assessment test that you also gave to Ms. Heard,
Let's
correct?
just walk through it.
I didn't give it to her. I filled it out based on the data that was provided to me.
Oh, so you asked her the questions and then you filled it in.
It was somewhat collaborative.
Okay.
What do you mean collaborative?
Blow up.
What do you
the
mean-
second
whoa, whoa,
full
whoa, whoa.
paragraph.
What do you mean by collaborative? Y'all did it together?
Says, using the calendar, please mark the approximate dates during the past year when you were abused by your partner or
She gave these in
ex-partner.
like 2019.
You didn't use any calendar, did you?
I did not use a calendar because she was already out of the relationship. As I said, these are static risk factors, so they don't change. So I
But these
orient her to the
exams-
time of the relationship.
Ma'am, it's fair to say that this examination that you gave specifically indicates that that you were supposed to look over the past year. And
That's
not the
one,
language?
no, that's one administration. People use this instrument for if you're in an acute situation in a relationship, trying to get a better assessment of the current behaviors. We can use it retrospectively, like I just stated, and in homicides and looking back about what are the serious risk factors that were in this relationship.
I didn't ask you about anything other than, don't the instructions limit this test to the previous year?
You can give this test not only on the
Nope,
previous
asking
year,
you about the instructions.
but I'm telling you how the test is administered in clinical practice and in forensic practice.
And opposing counsel can come up and ask questions about it. I'm asking you about the instructions. And the instructions say, look over the past year.
Yeah, on this, yes, that it says that.
And you had actual knowledge when you gave the test
Little visitors.
that Mr. Depp was gone
it's
way
the
more
first
than a
day of
year
summer.
before this test.
That is correct.
Right. All right, let's look at more instructions. Can we look at 1247, which is already in evidence?
This is going back to Dr. Curry saying she didn't follow the instructions. She did not understand the assignment. And he is pointing out, this was the assignment. What did you do? This was the assignment. What did you do? She filled it out for
Hughes,
Amber. And that's
you recognize this
what
one too,
Dr.
right?
Curry
Yes.
said.
All right, this is the, what everybody calls the CAPS 5.
Correct.
All right, can we go to the first page?
I want to hear him say that's not my question. My question's
Let's
more
blow up the
specific.
instruction.
Answer my question. Yeah, he lets the witnesses go a bit.
Standard administration and scoring of the CAPS 5 are essential for producing reliable and valid scores and diagnostic decisions. Correct?
Correct.
And you know you have to do this in a standardized way because it is the first instruction, correct?
Correct.
Well, I'll get to that at the break.
Can we go to the next page? One more.
These
Oh, wait.
documents are all blurry for me as
That's
well.
good. This is a page on scoring, and we talked about this last time.
Yes.
You score these tests by frequency and intensity.
Correct.
Dennison does the experts. I don't
And
know
you'll
why.
remember that in every single instance that you were asked to fill in the blank about frequency,
Yeah, my little guy
you
came
failed
in.
to do so, correct?
That's not correct.
Oh,
Oh, it's not?
you filled in any blank on this form with respect to frequency?
I filled in the frequency on the side of the caps where I am actually scoring the caps.
No, I
Where
asked
it's
you whether
relevant.
you filled in a single blank on this form with respect to frequency. Is the answer to that yes or no?
I don't know what you mean, a single blank.
All right, let's page down.
Let's look at it.
Let's keep going. All right, we'll stay at this page for a second. This is the very first box you're asked to fill in as to, I think, a fairly fundamental question, right? What happened?
We talked about this before, Mr. Dennison. I had 88 pages of notes of what happened. It would have been
That wasn't the
redundant to
question.
put it there.
You know that you are obligated to produce this test in a way that other people can meaningfully review them. Yes?
The people in this case who are meaningfully reviewing them have my 88 pages of notes.
Right, but you
This
chose to put absolutely nothing in the box, a standardized box that said what happened.
You don't have to put it in the box if you have it somewhere else. It's not
Because
a,
this
if
is
it's
not
not
a
a,
standardized test?
well, if it's not a research instrument that is used for
What?
research, if you're using it for a clinical diagnostic purpose, no, you don't.
So I can use it
If you
however I
have
wanna
that
use it.
data elsewhere.
Okay, let's go another.
So I
page.
can use it the way I want to use it. That's not what Dr.
All right.
Curry said.
Let's do another one.
The text on these screens have been blurry. Yep, absolutely.
All right, let's look at item 4B4.
Yeah, the collaborative is a lot for me.
And I asked you whether you filled in the blank
No.
about
One
frequency.
attorney, one witness.
And there's a blank in many of these items that asks number of times. You didn't fill a single one of them in, did you?
Right, because I filled them on the right side of the instrument where I am scoring it.
And that is the way that you believe that you followed the instructions of a standardized test.
Yes, correct.
No further
Yep.
questions.
She
All
wrote,
right, redirect.
she failed to follow the instructions of a standardized test. I wonder who, yeah, it's interesting that that's back.
What did you mean by that?
Your mic, Elaine.
Static risk factors are risk factors that don't change. It's maybe if you smoke cigarettes, you may have a risk of lung cancer, right? That's a factor that doesn't change. You can look forward if someone's smoking, you can look past if someone's smoking. So these lethality risk factors are present whether you're evaluating them in the last year or 5 years ago.
And when you're trying to assess for trauma related to the interpersonal violence that we discussed, why is it important to get a time frame in which the relationship was in existence?
Well, you want to see the amount of trauma that the person experienced. The longer that they're in a relationship, you have more successive trauma. And one of the things that we know from the research is more trauma is not better. So the more successive traumas that you
I think we
have,
can all
the
agree
greater
that more
likelihood
trauma
that
is not
somebody's
better.
going to have psychological consequences and
We've all found a point
symptomatology
of
as a
agreement.
result.
And therefore, you need to get it within the relationship.
Objection leading.
Yep.
And so how does that relate to needing
What,
to
if
get the
anything, does that
timeframe
relate
in
to?
the relationship?
Well, you need to understand when you're trying to evaluate the impact of something, you want to have to understand what happened to the person. And that's sort of the core and the basis of trauma-informed care and of trauma diagnoses. You
Dr.
have to
Curry said you needed,
understand,
like, multiple tests,
the
though.
traumatic event and how it transpired and how it played out for that individual so that you can better assess for the symptomatology that's falling from it.
You said you had 88 pages of notes. What were in your 88? And without going into the specifics, can you just describe what was included in the 88 pages of notes?
In the 88 pages were many of the documented incidents of intimate partner
Objection, Your
violence.
Honor.
She's just describing it. That came up. He said you didn't fill those in the boxes. She said it was in my 88 pages. I'm just saying what was in your 88 pages.
Oh, my God.
I'm not asking her to give each of the specific events. She can describe the summary of it.
Elaine, Judge A.
Can we come up?
Okay.
Oh, Judge A. That this judge doesn't generally do speaking objections. That is a speaking objection where Elaine's like, but this and this and this and this and this, Your Honor. And he's like, no. But it's appropriate to say what we're not going to do is reiterate this. Let's get, stop testifying, Elaine. Exactly. It's just, the judge probably told her to move on.
What is the difference between
And she did.
clinical
Move on.
scoring and clinical evaluation and research evaluation with respect to the CAPS-5 and the other tests?
Objection compound.
Sustained.
Well, now Dennison is showing some control.
Your Honor, when it's compounded, it's because it might be confusing to the jury.
No, Elaine.
Next question.
Okay. Can you explain to the jury what the difference is between clinical scoring and evaluation on a test and research?
Objection, Your Honor, compound.
Overruled, go.
No. It's
Sure, so
between.
the PCL and the CAPS-5 are frequently used in research. And when they're used in research, that means the document stands alone. They don't have 88 pages of notes to help understand the background of the trauma and what the person has
180
experienced.
now.
And why those boxes may be relevant in research is because, back in the day when I was a research assistant, I had to input that into the computer. And then they would maybe look at some of that data for the research study. So that becomes very important in research.
All right. Thank you. I have no further questions.
No, Elaine did not mansplain
You can
the
stay in the
judge.
courtroom or you're free to go, okay?
Elaine
All right, ladies and gentlemen, let's go
splains.
ahead and take our afternoon recess.
What?
I mean, sorry, our morning
What?
recess.
What?
I'll just
She
take a
Elaine
15-minute
splains.
recess. Do not discuss the
Ooh,
case with
something's
anybody
happening.
and don't do any outside research, okay?
What's happening? All right, I hope they'll put it on the record. Huh. I'm curious. I think we might have a scheduling issue. Let's see what the judge has to say. Actually, I'm going to go bigger to the court, and then we'll do. If they run out of time before they are
All
finished,
right, why don't we just come back at 11:05 then? All right, excellent.
normal break. If they run out of time before they are finished, the judge has said she will cut them off in the middle of a sentence. That's what she said. It's Elaine tries to reset. I don't mind the reset. Sometimes it's very hard to do it in real time. I glitch resetting sometimes in real time. It's hard. But the arguing back to the judge is what very much puts me off. It's like, but Your Honor, it's only compound if it's this. The judge already said sustained, Elaine. And if the judge said sustained, then it's sustained. And the pinnacle of the Elaine splaining for me is when she does shit like, but Your Honor, I don't think it's compound, or I don't think it's hearsay. It's like, your opinion doesn't matter. The judge ruled. Give a legal grounds or move on. So with that, we're just going to do a quick check-in because y'all, we're almost at 540 on that road to 550. Thank you so much to the 180,000 of you in here. If you would like to go ahead and do the subscribing things, I would appreciate it. Heather Boo says, I hate seeing the lawyers fight with the judge. I do too. Judge A has been very, very patient with the Elaine splaining, but I think she could shut it down a lot more. Let's get to some more of your questions. We've got about 15 minutes for a break, so I'm gonna try to like zoom. We're gonna do a real speed run through it. My little one who came in a little bit earlier was talking about the drama with Dreams speedrun. He's just discovered that portion of YouTube is whether there was a speed run or not. It's very fun listening to him try to explain it to me. Is court still dark Friday? No. Closing arguments are Friday. Closing arguments are tomorrow. Peyton said, I have PTSD from medical abuse. I'm sorry to hear that, Peyton. I cry whenever I think about it. I couldn't sit through a trial. And I think that's part of what Dr. Curry was getting to. Dr. Curry was talking about the kind of the most severe PTSD, but was also talking about where Heard scored on those scales, saying, or at least that was my understanding. I will go back and watch the testimony. So thank you guys. We're going to pass that in just a second. If she doesn't write it on the form and she has such a heavy reliance on notes, how do we know she didn't miss things in her notes? I think that's why the forms have rules. Like, not a doctor, but I think that's why the forms have rules and like procedures. So they're like standardized in some way. Like, so if you're not using it as a diagnostic, why are you using it as the basis of your diagnosis? Sister Babylon. Exactly. Why? I wish you would have asked that. You should have fed a Post-it to Dennison to say that. I asked yesterday about the judge intervening when questions are not appropriate. Why does the judge ask if there were any objections? Isn't that the attorney's responsibility? Will Bender, this is a fantastic question. The judge asks if there are any objections to the exhibits. That's the proper procedure. I'm offering this exhibit. I want to mark it as this for evidence. So I've got an exhibit. Do I need demonstratives? Yes, I have an exhibit. Your Honor, I'd like to mark this exhibit 1. And then it would be any objections. Objections? No. Can it be admitted into evidence? And then you can admit it into evidence without any objections. And then you can publish it to the jury. So in the context of admitting evidence, that is why the judge asks any objections. In the context of questioning a witness, it is the lawyer's job to say objection or to stand, depending on the jurisdiction. That would have made me bananas if I had to stand up I would be so distracted if I had to stand up every time I had to object. We didn't do standing objections, but if you have to stand, hit the button and object, it can be a lot going on. We've seen Elaine miss the button quite a lot, but that is why. It's when you're admitting evidence only. That's the proper time to object. You wait for the judge to ask for it. Oh my, is that Daria? I love Daria. Cyan. I hope I pronounced that correct. Just wanted to say thank you for your fair and educated analysis on the case. I try to be fair. Your humor and vibes are immaculate. Thank you. I try to be fair. And I will try to tell you if I just don't like someone. Like with Dr. Hughes, she put me off in her original testimony. It makes it harder to say what are the good points and what are the not good points. She did a pretty good job on her direct, but again, it's hard to listen to because she's like, as I told you, as I said, and that is very off-putting. Rachel said, I'm a little behind, but am pissed that Dr. Hughes called Dr. Curry Shannon Curry without the doctor when she said she was here for rebuttal. It was disrespectful. I don't know if the jury will pick up on the disrespect, but we sure did. So thank you guys. Are judges and attorneys ever friends outside of court? Yes. I wonder if Elaine feels like she can argue with Judge A. I lost it. Where did it go? Oh, I wonder if Elaine feels like she can argue with Judge A because they are friends. No. If they are close friends, I would imagine that it might be an issue having them on the same case. It could potentially be a conflict. But yes, judges and attorneys are friends because essentially judges are attorneys that have taken a different career path and taken the bench or have been appointed to the bench or elected. But you appearing before someone that you have a close personal relationship might be a conflict, though it can be waived. But you just wouldn't do that. I think because the judge has let it go, Elaine has let it go. And I think the judge has the interest of getting this trial done and not nitpicking Elaine on every little thing. But also, I wonder if this judge is patient kind of as a rule. Question from Bellaboo. Rob Morton commented on the jury demographics yesterday, age range, sex, ethnicity, and discussed their body language during Amber Heard's testimony. Is this okay? He was in the court, so it's proper to say, this is what I've noticed. This is what other media outlets are reporting. Court is kind of a sacred space. So doing things that can impact the jury or visible to the jury, like I had somebody come into shirt into court in a like snitches shirt. And that was yeeted immediately because it was like, are you trying to intimidate a witness? Are you trying to intimidate a jury? Whatever. But so displays in court can be a problem because they're in the view of the jury, but analyzing the jury and what we're seeing from the jury, it doesn't go outside of any bounds because that is how you analyze a jury. You look at these demographics and that is part of jury analysis. So no, I don't have a problem with that. Also, Rob from Law and Lumber practices in this jurisdiction. So if anyone is going to be vigilant or even hyper vigilant about what they share on the internet, knowing that this case has so much attention, it will be someone who practices in that jurisdiction who very, very reasonably can end up in Judge A's courtroom on other matters. When I was a DA, walking into Judge Ito's courtroom was always a surreal experience. I was like, I saw this on TV. Hello from Alabama. I wanted to say thank you for your coverage. I witnessed my mom physically abuse my dad growing up. I'm sorry. I see my dad when I look at JD. I hope JD knows how much it means for so many people. I wonder if he does, Emma B. I'm sorry for that. But we will see. I don't know if his lawyers are protecting him from the internet or if they will tell him at the end of this, but I'm sure he sees all the people. I mean, you can't miss the people outside of court. If Hughes wrote notes on another paper, why didn't she, one, put it on the form? Especially if the small numbers, and two, why aren't the notes submitted as well to the court? So none of the tests are submitted as evidence. It's the testimony that's evidence. None of the tests are submitted as evidence. It's the we binged. Thank you. It's the testimony that's evidence. The other side would have had it. What they are pointing out is how is this valid if you're not following the testing? And Dr. Curry talked a lot about the testing procedure being very, very specific. So do you think Dr. Curry will come back and rebut again and get the final word? No. At some point it's done. It's like you've got Dr. Hughes rebutting Dr. Curry, rebutting Dr. Hughes, so no. You're not going to see that. Dr. Hughes' testimony today could have been narrowed even further if Dennison was objecting. He wasn't, but it could have been narrowed even further because it could only go to what Dr. Curry said about Dr. Hughes. It's like expert inception at this point. Where did you get the chair behind you? It looks like a great nap chair. It is a great nap and reading chair. It has been generally stolen by the paw nerds, and I had a link to it. I got this one on Amazon. I had a link to it on Amazon. So that is where I got it. It should be in my Amazon shop if it's still available on Amazon. I started my tattoo apprenticeship this week, and my first day, the piercer said, do you mind if I listen to the Johnny Depp trial? The entire shop is just as obsessed as me. Kelly, that's amazing. Obviously, you're at a great shop. There is nothing I love more than a good tattoo shop, but that is just me. I am a local to the area. People are literally bringing their babies into the courtroom. One such woman held up her baby and claimed it to be Johnny's. I'm shocked that the court has remained open. Mom, what I saw was that she said, what would you, not this baby is yours, but like, what would you do if this was your baby? That's the reporting I saw about the woman in court with the baby. But yeah, and that's we're seeing the weird part of celebrity kind of play out in real life. And that's got to be hard for Johnny Depp too. Just to remember, if you guys put, the description is empty. That's my fault. I'll fill it up. I'll go put it in there as court resumes. Apologies. Do you think the jury is staying engaged throughout this trial like we are? No. If I was in the juror's seat, a lot of information would be lost. Yes. It's why they take notes. It's why there's multiples of them. But it's why they take notes. Just saw a tweet that said, so students don't need to actually take standardized testing. Just turn in your notes from the year with a blank test. It's all good. Yes. See, I notes. This case is so close to my own life because I was accused on social media by a woman and lost my 14-year military career, but represented myself in federal court 3 times and won all 3 for defamation. Oscar, I'm sure you are riveted by this case. I am sorry for that experience. This is why defamation cases exist, because it can be reputationally damaging, and that has real world impacts. Question, how much weight does the closing argument have on the jury's decision based on my past trials? Some juries found it very helpful, some didn't. So it really just depends on the jury and it depends on the closing. The thing I liked using closing for was trying to show the jury instructions, how to use the jury instructions, and help the jury understand how to do what they have to do. They're like, okay, go in a room and decide. And it's like, how do we do that? So trying to give them a way to do it, and then trying to not just give them a way to do it, but also give them what facts support it. So we should see a thorough, hopefully we should see a thorough walkthrough. So let us, can a criminal trial have a time limit? I've never seen that, Kid Carson. I think it would be very, very difficult, particularly when it comes to the defense, to limit their time, as it's their constitutional right. I've seen courts ask for time estimates and then get very feisty if they're going over the time estimate and it's cumulative. But I've not seen in a criminal trial a judge shut it down. I think you would have very large constitutional issues. I don't think you could shut down a defense attorney in a criminal trial without creating a huge issue for appeal and a mistrial, because so much is on the line. I also don't think you could limit the prosecutor and not limit the defense. So if there is a jurisdiction that does that, I would be fascinated as to how they make it work. But judges do get sassy when you get to a time estimate. If it's getting cumulative, they will start being like, this is cumulative and we're moving on. So I have not seen that. Time estimates, yes. Time limits, no. And again, constitutional rights. When you're taking away someone's liberty and their freedom and potentially sending them to prison for the rest of their life, potentially more severe consequences, I just don't see how you could tenably do that. Everyone has the right to a trial. So in criminal, you've got this constitutional protected. In civil, if they were going to have that much time, they could always choose to have a bench trial. I mean, suppose in criminal you could too, but it's a bit different. From my perspective, Apathetic Ape, I'd love to see you and Asmon Gold discuss this case afterwards and hear a lawyer and a layman share their thoughts. That would be fantastic. I'm always down to have a chat. I have not watched other coverage of this trial because we've been doing this for like 10 plus hours a day and then trying to do the things I have to do at the end of the day and then sleeping. Can you give an example of an objectionable leading question versus an acceptable non-leading question? Lauren, on the spot, an objectionable leading question would be all of the questions you heard on cross. Isn't it true that this is not the same to photos? Isn't it true this is you you had time to hide the gun, didn't you, Chutney? Leading. Very leading. Versus, did you have a gun? Did you do anything with it? So, open-ended questions versus closed questions that call for a yes or no answer, and subsume the answer into it. Question, what are non-binary attorneys allowed to wear in court in the U.S. from the Philippines? And I haven't seen, heard, or come across any. As far as I know, dress code is crucial here. Riza, I have worked with trans attorneys. I have not worked with attorneys that I know to be non-binary. I would imagine that they could dress how they feel comfortable and appropriate, but I would imagine that could also vary by jurisdiction. I worked in California where juries' mindset can be different, public perception can be different, but I think most attorneys, and I would encourage you to ask an attorney who is non-binary, most attorneys would want to do what presents best for them and for their case, and would probably choose to present however they feel that is. But I don't know if there are dress codes, and different judges get cranky. I had judges that got cranky with me for wearing pants. Things have changed since the early 2000s, and glad for it, but I don't know. I don't know. How will we get the jury's verdict? Will it be televised? If it's not televised, I will literally lose my mind. It will feel like we have gotten to the very last few minutes of the movie when you get the big reveal and then like the power goes out. I can't imagine not having it televised. It should be. I haven't seen anything that says it won't be, but oh my God. Let's not put that out into the universe. Should Cross have asked if there are any formal instructions for how Dr. Hughes administered the test? I think they got into the rules of the test because they went through on Cross, and this might have been, oh no, this was just from a few minutes ago. They went through the form rules at the top. So I think they covered it. Whether the jury absorbed anything today, they're probably so over it. I don't know. They might just be so over it. Why is Amber's team allowed to have a full rebuttal? I thought it was just for her to prove her counterclaim. So in the, she has a rebuttal because she has a counterclaim. In the closing, her rebuttal in the closing just goes to the counterclaim. So the judge has narrowed that, but did not narrow this. So everybody got a rebuttal. So that's the difference between a rebuttal witness and closing. Can lawyers use video testimony from this trial in closing remarks? I don't know if the judge will allow that. It would be up to the judge. Generally, you get them using transcripts, but because generally video is not available. Video is available here. I don't know what the judge would do. I don't know what the attorneys would do. I would want to use their words, and I would want the jury to hear my take on those words. And I think they'll use the audio from bits of evidence, but I don't know. I don't know if they'll ask the judge. Maybe we'll see it if they do. Thank you for being an amazing law professor. I don't know if I'm a law professor, but I definitely try to break it down at least so we can all understand. If the jury comes back with a verdict and the judge doesn't agree, can the judge overrule the jury? The problem is this is a not simple answer to what should be a fairly simple question. It very much depends. It is very, 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 very rare that a judge would turn over a verdict. That means a judgment notwithstanding a verdict. It is very appealable when they do. Can it happen in rare circumstances? Yes. Is that likely at all in this case? No. The judge denied both the motions to dismiss. They found enough evidence for the jury to make the decision. It would only be if the jury did something very, very wonky, like contradictory counts. Like you can't find count one and count two and count three. They contradict each other. They're alternative theories. And the jury finds like all three. It's like legally you cannot find all three. That does not legally follow. Then you can get it there. So question, do you think Camille can split into two? I feel like it'd be more impactful. We need 7 Camilles. New ADHD diagnosed and only okay with my quirks to say, fuck judgy people, registered as a psych. Seeing you excel with quirks has been amazing. Thank you. It's a lot of why I do what I do and how I do it, so that it works for me. My wife, Shay, is a law nerd and got me hooked. We love your channel and wish you continued success. Thank you, Jeremy and Shay. Love watching. Thank you. When this is done, I'm going to miss hearing you say, turn on your mic, Elaine. It's going to come up as a meme. It's a meme now. It's going to come up. It's going to come up. We're going to turn on your sub counter, Emily. We're going to, y'all, you did it. Thank you. Thank you. Thank you. Thank you. With all these objections, issues, and media frenzy, can we get a justice for Judge Askarati trending? I feel so bad for her. Judge Askarati has never been more relatable than yesterday when she was going through the TMZ motion and was like, and the TMZ attorney is like, I know this is a bit unusual or a bit odd. And she's like, so much has been unusual in this case. It was just, I was like, oh, Judge A, we feel you. But yes, justice for Judge A. Detective of 33 years, at home watching with a broken foot. Shout out to my wife, Patsy, who is taking care of me and told me about you, Toby Lewis. Stay safe, stay well. Broken feet are a bummer, but hey, at least you get to watch the trial and see some expert testimony that is both good and appalling. Here's the thing I don't understand. Why they had Dr. Hughes testify, and then they brought on Dr. Spiegel, who was an unmitigated disaster. And with Dr. Spiegel being an unmitigated disaster, why have him testify to IPV? It seemed like, based on the conversation in court, that he might have originally been designated to go to drug and alcohol use impairing memory and cognitive functioning. It seemed like that's what he was there for. And when they were arguing about this is outside the disclosure, that's what gives me that. The disclosure to the court saying, this is the expert, this is what they're going to likely testify about. This is kind of their education background and this is the context. So having him testify about IPV seemed to be ad hoc. And with that, I'm wondering why why they used him to undercut,
All right, are we ready for the jury?
why they used him to undercut Dr. Hughes
Yes, sure.
or try to support Dr. Hughes, and then why bring him back in, or why bring her back in? It just seems so odd. I don't know if they're time checking or what, but they're doing something. Thank you all again. Thank you. Stacy said, can you shout out my girlfriend, Jenna? Shout out Jenna. We are huge fans and chronic replay crewers, and I'm excited to be watching live today. Love replay crew. I think they're checking time again. This is the court's judicial assistant and timekeeper, and it looks like they are checking time again, which is interesting. The time has become a huge, huge factor in trial today. Only bashing her scientific opinion on her own opinion and Amber Heard, she fudged the test to support her own opinion. Maybe, do you think the jury sees the same? They might, especially when compared to Dr. Curry, they might. These experts present very differently. The jury might also be exhausted. Why can't they use the Australia recordings that Brian fell incredibly average? That completely disputes Amber Heard's testimony and prove that she's lying. Obviously the parties know, well, I'm assuming that it's obvious. I'm now glitching like Elaine. What, if any, obviousness is there, Emily? It seems obvious to me that if this audio exists and the internet has it, that the attorneys have it as well. I don't remember if it came up in the UK case because I only went through the judge's ruling at the end of the UK case because we could not watch it the same way here. So I went through the UK ruling. After seeing the evidence here, I think there are maybe some presumptions that I would not have made if I was the judge in the UK, but I am not. The audio in Australia that is known to the interwebs has, I think, been ruled out in this case. I don't know if we will ever know why. I can imagine it's because it involves third parties. There is a stipulation to audio that just has the voices of the two parties in this case. And I imagine that it falls within that. I don't know if there are issues of the propriety of recording it, but they asked Ben King about it. Are you aware that a recording was made? They asked him about it. I don't know if they were trying to open the door to get it in, trying to authenticate it, but it was asked about, and he said that he became aware later. But they did not. They did not enter it. So can you stream your and the Law Nerds reactions to old trials that are on Court TV new series idea? I will see. I tend to go through documents and current stuff, and it's a lot. We are behind. I am behind on quite a lot of cases that I regularly cover. However, it's not, I will not rule it out. I feel like maybe it's perfect for the podcast, like The Office Ladies. You watch a day of trial for an episode. I love your streams. Thank you. I always want to watch them after I watch the trial for the day because case to form my own opinion. Fair. You're always on point with everything. Well, thank you. Thank you for making things easier. That is always my goal, is to make things easier to understand based on my experience and education, and to save you the hundreds of thousands of dollars in debt that law school inevitably brings. Can witnesses hear the approach? No. Or does the white noise block? The white noise blocks it. I want to be able to hear the approach. The jury's not in the courtroom. I want them to just do it on the record. I know you get 1,000 of these, but thank you so much for your effort and everything you do. Huge fan, fellow ADHDer here. Thank you. Jekyll loves Hyde. I am always down for others saying that it helps normalize it for them, because if we can destigmatize neurodivergence in the broader sense and being a professional who's neurodivergent, then I'm here for it. Blue Cannon said, came for this trial, but saw your TED Talk last night. Going through that now and brought me to tears, feeling seen. Thank you. You're welcome. Thank you. I appreciate it. Let's see. I saw Runkle in there. I did.
All right, thank you, ladies and gentlemen. You may be seated.
They have not
Your
wrapped
next
yet.
witness.
Next witness.
Your Honor, defendant calls Amber Heard.
All right, Ms. Heard, if you come to the stand,
boy.
please.
Oh, boy. Oh, boy. Oh, boy. Oh, boy.
Yes, ma'am. Water.
Oh boy. I'm dying to know how much time they have left. They better keep this limited.
Mm-hmm. Thank you, ma'am. And just a reminder, you're still under oath, okay?
Of course, Your Honor.
Thank you. Thank you. All right, your question?
Amber, just to orient you and the jury, at this time, we are in the rebuttal to your counterclaim against Mr. Depp, so I'm going to confine my questions to that, okay?
All right.
I like that
How
Ron
have
is
you
taking the
suffered
questioning.
publicly as a result of the Depp
I like that
Waldman
Ron Born's
statements?
taking the questioning a lot. I'm happy to see that.
Objection, speculation.
Overruled.
And Camille,
I am harassed, humiliated, threatened every single day. Even just walking into this courtroom, sitting here in front of the world, having the worst parts of my life, things that I've lived through, used to humiliate me. People want to kill me, and they tell me so every day. People want to put my baby in the microwave.
that's fucking
tell me that.
appalling. And none of that's fucking
Johnny.
okay. But I don't know if
Threatened.
that's because of the Waldman statements.
Promised me that
That's
if I ever
hearsay.
left him, he'd make me think of him every single day
I think
that I
that's outside
lived.
the scope.
Objection, Your Honor, non-responsive.
Yep.
I'll sustain the objection as to
Yep.
if you want to ask the question.
And she's like, get it, Camille.
Amber, how did Mr. Depp's statements and threats to you that you were discussing,
Not Depp's statements.
how did
Did you
those
see
continue
Bench's
to
face?
manifest themselves today?
In the harassment and the humiliation, the campaign against me that's echoed every single day on social media and now in front of cameras in this room. Every single day I have to relive the trauma. My hands shake. I wake up screaming. I have to live with the trauma and the damage done to me. My friends have to live with a set of unspoken rules about how to not scare me.
Objection, hearsay.
Yes, sir.
It's
Unspoken rules
outside.
Overruled. Go ahead.
They're
about how
unspoken.
to not touch
Not
me, not to surprise me. My intimate partners have rules about how they can deal with me, how they can touch me. I have rules for doctors and medical professionals I see, gynecologists I see. I live my life with these sets of rules that I have to follow, my friends have to follow for me not to have a panic attack or a triggering event where I relive the trauma. Even if I'm training to do my movie, for instance, if I'm training for Aquaman, a combat scene and a trigger happens, I have a meltdown and have to deal with that. The crew I work with have to deal with that because of the damage I walk around with every single day from what I've lived through, from what I've survived. I'm not sitting in this courtroom snickering. I'm not sitting in this courtroom
That
laughing,
is outside.
smiling, making snide jokes.
You were
I'm
laughing
not.
yesterday.
This is horrible.
We watched you
This is
yesterday.
painful.
I don't doubt
This
that's
is
true.
humiliating for any human being
I don't doubt that's
to
true
go
either.
through.
But also,
And perhaps it's easy to forget that, but I'm a human being. And even though
Camille
Johnny
could
promised
object.
that I deserve this,
Yep,
and promised
that's
to
where the
do this,
objection should come
I
in.
don't deserve this. I want to move on. The statements, the attacks on me, the campaign, that Johnny has elicited millions of people to do on his behalf
that's
when he
speculative.
Objection, Your Honor, lack of
Yes,
foundation.
yes, move to
Torture
strike.
me every day.
Move to
Speculation.
strike.
I'll sustain the objection. Next question.
Amber, how have the Depp Waldman statements impacted your ability
Asked and answered.
to do charitable work?
You know,
I don't know if that's relevant, but okay.
the only reason that people like Dr. Curry can sit up here on the stand and say I'm high functioning and do things like have hobbies and
Outside.
have interests is
Objection,
because I'm not.
non-responsive.
Yep.
Your Honor, Mr. Depp gave long-winded responses yesterday.
You didn't object. That's
It's
the
because I found a
difference.
solution to that pain. I woke up every morning with panic attacks and trauma until I realized I could do something with it. So to answer your question, Ben, it's I was able to turn the things that I've lived through,
Ben.
my pain, my life experiences, into work,
To
into
answer your
action, into
question,
providing a voice
Ben.
for other people. I'm not a saint. I'm not trying to present myself as one, as you all know, but I selfishly found relief in being able to use what I've lived through to advocate for others, to bring light to these issues, to give a voice to people who don't have the voice and the platform that I have. And while I would not wish this situation on my worst enemy, if it gives a voice to someone who doesn't have it, but I now, as I stand here today, can't have a career. I can't even have people associate with me because of the threats and the attacks that they have to endure.
Objection,
when they are.
non-responsive.
And I can't do my charity work.
Sustain the objection.
She needs to stop when there's
Amber,
an
other
objection,
than
but
the
Depp didn't
threats
do
that
it
you
yesterday
described,
either.
what other threats have you endured since the Depp Waldman
Calls for
statements were
hearsay. It all calls for hearsay.
I receive hundreds of death threats regularly, if not daily. Thousands since this trial has started. People mocking my testimony about being assaulted, making fun of my.
Objection, relevance.
Yeah,
Non-responsive.
I think that's outside. Talking about what's going on social media during this
You
trial,
can continue.
I have questions about.
It's been agonizing, painful, and the most humiliating thing I've ever had to go through. I hope no one ever has to go through something like this. I just want Johnny to leave me alone. I just want him to leave me alone.
That's gonna come up again.
I've said that for years now, and I thought he would after
Objection,
2020.
non-responsive.
All right, I'll sustain the objection. Next question.
Yeah, she's allowed to watch the internet, just not when she was testifying. She's
What do you hope to
allowed
reclaim
to
after
watch
this
the
is
internet.
over?
I don't know how this is helping. And you guys just remember,
Protecting the secret that I did for as long as I did
whatever your feelings about Amber Heard,
has taken enough
no
of
name
my
calling.
voice. Johnny has taken enough of my voice. I have the right to tell my story. I have the right to say what happened to me. I have the right to my voice and my name. He took it long enough. I have a right as an American to talk about what happened to me, to own my story and my truth. I have that right.
Not your truth, the truth.
I hope to get my voice back. It's all I want. And I've said that from day one.
Thank you, Amber. I don't have anything else.
All right, cross-examination.
Thank you all for no name calling in the chat. Talking about her testimony is fine, but name calling is not. By the way, people receiving threats
Yes,
and harassment
yes.
is never okay. They're going to approach because they kept this very limited in scope. It's interesting to me that they didn't bring up any of the past DV with Tasha Van, I think it's Van Ray. If I pronounce that wrong, I apologize. I think it's interesting that they didn't address any of that. It might be that Amber wanted to have her moment that Johnny Depp had yesterday. He had a moment at the end of his direct examination before his cross-examination where he said why he was going through this. And I tweeted it out. It was a fairly powerful statement. So with this, I think she wanted, the staring down the jury is odd for me. I think she wanted to have that moment of saying, I want my voice back. And that this might be the last witness. And I guess that it probably will be the last witness here before lunch of this case. But it's going to be interesting to see how the jury feels about it, because now we have a very close in time juxtaposition to the two different testimonies, and that could either work well for the jury or not work well for the jury, depending on how they feel about her testimony. But this testimony came in very emotional, very fast. She tried to get into her harassment online, people making fun of her testimony, and this trial, which is very interesting to see, trying to bring that again into court. But after having those social media experts that came in and talked about the hashtags, I don't know how the jury will feel about the online harassment campaign. I personally don't think they have shown a campaign of online harassment. Have they shown that people act like dicks on the internet? Yes. Have they shown hashtags that are not flattering? Yes. Have they shown that those hashtags can be associated with the words hoax and fraud? Yes. But I don't think we have any evidence of an orchestrated campaign on social media. They've tried to make that happen. I just don't think we've gotten there. So to bring it up again, the jury might be like, but we're at the end of the case now. Where is it? You keep trying to make fetch happen. Where is the orchestrated hate campaign? Where is this on social media? Because we did not see that. We saw hashtags that are unflattering, just like we saw appalling texts from Johnny Depp. I think, again, when the jury takes this case back to the jury room, it is very likely that they say, okay, what Johnny Depp said over here, what Amber Heard said over here, fine. What is everything else? What are the photos? What are the documents? What is the other witness testimony? I think Camille wants to get into stuff, and the judge looks like she is explaining to Rottenborn, but you did this and you did that, and she is allowed to get into it because Camille is limited in cross to what was asked in direct. I think that's why direct was so quick and narrow. I will say I liked the dynamic with Rottenborn much better than the dynamic between Elaine and Amber Heard. I wonder if the jury will notice the difference between the dynamic between the two of them. I think Rottenborn probably should have been the attorney that did the examination of Amber Heard at all. It's interesting to me that she brought up Shannon Curry. The only reason people like Dr. Curry can be here, that was very, very interesting to me, because then she tried to rebut Dr. Curry, and she could have, but Rottenborn didn't want her to get into it because Rottenborn didn't want her cross-examined on it. So with that, let's get to a few of your questions. I'm a photographer, and file size absolutely can and likely will be different. iPhones have an option in photos on what you have a device in iCloud, so compression would change size. And they did talk about size changing. It is, I don't even know where we stand with the photos. Like after all the testimony, I would have to go back and rewatch it. Like I don't even know. Like I don't know where I stand with the photos. Where are the tears, though? Felt Johnny's statement was way more believable than Amber's, and some might. I don't stand for death threats and threats against her kids. No, it's fucking horrible. People need to act right. The social media, and this is different with the rise of social media, right? That people can try to DM someone death threats, make threats against them, threats against their kids. I have had more threats against me and my kids in my work in my work being a content creator than I did as a district attorney. I found that very odd. The internet being the internet. It's never okay. I don't understand the mentality behind it. I just don't. But I also think that energy can go elsewhere. Is Whitney side-eyeing Whitney Enriquez? Sorry, I keep calling her Whitney Heard because that is, I know her to be Amber's sister, but Whitney Enriquez is she trying to side-eye the camera? Can you feel it? Can you feel it zooming in? I just think that might be awkward too. But she started this whole thing with the op-ed. She was also the first one to attempt to initiate litigation, it seems. And I think that might come up too. And the jury might remember it, or the jury might be done. Can you clarify for us what constitutes freedom of speech and defamation with regards to libel or slander? I'm going to try to simplify. So you can say awful shit. It just can't be false. So defamation and libel, well, libel and slander, libel being written, slander being spoken, go to something that is not true, that is reputationally damaging. On not this week's podcast episode, which came out yesterday. By the way, the podcast just hit 1 million downloads. Thank you. Not on this week's podcast episode. On last week's podcast episode, I break down the jury instruction on defamation. And chat, remind me, if court ends early, let's just pull that jury instruction up again and break it down. I think that would be really helpful for us to do together, is to break down the jury instruction on defamation. And we will do that if they get done before lunch. It is 11:25. Court normally breaks around 12:30. So there's like an hour left. Again, Rottenborn was strategically very smart in keeping that direct examination very, very short, because you can't cross-examine forever. You could only get into what was gotten into on direct. Camille also did, I think, the appropriate thing and said, you know what, Your Honor, can we approach? Because there are areas she wants to get into and wants to make sure to not raise the objection in front of the jury like we saw in other trials. You want to make sure that door is open and clear it with the judge before you get into it. That is the respectful and the proper thing to do. So when you get into libel and slander, it is a false thing that causes reputational damage. And when it comes to public figures, there is generally an element, not generally, it depends on how the element is worded based on jurisdiction, but there's an element of willfulness, meaning you know that it's false. And that is where proving defamation as a public figure is hard. We talked about this in the Cardi B defamation case. Proving that the person saying it knows it's false is difficult. And that's why the TMZ video matters so much. That's why all of these little pieces of do you know it's false matter so much. That's why proving what actually happened to Johnny Depp's finger matters so much, because you need the jury to be in a place where they say, okay, if I don't believe you, what am I using to back it up that I don't believe you? And they're still talking about whatever Camille wants to get into in direct examination. I think celebrities are made fun of all the time in the media. It goes with the territory, not threats, but making fun of. Yes, I think what she was saying specifically, though, is people were mocking her testimony. And again, that's true. People have been mocking her testimony online. I've seen that happen. I'm sure y'all have seen that happen. Oh my God, the 200,000 of you that are here. Hi. I'm Emily D. Baker. You can do the YouTube things if you like. The look on Amber's face yesterday when Johnny spoke about this was smug and vengeful. Johnny's look on his face while Amber just spoke looked like he was regretful that it's come to this. I think that speaks volumes. And we will see. If the jury was paying attention to Amber Heard's demeanor yesterday, she was laughing and joking with her attorney. I don't know if all of that was in the presence of the jury, and it might not be. What can we expect from closing tomorrow? Oh, closing is the greatest. Will Johnny Depp and Amber Heard need to be present? Yes. How much spice will there be? All. Thank you so much for helping me understand the process. If you watch no other day of this trial, closing is where it's at. It is where the attorneys not just walk through the law and how they think that they will get to proving their case, but it's also where they will get to argue against the other side and say, you know, that this proves these things, these facts prove that we are in the right and the other side's in the wrong. I imagine that we will get audio clips. I can't imagine that we wouldn't. I want to see if Johnny Depp's team ends with the tell the world Johnny, and it will be a back and forth. Depp's team will go first, then Heard, then Depp, then Heard. So in 2 hours, we will get a lot of back and forth. It'll be feisty. And we'll get the jury instructions for the first time. And we'll get to see if there's any limiting instructions about discovery violations. We'll get to see what Judge A has done with that. We'll get to see if there's an instruction about attorney-client privilege to limit the negative inferences the jury can draw, because Waldman pled the fifth. Wrong, Emily, because Waldman asserted attorney-client privilege. Well, Depp asserted attorney-client privilege and Waldman didn't talk. So we will see it for sure. All right, let's get to some more questions. If the chat is moving fast and I don't get them, I apologize. Putting question or a question mark at the front really helps. Since Amber Heard brought up what she did, can Johnny Depp's team bring up the Elon Musk embryo media for more context? No. That has not come into this court at all. That's not come into this trial, and that is well and far outside the scope. Also, it's something I'll have to look into after this trial because I have no idea what that's about. I feel Whitney stare through my soul right there. I mean, Whitney, this can't be easy for Whitney. I've been following you since day 3 of the trial, sending you all the love from Nigeria. Thank you so much. Thank you, thank you, thank you, thank you. Mercy. Appreciate that. The makeup fairy was not discussed in relation to the metadata. They didn't discuss a ton with relation to the metadata. It was pretty quick. As a non-law junkie, well, law nerd junkie, sweet cheek or cheeks, I don't feel like either party proved anything. How in the world can Johnny win with all that he said, she said? Can you please give me solid examples of proof? Well, after closing arguments, I think it will be the better time to go through it because it's been 6 weeks of trial. But I think you absolutely have proof that the statement was made in the op-ed. We know the op-ed was published. We know Amber Heard wrote it. We know that it was in part about Johnny Depp because she said it was about Johnny and others, and that's all from her testimony. So we have those elements. The back and forth really comes onto whether Amber Heard was allowed, or whether allowed's the wrong word, whether it's defamatory for Amber Heard to characterize her relationship with Depp as abusive. And that's where the back and forth comes on what happens. And the jury could very much go, no, none of this is defamatory. There are elements of truth to all of it. There are elements to truth to the Waldman statements. There are elements of truth to the Heard statements. No one defamed anyone. They could do that. They might not do that, but they could if they wanted to. So the closing argument, each side tomorrow is going to point out what they think their strongest evidence is. Evidence comes in the way of testimony, documents, photos, and you can have direct evidence. I saw this. Like the guy from Mr. Knight from Hicksville. I saw this. There was $62 worth of damage to the trailer. That's direct evidence of the damage to the trailer. But you can also have circumstantial evidence like the guy from TMZ. And I'm pulling these examples because they're closest in mind because they just happened yesterday. And reaching back through 6 weeks of trial is much harder for my brain after streaming for 12 hours a day for like weeks. So the guy from TMZ said, look, if the copyright holder gives us the video, it takes us about 15 minutes to verify the video and get it up on the site. Time is of the essence for TMZ. But what he didn't say is who gave him the video of the door slamming. We know it was taken on Amber Heard's device. She testified to that. She testified to taking the video and why. And then the TMZ guy said, if the copyright holder gives us the video, it takes us about 15 minutes. How long did it take this video to go up? 15 minutes. And so Camille looks like she's ready to get to cross. The judge looks like she's still explaining something to Rottenborn that he's not liking. So that's circumstantial evidence. Did it say to the jury, Amber Heard gave TMZ the video? No. Can the jury conclude that from the evidence? Yes. And that's circumstantial evidence. And circumstantial evidence is a valid form of evidence. We're about to start cross-examination. I'm so excited. Here we go. Don't forget to do the YouTube things. So wild that there are over 200,000 of you here. Thank you so much.
Ms. Heard, you just testified that this case has been very hard for you. So let's talk about that and why.
All right.
Your lies have been exposed to the world multiple times,
Oh,
right?
shit.
I haven't lied about anything I've been here to say.
You sat here and told this jury that the events in Hicksville started with Mr. Depp getting really upset about a woman leaning on you. Is that correct?
Yes, that's effectively what happened, yeah.
You testified that he actually grabbed that woman's wrist and twisted it, right?
And told her that he could effectively break her wrist by saying he knew how many pounds of pressure, or asking her how many pounds of pressure it took to break a human wrist.
But your own witness, your former best friend, Rocky Pennington, she didn't corroborate that, did she?
She did not.
I'm not quite sure what part of that night she saw. There were a lot of people there.
That's fair.
She didn't testify that Mr. Depp grabbed anyone's wrist in Hicksville.
Again, I don't know what Rocky saw. There were a lot of people there that night.
You testified that once you brought
none of
Mr.
them
Depp
saw
back
that,
to your
though.
trailer, he trashed it, correct?
That is correct.
And the manager of the Hicksville trailer park was furious that Johnny had wrecked the whole thing. Do you remember that testimony?
That's correct.
Well, we heard from that manager of the Hicksville trailer park, Morgan Knight, on Monday, didn't we?
I'm not quite sure who that guy was or if he had any involvement in this. I know a lot of people have come out of the woodwork to be involved.
They want their 15 minutes of
So you're
fame.
accusing Mr. Knight of testifying
Falsely.
and committing perjury?
Yep.
I'm not accusing anyone. I just don't recognize that man.
You heard Mr. Knight testify that it was actually you who was upset with Mr. Depp spending time away from him. Isn't that correct?
How would he know? He wasn't there.
You heard Mr. Knight testify that it was actually you who was yelling
there?
at Mr. Depp.
Again, I've heard a lot of people say a lot of things to be involved in the Johnny Depp show, but he wasn't there. He doesn't know. And he certainly doesn't know what happened behind closed doors, like most people.
So you're calling Mr. Knight a liar?
Does.
I am saying he wasn't there.
With
and
regard to the
what
damage.
he testified to doesn't match what I know happened. But I don't fault him. He wasn't there, so how would he know?
He testified he was there, Ms. Heard. Did you hear that?
That's his testimony, yes.
So you're calling him a liar.
I'm just saying he wasn't there.
You heard Mr. Knight testify that the trailer wasn't trashed, and that's why you're calling him a liar.
He testified that a light fixture was broken, similar to the way that
Yes, other
Johnny's
than a light
employees
fixture, that was
testified
the
to
only
my
thing that was
closet being
broken, right, Ms.
rearranged
Heard?
and things
Ms.
like
Heard,
that.
the only thing that was broken in the trailer, according to Mr. Knight, was a light fixture. Yes or no?
I realized that he summed it up by saying a light fixture was broken, just the way his security guard summed up him trashing my closet as being rearranged.
Your Honor, I'm going to move to strike everything after he summed it up, that it was a light fixture.
So everybody's going to have a rough
As
time on
non-responsive.
cross,
Answer
on
the question,
rebuttal.
Your Honor.
Overruled.
In the security guard testimony, Your Honor?
I'll allow it, go ahead.
Oh, well then we're getting into all
Mr.
of
Knight
it.
also testified that he charged Mr. Depp only $62 for the damaged light fixture. You heard that,
Oh, this is
correct?
going to be hot.
I did.
In Hicksville, you were the only one that was jealous that Mr. Depp was spending time from other people.
Weren't
Isn't
you?
that correct, Ms. Heard?
That is incorrect.
In Hicksville, you were the one who was upset that Mr. Depp wasn't giving you enough attention.
Incorrect again.
Ms. Heard, you told this jury that you had no idea the press was going to be at the courthouse when you got your TRO
Oh,
on May
TMZ.
27th, 2016. Do you remember that testimony?
I said I did not have anything to do with it. Yes.
No. My question again. You told this jury that
My
you had
question
no
again.
idea that the press was going to be outside after you got the ex-party TRO on May 27th, 2016. Do you remember that testimony?
I apologize. I must have misunderstood Ms. Vasquez. I actually had no idea whether they were going to be there or not. When I walked into the courtroom that day, it was completely quiet, still, empty. Even though I had given Johnny's team notice that I was filing a
Objection. Your
TRO,
Honor, this is
we
not
had no
responsive.
reason to
Move to
believe the
strike.
press knew.
And Your Honor, I would also ask that you instruct the witness to please stop talking once I lodge an objection.
Your Honor, she's trying to answer the question as best she can. Ms. Vasquez is misrepresenting to her what she testified to.
Well, I'll strike the last part as non-responsive.
Thank
Just if you could just answer the questions asked, okay? Thank you, Ms. Heard.
In fact, you testified that you were, quote, shocked when you saw press when you were leaving the courthouse.
Also, the
Yes?
press wouldn't be
Yes.
inside the courthouse.
You
with
weren't
cameras.
shocked
They
at all,
can't
though, were you?
record inside the courthouse.
Incorrect. It was
You knew the press
horrifying.
would be at the courthouse, right, Ms. Heard?
No.
Well,
I'm
you did
looking
bring
at
your
the jury's
publicist to the
disconcerting.
courthouse with you on May 27th, 2016, didn't you?
I sure did. I'm a public figure. I brought my publicist in case it blew up. In case. And
You
I'm
actually
glad
had
I did.
alerted TMZ that you would be filing a TRO against Mr. Depp that very
No,
day,
I did
didn't
not.
you?
No, I did
The
not.
one day you didn't bother to wear makeup to cover up the mark on your face.
I did not call TMZ or any other news source or paparazzi source. No one.
Well,
I
we
never
heard
did that.
testimony from former TMZ employee Morgan Tremaine yesterday, correct?
Did I hear his testimony?
Yes.
Yes, I was here.
Yes. And you heard Mr. Tremaine's testimony that he knew to dispatch the paparazzi to the courthouse on May 27th, right?
I heard him say that he knew that, yes.
Yeah, and that he dispatched paparazzi to the courthouse to capture a picture of an alleged bruise on the right side of your face. Do you remember him saying that?
I remember him saying that.
She's holding her
That
own
information
cross.
must have come from your team, right, Ms. Heard?
Absolutely not. Why would I want that? What actual survivor of domestic violence wants that?
Now, the
were
video of
supposed
Mr.
to
Depp
turn your
beating
face,
up
he
some
said.
kitchen cabinets, you admit that you took that video, correct?
Yes, I did.
Right. And you acknowledge that the video was released online the day before you were deposed in connection with your divorce from Mr. Depp in August of 2016, right?
I believe it was, yes.
But you testified that you had absolutely nothing to do with the video's release, right?
Absolutely not.
Wait,
And
you
you testified that you
absolutely
learned
not?
about it when you landed after flying into LA. Do you remember that testimony?
Upon touchdown is when I was alerted to the video's
You
existence
heard Mr.
online.
Tremaine testify about this
the
video
video.
as well yesterday, didn't you?
Yes, I did.
And you heard Mr. Tremaine testify that TMZ received the cabinet video
Danger,
the same
danger,
day you landed
danger.
at LAX. Yes?
I don't know if that's what his testimony was. I'm sorry.
You heard Mr. Tremaine testify that the cabinet video was
Camille's gonna
posted
tell you.
15 minutes after TMZ received it. Yes?
That's what I heard him say.
And that this could only have been possible if the video was received directly from the source. Yes?
I heard him say that. I don't know if that's true or if that's possible because
And
it
you
didn't come
heard
from me. I was
Mr.
flying.
Tremaine
So
testify.
I know that's incorrect is what I mean to say.
Another liar on the stand.
I just know that that's
Everyone's a liar but
incorrect.
her is their theory of the case.
And you heard Mr. Tremaine testify that TMZ owns the copyright to the cabinet video, right?
That's news to me.
They
The cabinet video you filmed of your then husband. Yes?
The copyright ownership of that is news to me. I learned that yesterday.
No, you
It's
didn't.
the cabinet video.
Camille asked you
that
about it on Cross.
captured
You didn't learn
of
that
your then
yesterday?
husband. Yes?
That is correct. I did capture that video, and
The
yes,
cabinet
that was my
video-
husband.
The same cabinet video that was released the night before you were deposed in your divorce. Yes?
That's correct.
You must have also heard Mr. Tremaine testify that the version of the cabinet video that TMZ received was incomplete compared to the video the jury saw in this trial. Did you hear that?
The video that you have seen is complete.
Right. But the one
That's not the
TMZ
question.
got the day before your deposition in the divorce was incomplete.
I don't know. I haven't seen it.
He testified that at the beginning portion of the video where you set up the camera, that wasn't included in the video that TMZ received.
I don't know what video TMZ
I'm talking
received.
about Mr. Tremaine's testimony, Ms. Heard. Let's just
So you're
focus on
asking me
Mr.
to
Tremaine.
repeat his testimony?
No, I'm asking you if you recall hearing him say those words to this jury.
Yes,
Under oath.
I heard his testimony. We all did.
And he testified that the end of the video where you can be seen smirking. I know you testified earlier that you haven't been smirking in this trial, but you sure were caught on camera smirking in that video.
I disagree with that.
Was also not included in the TMZ video.
Everyone can watch that video and you can determine whether you think it's funny to me or not.
That's because the video came from you, right, Ms. Heard?
She didn't say funny. She said
No, it did not.
smirking.
You
That
edited
video
out
did
the
not
portions.
come to me. I
Ms.
mean,
Heard,
come from me.
Ms. Heard,
You've
you
been
edited
admonished by
out
the
the
judge once,
portions
Ms.
that
Heard.
made you look bad before sending it to TMZ.
You're very wrong about that.
So
If
that
I
only
wanted to
Mr.
leak
Depp
information, I
looked
could have
bad.
done it in a more effective way, a lot sooner and a lot more.
Because you
I
knew
was
exactly
living
how to
with
do
a
that,
mountain
right?
of this evidence. If I wanted to leak it, I could have done a
Mountains?
lot more with it.
Mountains?
So you testified earlier in this trial that you didn't know how to leak things.
I
Remember
don't.
that?
Don't try to out clever.
You edited that video before you gave it to TMZ so that only Mr. Depp would look bad. Yes?
That's absurd.
Right in the middle of your divorce proceedings.
Again, you're very wrong.
Look at Camille, not the jury.
I'd like to show you a picture that's already admitted into evidence. It's Defendant's Exhibit 799.
We'd love to see it. Oh boy. This is the problem that Team Heard has right now. They are very limited on
This
time.
is you at the courthouse on May 27,
Camille has
2016,
all
when
the
you got
time
your
in the
domestic
world.
violence restraining order against Mr. Depp, right?
It is.
And next to you is a woman named
Why
Jody
this wall
Gottlieb,
looks
right?
weird.
Yes.
Jody Gottlieb is your publicist.
And dear friend.
Now I'd like to show you what's been marked as Plaintiff's Exhibit 1316.
Is that the first time we've heard her call a friend? Because I think it is.
This is a picture of you and your friend Rocky Pennington, right?
That is correct.
Your Honor, I'd like to move to admit this photograph.
New
Any
evidence.
objection to 1316?
No, Your Honor.
All right, 1316 in evidence, you can publish to the jury.
Ooh, publish.
This is a picture of you on May 28th, 2016, right, Ms. Heard?
I don't know when this was taken.
This is the day after you obtained the domestic violence restraining order against Mr. Depp, right?
Oh boy.
I have no idea when this image was taken. I did not take it.
There's no bruise on your face in this picture, is there?
Again, I don't know when this was taken, and also I'm outside. I was obviously wearing makeup. I have no idea when this was taken, so I have no idea if I can
Let's
speak
refresh
to
your
what
recollection.
bruise you can see
Let's
or not.
refresh your recollection about when this picture was taken. Can we please pull up Plaintiff's Exhibit 1315, just for the witness?
Oh boy.
This is an article dated May 30th, 2016, right, Ms. Heard?
That's what it is, yes.
And this article contains the same photograph of you and Ms. Pennington we were just looking at, yes?
Yes, I see that.
And the article is entitled, Amber Heard Smiles as She Puts Arm Around Friend One Day After Getting Restraining Order Against Johnny Depp. Is that what the title says?
I know that's what the title says, yes.
Your Honor, I'm going to move to admit and publish the article with everything but the headline and date and the photo redacted.
Objection, Your Honor. That's inconsistent from the way you treated all of these.
I'll sustain the objection. All right, next question.
Let's take a look at picture Plaintiff's Exhibit 1317. This is also a picture of you and Ms. Pennington on May 28th, 2016, isn't it?
I don't know when this photo was taken, but it looks like the same outing as the picture prior.
Your Honor, I'm going to move to admit and publish Plaintiff's Exhibit 1317.
Any objection?
No, Your
All
Honor.
right, 1317 in evidence, you can publish.
There's no bruise on your face in this picture either, right?
Publish it.
I disagree. If it is taken when you represent it was taken, then obviously there's a bruise on my face. It's covered by makeup as per usual.
Let's zoom out of that picture for a moment, please. Thanks, Tom.
And the jury's going
That's
to
Josh
believe
Drew in
what
this
they
picture,
believe.
right?
Yes, that's correct.
And Ms. Pennington
That is correct.
in there too?
That
Ms.
is correct.
Pennington submitted a sworn statement on your behalf
like
in
the rest
support
of
of your
his sleeve,
domestic
though.
violence restraining order, didn't she?
I believe she did, yes.
Mr. Drew also submitted a statement in support of your domestic violence restraining order.
I believe they both did, yes. Mhm.
Ms. Hurd, I'd like to show you Defendant's Exhibit 512, which is already in evidence.
Oh boy. I like that they're going through photos. This is exactly what Rotten
You've seen
Boy
this
did
photograph
yesterday.
before, right?
I have.
On the second day of your direct testimony, you testified that this was taken in the downstairs of the main apartment on
Oh my
December
God.
15th,
She's going to bring up the
2015.
discrepancy
Do
in
you
these
recall
photos.
that testimony?
It's not come up yet.
Yes, I believe so.
So it's your testimony that Defendant's Exhibit 512 reflects damage to Penthouse 5 that occurred during the December 15th, 2015 incident. Yes?
I'm not quite sure from what incident this is when I see this photo in a vacuum without context.
Let's give you that context. Can we please?
Dead. I'm dead.
I could have day 16. trial
This
testimony.
photo, just for what I'm thinking, since they're pulling up the photo, this photo has been submitted twice. It is slightly colored different, like the contrast is different, but it's been submitted twice, going to different events, and they have not brought up that discrepancy yet. Oh, I thought we would have a longer break, but it's going to come up. So these photos are submitted
Could you
for
please turn
different
first
events.
to page 4585?
And we've not seen it come up other than on the internet, where the internet has been like, those are the same photo. Wow.
Sorry, one sec.
Specifically starting on line 16, where it says,
Camille
let's
is
talk
matching
about
energy.
December 15th, 2015.
You said 458. Oh, I'm on 4485. Sorry, you said 4585.
4585.
Pardon.
Line 16.
I will try to get to the questions when we get breaks. Tanya said, once again, everyone else lies, including her own witnesses. This is what Camille's going to try to point out for the jury. And again, Camille has so much more
Line 16,
time.
where it says, let's talk about December 15th, 2015. Do you
Lizzie
see
Beth,
that?
I didn't know that was out yet.
Yes.
I have not seen it yet, but thank you.
And then do you see that your testimony
Thank
about
you.
December
I'll go find
15th,
it.
2015 follows?
Let's see. It's just the first line or two.
At closing, it will be Depp, then Heard, then Depp, then Heard. They each have 2 hours. The time today doesn't count against. Heard's team started today with much less time on the clock at just about
Yes.
an hour and 15 minutes.
Now, I'd like
Depp's
you to
team
turn
had
to
7
page
hours.
4603,
This is going to be a long, I think, well, a methodical cross.
starting at
point
line 12.
by point by point.
4603.
And that is where this time in this trial is going to play in so heavily. Each side started this trial with 61 hours
Starting
and
at
15
line
minutes.
12 and going on to page 4604, line 4.
Okay.
And do you see that you testify that Defendant's Exhibit 512, which is on the screen,
Yes,
is a picture of the downstairs of the main apartment?
that's correct.
And the main apartment is Penthouse 5 in the Eastern Columbia building, right?
No, well, depends on what, the main apartment's penthouse 3 generally when we say main apartment.
Penthouse 5 was where you had your closet?
The downstairs was kind of like had
That's
some
not
of
the
my
question.
painting studio set up and a reception area. Upstairs was the closet. Mezzanine office was in between.
All right, so it's your testimony that Defendant's Exhibit 512 reflects damage to the penthouse, Penthouse 5, that occurred during the December 15th, 2015 incident, right?
I'm just not sure from which incident this is a picture of, since I'm only looking at
Even
a
though your
partial
counsel
floor.
You
was
testified to
asking you
it.
questions about December 15th, 2015, and then admitted this picture into evidence
Again,
in
in my
relation to that incident,
Sorry, go ahead.
in relation to that incident on December 15th, 2015. This exhibit, defendant's exhibit, you are the defendant, number 512, was admitted into evidence in this court. You testified that this was the result of damage that occurred on December 15th, 2015. Yes or no?
I just need to orient myself because I'm just looking at a picture of a partial
No,
picture of a
Ms. Hurd,
floor.
you didn't just
She's
look at
not
a picture.
oriented to time.
You looked at your testimony.
You pointed me towards the page and then asked me a question. I haven't actually reviewed it. I don't know if this was submitted in relation to that incident.
Let's actually
jury
leave
does
out
now.
defendant's 512 and please pull up defendant's exhibit 725,
Oops, side by side. The thing
which
is,
is already in evidence.
Thank you.
In
in
redacted
cross,
form,
the
Your Honor.
questions
All right, thank
a
you.
lot of the time
Side
matter
by side.
more than the answers. Let's do them side by side.
You've seen this photograph as well, right?
I have.
There it is.
On the third day of your direct testimony, you testified that this photograph reflected spilled wine in Penthouse 5 on May 21st, 2016, didn't you?
Again, I don't know because I'm looking at a partial picture of a floor. So unless you remove the metadata you've covered up, we could then tell. If you
I didn't
remove-
cover it up, Your Honor.
Could we unredact
Your Honor
them
did.
so we could get context?
Oh,
That's how it's in evidence.
That's how it's in evidence.
Next.
Well,
your team put it in
metadata
evidence.
next to it is so that.
Ms. Hurd,
there's no
Ms.
question
Hurd, There's no question pending, and I would appreciate it if you wouldn't be making argument to the jury.
Sorry, I
It's
thought you had
inappropriate.
asked me about it.
it's inappropriate.
No, I didn't ask you about anything. Let's look at your direct testimony
You
from
can see Chanley
the
Painter
third
looking
day.
at the jury here, Runkle looking at the jury, DUI guy looking at the jury. You can see everybody looking at the jury, which is this direction here. Wow. And again, this is what we got with Depp too, confronted with the photos that they were holding out until the end. And that is not surprising. None of this would have come up if Hurd hadn't testified. But these two parties want to have their say in court. And with that choice comes cross-examination and wow.
Let's turn to page 4750
Camille Crossboss
in day
Vasquez.
17 transcript.
Sorry, can you repeat that?
4750.
Slowing it down is not going to make it less painful at this point. And this is the thing, Camille has the time to go line by line by line that they could not do with Depp yesterday because they simply did not have the time if they wanted to get to their three
Specifically
witnesses
line
today.
16.
I want to
You
know what's
see
on
where
line
Ms.
16.
Bredehoff asked you to describe for the jury what took place on May 21st, 2016?
I see that.
And do you see that your testimony is reflected about May 21, 2015
Yes.
that follows? Okay.
Yes.
Now let's turn to page 4804.
I haven't even looked up. Thank
line
you all for
14.
watching this with me. This is wild cross.
4804. Starting at line 14
Yes.
through 4805, line 4.
What's interesting though is Amber Heard's demeanor on
going to what
cross
line?
has been
Line
good.
4 at 4805.
She has held her own. Even when her testimony seems contradictory, she has just held her own. Just nope.
Do you see that you're testifying that defendant's exhibit 725, which is reflected on the right side, reflects spilled wine on the floor in Penthouse 5?
That's correct.
Okay. And defendant's exhibit 512 and 725 seem to be different versions of the same picture, don't they?
That's correct.
Okay. So which is it? Which one was taken on December 15th, 2015?
She's going to say, I don't know.
Or May 21st,
I can't see the metadata.
1st, 2016?
If you remove the redacted metadata, you can find out. It's right there.
Or if you're telling the truth, you would know.
Oh, shit.
Recognize a portion of of spilled wine on a floor, and I'm supposed to know off the top of my head when you've
No.
lived through 5 years of this stuff? I don't think so. That's not how that works.
Oh, the best friend's necklace is back.
Thank you, Tom.
I think my favorite part of Amber Heard's
Ms. Hurd, at the
cross-examination
beginning of
last
your
time.
cross-examination
Your
last
Honor, may we
week,
approach?
My favorite part of Amber Heard's cross-examination last time was when they were talking about the cocaine table photos. And she's like, it doesn't look like people have been, this is a very neat table. It doesn't look like people have been snorting cocaine off the table. And Amber Heard looked at Camille Vasquez and was like, respectfully, I don't think you know how that works. Favorite moment, I think there were good moments, but I think that was one of the lighter moments of cross-examination last time. And again, Johnny Depp has been cheeky and sometimes dismissive on cross-examination. Amber Heard has too, but she has held her own and her demeanor on cross. If this had been her demeanor, I think on direct, I think it would be a lot easier for the jury to hear her story. Sometimes her responses to questions on direct got so big and then don't match the other documentary evidence that it was hard. Her demeanor here is much easier for me to listen to, even though it's on cross. And that is really interesting.
All right, ladies and gentlemen in the gallery, I would ask that there would be no words or no phrases, no words, no sounds at all coming from you. If I hear one more sound, I will clear the gallery and we will continue this testimony without anybody in the courtroom. Understood?
What the fuck
Good.
did they do
All right,
in the
your next
gallery? Because that can
Ms.
impact
Hurd,
the
at the
jury.
beginning of your cross-examination last week, I
shit.
showed you an audio where you told Mr. Depp to tell the jury, tell the judge, tell the world that he is a victim of domestic abuse. Do you remember that?
Oh, God.
That's correct.
And you testified you found it hard to believe that Mr. Depp would tell the world that he's a victim of domestic abuse, didn't you?
I said I find it hard to believe that he would do that knowing that he himself had beat me up for 5 years.
But he has told the world that he's your victim of domestic abuse, hasn't he?
Well, he started to say that only recently. He didn't make that claim up until very recently. So when we signed our divorce agreement and we signed a statement saying that neither party had ever said false claims for financial gain, it was relevant and important to me because I was the only one making the accusations. I was the only one making those claims. He wasn't doing that at the time, and he signed his name to it.
You didn't expect as many people to show up and testify on his behalf that did you?
Incorrect.
When you told this jury under oath that you
Should have
never
said the witness
assaulted,
list. Camille.
when you told this jury under oath that you punched Mr. Depp because you thought of Mr. Depp pushing Kate Moss down the stairs, you didn't expect Ms. Moss to agree to testify that never happened, did you?
Incorrect. I know how many people will come out of the woodwork to be in support of Johnny.
So
It
you
is
think
clear
Ms.
by this
Moss
courtroom
needs
how
to
many
come
people
out
will
of the
do that.
woodwork to testify for Mr. Depp?
Ask her, does Kate Moss
Everybody
just want
who
her
was
15 minutes of
around
fame?
in the 90s and the early aughts knew that rumor. I had heard that rumor from multiple people.
Everyone.
Of course, that's what flashed through my head when my violent husband not only swung for me, but all of a sudden swung for my sister.
That's not
Of
what your
course I
sister
thought of
said.
that. I did not expect her to show up or not expect her to show up. It didn't matter. It doesn't change what I believed at the time when we were on the stairs and I thought he was going to kill my sister by pushing her down the stairs.
Oh,
You
shit.
told this jury under oath that Mr. Depp was aggressive and trashed a trailer in Hicksville. You didn't expect the manager of the Hicksville property, Morgan Knight, to come forward and testify that was untrue, did
Notice
you?
how Camille changed
Incorrect.
demeanor?
I've already been through trials with this man. I know how many people will come out in support of him.
When you told this jury under oath that you had no idea that the paparazzi would be at the courthouse on May 27th, 2016,
Good line of
you
questioning.
didn't expect a TMZ employee to show up to testify that TMZ had been alerted that you would be at the courthouse and knew exactly which side of your face to take a picture of, did you?
I know how many people will come out and say whatever for
She's
him.
just sticking with the
That's
answer.
his power. That's why I wrote the op-ed, is I was speaking to that phenomenon. How many people will come out in support of him and will fall to his power? He is a very powerful man, and people love currying favor with powerful men.
Currying
And I know
favor
that
and
firsthand. I've
risking
lived
jail
it.
time for committing perjury?
Excuse me? I didn't hear your question.
I was in the middle of my lines.
Ms. Vasquez, if you do mind,
Curry-
please just repeat the question. I didn't hear you.
Curry favor and commit perjury in this courtroom?
I have
For a
seen people
powerful
do this.
man?
I have seen people do this time and time again.
Commit perjury?
That's
You've seen
why
people
I
commit
wrote the
perjury?
op-ed.
You didn't expect Ben King, the house manager in Australia, to show up from England. He flew from England to testify that Mr. Depp's fingertip was found exactly where he said it would be. Did you?
I have never heard Johnny testify to knowing where his finger was, or really, frankly,
That's not the question.
making a claim that he knew where it was when it was found.
That's not the question.
I've never heard Johnny claim that.
Johnny
You didn't
didn't.
expect
Johnny
Keenan
doesn't-
Wyatt.
Johnny has never
Ms.
actually
Hurd,
said
She's asking you about Ben King.
And
I think the
Ben
jury
King,
can,
yes.
Ms. Hurd, there's no question pending. You didn't expect Keenan Wyatt, Mr. Depp's longtime sound technician, to show up and testify that Mr. Depp is not being fed lines through his earpieces, but instead music, did you?
Not that it matters much, but of course I did. I know how his employees treat him.
So you
I know how
probably-
his team treats him. Of course I expected that.
Okay, so you probably expected Isaac Baruch to come and testify for Mr. Depp, right?
Isaac said things helpful to her too.
I'm not sure I thought about that.
Yeah. But you didn't expect Mr. Baruch to weep for Mr. Depp. after what you've put him through and so many others with your lies.
I
did you?
relate to Isaac
she's almost
because he
done.
and I are the
I have
only
nothing
ones
further.
who cried on this stand.
Oh, shit. She just walked out on her. Camille just mic dropped on her and said, there's nothing further. There's nothing pending. Camille just walked off. Camille walked off while Amber
you,
Heard
Your
was still talking.
Ms. Heard, if Mr. Baruch felt misled, who misled him?
Johnny, and I don't blame him. I don't blame him from crying. This is horrible.
Ms. Vasquez has suggested that you faked bruises on your face. Is that true?
Absolutely not. I didn't need to.
I would just end with
Did
that.
you ever fake an injury caused by Mr. Depp?
No.
I would
Is
end with
any
that.
of the evidence of your injuries that has been put to the jury in this trial fake?
No, absolutely not.
And to the extent that there may be some confusion over when a picture of spilled wine was taken, why might that be?
Objection,
Because there's so
lack of
many-
foundation.
Overruled.
Because there's so many incidents of violence. There's so many pictures. There's so much evidence.
There's so many pictures.
Most people don't have this kind of evidence for years, 5 years. And when I was saying that to Johnny on the phone in that recording, I was saying for years this has been going on. And I have pictures, we have texts, we have everything. Normally you don't get this amount of evidence. That's what I was pointing out to Johnny. It would be crazy to try to challenge this in this way. It's crazy. It's easy to not know the context of a picture of spilled wine because there are so many more important details, pictures, and also
What's more important? What's
so
more
much
important?
I didn't photograph, so much I didn't have the presence.
Objection,
time to document.
non-responsive.
All right, I'll sustain the objection. Next question.
Did
The
Mr.
jury's
Depp
going to
abuse you
decide
physically?
if there's mountains of
Yes.
evidence.
Verbally?
Yes,
Emotionally?
yes,
Psychologically?
yes.
How did the threats that Mr.
He should
Depp
have
made
asked
against
about
you
sexual abuse.
individually years ago resemble what you've endured as a result of the Depp-Waldman statements?
And he did not.
Beyond the scope of cross, Your Honor.
It was.
Overruled.
Johnny promised me he would ruin me, that he'd ruin my career, he'd take my life from me. Death was the only way out. And if I got out, this is what he'd do to me. He'd make me think of him every single day. He promised me global humiliation. You saw those texts. What he couldn't do, the work of one individual, meaning Johnny, when he was inviting a disgruntled employee over for a spot of purple to fix my flabby ass up, that revenge that he sought back then was just what he could do as an individual, calling the studio to get me fired, trying to block him.
Objection, Your Honor, lack of foundation, speculation, hearsay,
all in
non-responsive.
It's
I'll
not
stay
all
as
in evidence.
non-responsive.
It is non-responsive.
Ms. Heard, how did those things that you just testified to that Mr. Depp did, how did those resemble what happened to you after the
minutes away
Depp-Waldman
from evidence
counterclaim
closing
statements
here.
were made?
Those are,
I don't
There's
know
Your
why he
Honor,
didn't
lack of
ask. He needed to
foundation.
ask that, and I don't know why he
She's-
didn't ask.
Overruled.
Thank you. Thank you, Your Honor.
those are just an echo of what I'm living through today. It's like what I'm living in right now. What you see in this courtroom is an echo. This courtroom and the other courtroom he dragged me into to do the same thing again. That's just an echo of the violence and the abuse that I suffered within our relationship. The campaigns to have me fired, the blocking me to try to ruin my career, the threats he's made to humiliate me globally are being lived out in real time in front of you, ladies and gentlemen, for the past 6 weeks. And
She's
for the
just
whole world.
going to do her own
since
closing
camera's
argument
here.
right now.
No further questions. Thank you so much, Amber.
All right, Ms. Heard, you can have a seat next to your attorneys.
Them calling each other by their first name is odd. I think Amber
They have
Heard's
the
team's going to
attorney's
rest.
approach.
We have no further what. Oh, they're going to figure out timing. I think this is the end of evidence. I think we have reached the end of evidence. But it seemed like Amber Heard wanted to give her own closing argument. I want to know what happened in the gallery to get the judge to admonish the gallery so strongly. The gallery has to be mindful because their reactions can impact the jury. So it's just there are a lot of people in the gallery. We know from those that have been there in person that it's largely Johnny Depp fans, and it would be very difficult if one of those fans in the gallery did something or said something that impacted this jury in a way that could upset this case after 6 weeks and likely tens of millions of dollars of litigation. That would be wild. So, thank you. Grant, no need to be conflicted. I think Amber Heard absolutely feels the pain of a global kind of hate campaign. Whether that was orchestrated by Johnny Depp or not is for the jury to decide. But there's no denying that that is in fact going on online. What it's caused by is really the question here. But I've always said throughout this trial, the parts of Amber Heard's testimony that rang the most true to me is when she is talking about her career, when she is talking about the negative impacts of her career, and when she's talking about her reputation online. Whether that's attributable to the statements she's suing over is the big question. But I absolutely believe that we've seen it throughout this trial, how she's been talked about on social media. We've seen the weight of public opinion against her. So I absolutely believe that she feels angry and hurt and frustrated by all of that. The cause of that is what the jury is going to have to decide. Is the judge going to say we've come to the close of evidence, ladies and gentlemen? Did she just close her
Your
laptop?
next witness?
Your Honor, the counterclaimant Amber Heard rests.
All right, thank you, ma'am. All right, ladies and gentlemen, you have heard all the evidence you're going to hear in this matter.
Yes, you-
What I propose doing is to go ahead and give you the rest of the afternoon off so you can have a
Thanks,
good
Judge A.
restful afternoon and evening, and we will do closing arguments tomorrow morning at 9 a.m., and then the case will be submitted to you for deliberations. Just to give you a little logistics of how that will go, tomorrow, I won't give you a time limit as far as how long you can deliberate in the afternoon into the evening. I will tell you, within reason, I will tell you I do not serve dinner, so keep that in mind, okay? You will not be deliberating on Saturday or Sunday
Or Monday?
because Monday is a holiday. I would like you to have you back here Tuesday morning, at least by 9 o'clock. If you want to come earlier, that's up to you. You can decide as a group if you want to come earlier than 9 o'clock, but you have to be here at least by 9 o'clock to resume your deliberations again. And again on Tuesday night, and if you have to go to Wednesday or Thursday, that the time that when you take your breaks is up to you, as long as you take them together, as far as not having any deliberations unless all of the jurors are in the
Everyone
room
must
at
be
the same
present.
time. When you take your lunch is up to you. And then again in the evening, within reason, I'll let you go as long as you'd like to go, okay? So have a good evening, and we'll see you tomorrow morning, okay? Do not discuss the case with anybody, don't do any outside research.
Wow. And with that, we are at the end. All that's left is closing arguments, jury instructions, and for this to go to the jury. The court's going to likely do some legally court shit. So let's talk about that. The court's going to ask about jury instructions. I want to know if they are done yet, and then I'm going to answer questions. We are done.
We'll go ahead and take a modified lunch recess just till 12:50. We'll come back at 12:50. We just have a few jury instructions left we have to do. Make sure we get the verdict form taken care of. I want you to review the laptop that we have mocked up and make sure everybody agrees what's on it. And also I want you to look through all your
The evidence
exhibits
laptop.
and make sure we're all on the same page. Before you leave, I'll make sure you have copies of the jury instructions in the order that I'm going to read them, and you should be able to prepare for your closing arguments for tomorrow, okay? All right, we'll see you at 12:50 then.
So that will likely not be televised. They've not televised these types of court proceedings before, though the gallery and the public are allowed to be in there. They do not televise those parts of Law in Motion, which is the only thing I'm frustrated about not being there in court for, because I would love to hear that happening in court. Of course, when they do it up at the sidebar, you don't hear it. Wow. All right, we're going to get to questions. Tomorrow morning at 9 a.m., we are going to start with closing argument. I will be interested to see tomorrow what jury instructions are coming in. The court will read the jury instructions out loud. So you will see from the court all of the jury instructions. She will either do that before the attorneys argue or after. So we could start off right at 9 a.m. with reading in the jury instructions or with argument. I hope that she does the jury instructions first. I think it gives you a powerful leg to do your closing on. And I also think it gives the attorneys the weight to say this instruction, that instruction you've heard the judge say, and then Closing is fresh in the jury's mind when they go back to deliberate. Only 2 hours each side, so 4 hours total tomorrow of closing. That might be split up by the lunch break, depending on when jury instructions are read. But then this case will go to the jury, and the court said you can deliberate as long as you like until it's time to break for dinner. So if they want to go to 7 o'clock tomorrow, they can. Will we be on verdict watch tomorrow? Yes, we will. Do I have like a storm watch? I need like a storm watch logo, verdict watch. But they then have a 3-day holiday. Will I be flabbergasted if this jury reaches a verdict tomorrow? Could that happen? Yep. And if that happens, we will see all of it together in Virginia. The verdict forms will include the damages portion. So they will get to decide liability if somebody defamed somebody, and then they will get to decide how much. And we will see on closing how much they ask for. Each side should be asking for their damages and asking for what they want. I don't think we're going to hear Heard's team argue with a straight face $100 million. I don't think that's going to happen. I wonder if Depp's team will ask for, you know, his damages are $7 million that she took in the divorce and didn't donate. Or if they're going to say what he's looking for is his name cleared, liability, give him $1, we don't even care. And that will be very, very interesting to see. So with the 211,000 of you in here, I will just remind you, if you want to stay in the loop with what I am doing, and if you want me to alert you when I go live, if there is not a verdict tomorrow, I will go live for Verdict Watch and when we have word that a verdict will be read. Join the text crew. North America, don't have to pay. Like Phil DeFranco's, textemily.com from your mobile device will get you there. If you are not in North America where your cell phone might not allow you to be part of the text crew, just follow me on social. I will be sharing on my Instagram stories and on Twitter, whichever platform you prefer, at the Emily D. Baker, when it is time to go live. And if you like and subscribe to this channel, sometimes sometimes YouTube chooses to notify you. Sometimes it's a mystery. So we will see. I'm glad we still have a court feed right now. That's absolutely fantastic. So, wow. I'm going to get to questions. I'm going to see if we have anyone else who can join us. It depends if they are outside of the presence of the jury and being mindful about what happened in court today. I really want to know what happened with the audience. And so we're going to see if we can bring somebody in who was in court today. All right, let me close this out and get to a few questions. She said she wrote the op-ed because she knew people would run to defend him because he's powerful. I thought it wasn't about him. She said in her cross-examination with Camille last time that the op-ed was about him and others, but yes, she seemed to say more clearly, this is why I wrote the op-ed, because of my experience with him. I think we've already gotten to the fact that this op-ed is probably about Johnny Depp. I think after the ACLU testimony that, you know, the shit's out of the horse on that one. There's no pulling it back. What is going to matter is if she thought it was false when she wrote the op-ed. It's all going to come down, for me, for willfulness on the defamation. And I said I would bring up that jury instruction, so I'm going to get that ready. If we get Runkle in here, then we will put a pause on that and talk about court. I'm going to try to get to a few questions. Thank you for the super chats. I am trying to get to as many of them as I can. If you put a question mark or a Q at the front, I can know it's a question and make sure to answer it. Johnny Depp has the right to defend himself as well against defamation. Where is the evidence, the triggers she brings? But thank you for your education. You're welcome. We will see what the jury thinks. They are the finder of fact. They get to decide what's true. And hopefully, I really hope this jury doesn't hang. Man, the way I will be bummed. I really hope they come to a final decision and that this has some aspect of being like done, some finality to it. I think for the sake of the internet. For me personally, I need closure. But no, these parties have been locked at horns with this for 6 years. They also deserve closure. And we have RunkleOfTheBailey from court live. So let's add him in. Runkle.
Hey.
Welcome, friend. Introduce yourself to the chat. There's only 200,000 people here, so just be calm.
Okay. So it's just not many people then.
You and me and a few friends.
So yeah, I'm Ian Runkle. I've got a channel, RunkleOfTheBailey. I'm trying to find headphones to cut that echo.
Yet.
So I'm here at the courthouse, and I've been watching the proceedings, and holy crap, I just witnessed a murder.
Runkle, before we get into cross-examination, what happened in the gallery that caused an admonishment? Did somebody say something? Did you hear something?
I actually stepped out. I was trying to make a Twitter comment because I thought that was going to take a little bit of time. But everybody, so the gallery was not being good about keeping their mouth shut. And I think that the admonishment was just sort of general chatter, but I'm not certain.
Okay. All right.
But yeah, I did hear the admonishment. She was telling everybody that if they didn't pipe down, she was going to clear the gallery, which I would not have liked.
Judge A had very strong "don't make me pull this car around" vibes in that moment. And it was, children, this is a multi-million-dollar civil litigation. We all need to act like it. We all came to court today with our court behavior on, and that's the vibe I got from Judge A. So it's very, very interesting hearing that admonition. I was really, really surprised by it. So talk to me about how that testimony and cross felt in the courtroom, because I held my breath for at least 3 minutes of that cross-examination. I don't know how, but I went, I gasped in and then I stopped breathing because it was just, what do you think vis-a-vis Johnny Depp's cross-examination, which was pretty spicy yesterday?
Well, honestly, I figured she was done before the cross even started. And the reason why is because she and the jurors had something in common, which is that neither of them were shedding any tears. And, you know, when she's talking about this emotional, like, I've lost everything, and the jury's just kind of staring at her like,
that's not a good sign.
I was just like, she is done. Like, she can't get that emotion going on this. I mean, it's kind of no wonder she's having problems getting cast, but it's also, if the jury was remotely with her, I would have expected them to sort of have some more interest on that. And the jury started out very attentive when she was, when she went up for direct. But pretty soon I started seeing juror A rolls his eyes, juror E gave some side eye, juror B moved on to playing with his pen, juror C sighs, and I was, sleeping. So I'm like, this is not a great set of signs. But then it was okay.
Signs. And again, for all of you that are new here, because I know there are so many of you here, I've been a licensed attorney for 17 years. I'm a former litigator, over 10 years of doing court work as a prosecutor. Runkle is a defense attorney, so you've done jury work. So this is not just us guessing at what juries do. I mean, it is, but it's also based on experience. Those are educated guesses based on the things we've witnessed in our own cases. So when you're like, this is a bad sign, normally you see people have some empathy for those on the stands that they like and listen. I've seen jurors cry in court during heart-wrenching testimony in criminal cases. Even when they're trying not to, you can see tears rolling down with nothing else on their face, because when they feel it, they feel it. And yesterday, the chat got still. Like when Johnny Depp was testifying, everything got kind of still, and people were like, I felt that. When Amber Heard was testifying, people were like, I'm not feeling this, until the very end when she talked about her career. That is where I felt that she was like, the harassment online, that is where I felt genuine and true emotion from her.
Yeah, and when they finished and were passing it over for cross-examination, I watched jurors kind of waking up and sort of getting that we're interested in what's about to happen next kind of thing, which is also not good, because I mean, these are very serious, very shocking, very sympathetic allegations. If you are on board with this, what I would normally expect to see is first, jurors being moved by emotion when she's doing her direct, but also jurors tend to identify, with people they feel sympathetic to. So I would expect what you often see is defense counsel getting up to cross-examine somebody who's making those kinds of allegations. And usually you see jurors just like hate staring them.
Yep,
Like
they get
just, we hate you before you've even opened your mouth. And that was not what I was seeing. I was seeing them getting up and sort of leaning forward in their chair. Juror I, who's mostly been checked out, wakes up. He's ready to listen. And I'm going, oh.
For Amber Heard's case, because when the jury, because yes, that's been my experience too. When you have a victim that the jury's looking at, the defense attorney gets up to cross and has to be very mindful because the jury already hates you for cross-examining someone that they feel a great deal of empathy towards. But if the jury's looking at Camille going, go get her, girl, then you've got a big problem if you are Team Heard. Even if the elements of defamation have always been in Team Heard's favor, but if they lose it on the facts, the jury has room to find defamation, particularly with that tweet, which you and I agree on. I thought it was very interesting that Rottenborn asked about every type of abuse and did not
accept that
sexual abuse. And that very interesting.
I was like, wow, that is a hell of an omission.
I thought he would take the end of the list because it's so heavy. And I was shocked that he did not include it. That was not a mistake. That was a choice.
Yep. And I think that their argument at the end of things is probably going to be, listen, you can find that she's been abused and you should find that she did not republish this tweet, like that she did not republish the headline. I think they're going to lean heavily into that in the cross. It's going to be a technical argument, but it might be a winner. If the jury agrees that that is the way the law should be interpreted, and maybe if they get a jury instruction that's favorable in that regard, I mean, they could still have a scenario where nobody walks away with any money. Yes. I don't see a scenario based on the jurors' reactions today. I will be stunned if Amber walks away with $1 in her favor. Just stunned. But I mean, I've been wrong before on verdicts, and it may happen again, but I don't see her walking away with even a shiny $1 awarded to her. At this point, I think they're playing for zero. And
very interesting split, because we've got law squarely on Amber Heard's side. Facts have pushed Depp's side.
Yep. I mean, Depp walked in and had a 0% chance when he walked in, was my assessment. It was like, he's running this thing. I've looked at the law on this. He's going to lose. Like, just straight up, he's going to lose. And then the facts started coming out, and I went, this is actually a thing, right? There's going to be an actual issue on this. So, and now I'm leaning quite heavily to, I think I think he's substantially more likely than not to walk away with money. And we may see in closing an argument for give Depp $1. And I think that might be a powerful position, because ultimately, you can tell the jury it's not about the money. We want the $1 just so that the world knows that, that Johnny Depp, is a victim.
Tell the world, ladies and gentlemen of the jury, tell the world that Johnny Depp, a man, is a victim of domestic violence.
Yeah. And they can just ride that audio clip because it's so powerful. But I think even if they put the $1 pitch to the jury might go might hear $1 and think 7 million. I kind of stick to that number just because it's got that sort of poetry to it that the jury might latch onto. And like, this is a big deal for them. I had notes. Most of the jurors were doing that ping pong thing during the cross-examination. Oh, boy. They look to counsel, they look to the answer, they look to counsel, and that means you've got them. That is where you want the jury to be when you're doing a cross-examination. You want them doing that.
Like tennis. It should look like tennis. Did on cross-examination, I lost my question. Go ahead, Runkle. I'm sorry. I completely lost my question. This is why I take notes, because ADHD. This is what you get when you get the two ADHD lawyer kids of YouTube together.
I really like let's give you that context line that Camille had. I was like, that is smooth and that is crushing.
What did you think of side-by-side photos?
I was just like, how does she think anybody's buying these answers? the answers were so bad. She was so combative and weaselly. She was denying her own testimony, and she was doing that repeatedly. The side-by-side photos of, like, you said these are 2 different days.
How did her
Come on.
How did her attorneys allow her to walk into that position, admitting those with such staggeringly different evidence numbers so much later in testimony to be admitted as the same thing? And then Amber Heard was trying to get cheeky with the metadata, saying, well, uncover the metadata and then we can see. The jury can see those are the same fucking photo.
I mean, they were just obviously the same photo.
Yep.
And there was a point where juror A actually started to tune out a bit. And I think during the cross-examination, and I don't read that as he was losing, interest in the cross-examination so much as just a stop, she's already dead.
We're done. We get it. Can we be done now? I really liked her demeanor on cross, though. I thought she held her own on cross.
Amber?
Yep.
I think she got slaughtered on that cross.
Obviously, she
had so many moments where she was so combative and so refusing to accept the most obvious things put to her.
Obviously.
The gallery was gasping repeatedly. And of course, the jury is going to hear that. The other thing I will note is that on redirect, I think it's Rottenborn. I'm terrible with names.
It is Rottenborn, and I liked the change from Elaine to Rottenborn. Elaine has done all of Amber Heard's other testimony. I thought it was a better dynamic. I thought Rottenborn should have been the attorney doing her direct this entire case. It was a much better dynamic. I didn't like that they called each other by their first names. It felt weird, but I liked the dynamic better.
But when he said, there's nothing about any evidence, or you would agree that none of this evidence is fake, the judge looked like she was going to come over the table and smack him. She was like giving him an angry glare. And there's a reason for that, which is that counsel have some ethical obligations.
Yep.
And my read on that judge's reaction, and she's been very, very good about her, like her face has typically either been neutral or smiling. She hasn't adopted a lot of angry expressions. That she had an angry expression on, and I think she was like, my read on that was like, how dare you in my courtroom? How dare you? And I was just going, whoo. And afterwards, she's like, right as soon as that was finished, she's like, I'll talk to counsel now at my, I went, okay, I would love to hear this. Of course, white noise machine, you can't hear anything, but I was wondering if that was a discussion about, are you sure that was a question you wanted to ask?
And
are you real sure?
This is not a line of argument you're going down tomorrow in closing, because that contradicts the evidence. But we also get, in closing, you can get objections. So you can get that moment where either Ben Chu or Camille is like, objection, misstates the evidence, misstates the testimony if they go down that road, and they're going to have to do it.
Yeah, the thing is they were not doing well with their forensic, their forensic evidence. And I thought Hughes kind of ended up being a no points draw. Hughes didn't look good. She came off as whiny, but they didn't really land that really telling, punch on Hughes, the knockout punch on Hughes. Hughes came back and sort of was, whatever you had decided about the Hughes versus Curry, you're going to walk out with the same thing at the end of that. But
Curry responded in there because her testimony felt like I was being lectured by a teacher I hated. And that was across the screen. I don't know what the jury felt, but how did they respond to Hughes? Because she was like, as I said, as I told you. I'm like, are you per my last emailing the jury right now? What is happening?
Juror H was shaking her head at several points. That's the older woman there. So the jurors were interested, but I don't think that anybody was super persuaded. The metadata expert I thought was even more interesting, because they get him to that point where he's sort of going, well, yes, these are two images that the metadata says were taken at exactly the same time, at exactly the same place, with the same file name. And, it sort of comes down to, well, I'm an expert. You should believe me, notwithstanding this complete ridiculous position I'm taking. I think they just, like, the jurors sort of going,
I thought it was really powerful that that was redacted earlier, and then was like the reveal that they unredacted it during this witness, close in time to the jury going back to deliberate. And I thought that that was really interesting. It was like, ta-da, they're the same photo, which we kind of knew because you did a video on this with photos.
And the question I would have loved to have had that metadata for that video, because holy crap.
Runkle's video, obviously.
The one question I wish they'd asked, just as a follow-up there, is, they have the same file name. Isn't it the case that the phone takes photos with sequential file names? They increment the number each time. Isn't that a thing?
Yeah.
So wouldn't this indicate that that had not been another photograph taken, but in fact the same photograph? I think that would have been good, but I am nitpicking here because that was an excellent cross. And as much as you can say, hey, I could have put one more layer of polish on it, I'm sort of saying, hey, the brass could have been a little bit shinier. And yeah, I can't come in and say, hey, that was a mistake. I can just say, I think it would have been one more, a good question to ask.
They leaned into time. They leaned into time down to the second. And I think I wonder if they didn't know what this expert would answer if they asked that question. And on cross, you really don't want to ask a question you don't know the answer to. So it might just have been Dennison leaning into this, a lay person can understand, and this cannot bite me. This expert can't try to have another explanation because time, minute, second is just what it is.
And any explanation he can come up with is going to sound dumb. That's the great place that you want to be on these things. It's just, oh, sure, you have an explanation. It just makes you look even dumber that you're trying to explain this fact away. I thought, like, when I heard that they were going to call Amber, I was like, this is a desperation play because she did not play well the first time. She did not hold up to cross well the first time. And, there is no reason to give Camille another round of, hands tied behind your back boxing is really what that felt like, is that Amber Heard had nothing, and I'm just like, why would you give her another shot unless you feel that you are super in desperation mode? Now, the other possibility is I think Amber Heard has been running the show a lot behind the scenes, and Amber might have been, so this might have been a desperation play, or it might have been Amber saying, well, Johnny Depp testified again, I'm going to do the same thing. And she should have gone, Johnny Depp testified again, and it was a mistake. And maybe I don't want to make the same mistake. And I mean, I think Depp did okay on that, but it was a mistake for him to get up on the stand. I think that they lost some on that. Now, whatever gains that the Heard team made on Depp were erased today. Nobody's going to remember.
That's the red.
Nobody's going to remember anything, anything that they got on Depp. It's such a parallel. Like day one to day. There we go. It's such a striking, the contrast between them. It's night and day. Depp, there's places where maybe he's too argumentative, or, he's not really answering the question he's asked. Amber Heard, you just can't find a place where she's actually trying to answer the question in a way that seems honest. Everything is so combative, so refusing to accept even the most simple propositions that are put to her. It's
photos of her and Rocky Pennington. The photos where it looks like she's not wearing mascara, eyeliner, or any makeup, and she's like, I'm obviously wearing makeup. It's like, are these the same photo? Because you're saying I'm obviously wearing makeup, and I'm looking at a woman who is blessed with beautiful skin and looks good with no makeup on. What did you think of that? you tell from where you were sitting in the gallery on the screens?
On the screens, it's a little tough, at least from where I'm sitting, because I've either got to stare at a screen that's across the room, or I'm sort of craning up because I've sort of positioned myself for best view of the jury.
Yeah.
The jury actually has screens right in front of them. So yeah, yeah. So that is kind of its own thing.
What did you think Camille walking off while Amber Heard was still talking? She closed her binder and went, I have nothing further. And Amber Heard is still answering her question. She just walked off.
I think that Amber Heard's like insistence on over editorializing was not playing well. And I thought that was a bit of a power move. Like, she's really dunking on that behavior. I gotta say, like, I am such a fan of Camille's. It is just, she absolutely has better things to do at this point with her career, but she could teach an entire class on cross-examination, and it would be the class, that everyone is fighting to get into. And, the people with first priority on registration would be still not getting into that class and feeling really upset about it. It's so crystalline that it's just hard to even find, it's hard to make any notes on it. It's hard to say, like, this is something I would have done or would have liked to have seen. It's just phenomenal. And the other thing is just how, even when they're trying to break her stride on cross-examination, because there's a lot of people who do really good crosses, but an objection will just throw them aside, and they have like 5-10 minutes of trying to get that stride back again.
Yeah.
It's one of the reasons why judges will go off if your cell phone rings during the other side's cross. It's like, you can't break the other side's flow like that. It's really important. They couldn't shake her. They couldn't break her flow at all. And they tried. They tried with sidebars. They tried with everything. And, she just has the inevitability of a giant rock rolling down a hill. Wow. And, trying to interrupt that feels like walking out and just trying to stop that rock by putting your hand out. They're just not going to be able to do it.
Yeah. She right up. And that is not just well prepared, but that is a skill to be able to think on your feet like that she is unshakable. Yep. You might take a breath or two to just reset and ask the next question, but she does not take much time and was not shakable. And again, in cross, the important part is the questions, and Camille's questions were fantastic. She asks great questions, and the answers at the end, Camille said, these answers don't matter, so much so that I'm closing my binder and walking off. I felt like Amber Heard wanted to take the power of the closing argument out of her lawyer's hands and look and argue to the jury. And Camille said she's arguing to the jury. That's exactly what it felt like.
Yeah, and I think they're going to have a real hard time crafting a close that can fix any of that. Like, they're going to listen to the close and they're going to remember Amber from the day before. It's so damaging. It's so bad. I mean, my comment on Twitter was basically just, I just witnessed a murder.
Right.
It was such a brutally effective thing. And I don't know how I think it's going to be hard for them tonight when they're sitting there going.
I'm just going to leave up the court feed. They're trying to show Johnny Depp leaving court, so I'm just going to leave that up so we can chat as that's not what I meant to do. Chat as that happens. So keep going. We're now a sidebar of lawyers apparently. So
I think you're actually going to also see a lot of the courtroom's going to be pretty empty, because just about everybody's there to see Johnny, and now that he's gone, you're going to see a lot of people have gone home. I'm going to be there because I
you-
want to nerd out about the jury instructions.
Yes, because I don't know if that's going to be televised. If it's televised, I will come back and do it. But the last time they've been arguing motions in court, that has not been streamed. The parties, it seems like the parties are leaving. So the attorneys are going to stay in court and argue, and the parties are gone. I'm glad you'll be there reporting. So at least we get some clarity, because we did have some confusion coming out the last time that they talked about jury instructions with the wording of tweets from Chanley Painter. So I'm really glad you'll be in there to keep us updated. Are you going to stream on your channel after the close of court today to break down what happened for jury instructions?
Absolutely. Assuming that I can hear anything, because they might just turn on the white noise machine and be like, you can sit here if you want, but we're just going to blast white noise at you for the next 2 hours.
And I hope
in which case, yeah, I'll probably still be a massive nerd and sit there and just try to gauge what's going on. But it might be that there's just no point in me staying there any longer. But I'm really curious about the jury instructions, because there's a whole lot of battles. And, chat, if you've never sort of dealt with this, a lot of court cases are won and lost on jury instructions, because if you can get a good jury instruction, that's, if you remember during Rittenhouse, we had this whole big discussion about which jury instructions they got, because it's a big deal. And, so I want to see some of that, because I'm expecting a jury instruction about, say, solicitor-client privilege.
Mhm.
And, that's a big deal.
And she was trying to craft an instruction to not allow the jury to draw a negative inference, meaning that we think that Team Heard is trying to argue, look, everyone's protecting this powerful man. We heard Amber Heard alluding to that argument on the stand. Everyone's trying to protect him, but they can't lean into that on Waldman not answering questions because of privilege, because it's improper to argue it, and the jury can't draw negative inference, meaning they can't hold it against Depp. And Ben Chu is asking to craft a specific instruction. And so we'll see if we get it. The instructions are the manual for the jury to decide this case. It's their playbook. It's their rule book. It's all they have to go on most of the time. And depending on what you get, it's important. We also know there's the outstanding issue of that motion for sanctions regarding turning over digital evidence in violation of the court order or not. And that is likely being argued on jury instructions too. What else do you think they're still arguing over?
I'm just trying to think. The jury, I think that the sanctions issue is going to be a huge one, because there's been a lot of arguments about metadata and faked images and all of that. And with the jury, if they get an instruction saying, listen, you guys need to know that the Depp's team did not get all the metadata because it was required to be turned over by Heard's team, and they refused or failed to do so. Oh man, that's like right after it's
catastrophic.
That's a knife in the heart.
Yeah, it would be done. It would be absolutely instruction can be devastating, but that jury instruction is supposed to be devastating to incentivize attorneys to not pull fuckery in discovery. That's the point. That jury instruction is, it really is the stick of saying, you can do this, because a lot of attorneys are like, well, if you find me, you find me. If I still win, whatever. It can cost their case having an instruction like that, telling the jury, this side did this and it hurt the other side, is devastating.
And I mean, we may see Ben Chu in there citing the case of fuck around v find out. And
Runkle! I'm feeling that immediately. Fuck around, be find out. We need to
I've actually been planning on putting that on shirts for a while, because it comes up so often.
We can do a Canadian case site for it. I can fashion a US case site for it. We can do a format, or it's going to be fantastic. Oh my God. We need a case site for fuck around, v find out. Runkle, that's yours. It's brilliant. I love that so much.
It's just because I mean, that's really what's coming up, is just like, well, you guys decided to play with fire. Oh no, who could have expected that this could burn down your own house?
And Judge A has been firm. And if you're ignoring Judge A's orders, and what we learned yesterday when we were talking to Rob that I had not realized through this case, she's the site judge. Like, she's the top boss judge at this courthouse. So if you are going to cross her, not only is there a bit of setting an example for the other judges, but there's also a bit of, look, just because I'm not screaming at you doesn't mean you're not wrong. And judges can be very pleasant, so firm.
She's so effective at the pleasant but firm thing. Like I've lots of judges will get snarky or snippy or mean, and I haven't seen that from her. As I said, when I saw her glaring at Rottenborn there, that was the most like angry I've ever seen her. Usually she's just like, okay, I said sustained. And that's, it's a very polite way of saying, did I fucking stutter? But,
Per my ruling, Elaine.
Yeah, it's very, but it's very effective. Nobody crosses her. Nobody, she's got an iron grip on that courthouse or in that courtroom. I am just so impressed with her work.
Really great to watch.
It's
been great to watch her in this trial for this long. It's been really, really nice to see.
Yeah, I mean, the one thing I'm really sad about is that I don't practice here and won't ever, run a case in front of her, because she just seems, even losing in front, she seems really amazing in terms of the control she's got, the way she handles things, the fairness. Like this, she's a model for judges. And I gotta say, I've been really impressed with, this is a millions of dollars in legal fees and court costs. Like, I don't know what it's cost the courthouse to run this, but you got to figure they've got extra bailiffs on every day.
How much money?
They've got, this is basically all sides, including the court, have basically been shoveling money into a pile and throwing matches at it.
I had a judge that was like Judge Wyndham, who was the judge presiding over the Durst trial. And I've got to tell you, there was something so fun about watching one of my favorite judges presiding over a case that was then televised and getting to see him in court. I was like, go Judge Wyndham. It was so fun. And I'm sure there are attorneys that practice in front of Judge A that feel absolutely the same way. It's just like, yes.
And Rob practices in front of Judge A and says she is amazing. Like he can confirm that. But with the amount of money spent on this, I haven't walked away saying I think any side got ripped off. And I know there's a lot of criticism out there of Elaine. There are some things she does not do well, but I still think she's a good lawyer, and I still think she's, probably worth the price tag she charges, which is not a small price tag.
I'm going to disagree. Team Heard got robbed by Dr. Spiegel. That was a robbery.
Yes.
Dr. Spiegel robbed Team Heard. Other than
the expert witnesses, a lot of expert witnesses filled a bag of cash and walked away. I'm talking about counsel. I'm talking about the court.
Fair.
But if we're talking about expert witnesses, there were some definite expert. The stats guy. I pulled this stuff on the API and then I ran it through an Excel spreadsheet. Whatever they paid that guy, get a refund. Yeah, like that guy, literally what he did was just look at some data and run the most primitive search on it.
I don't blame him though. I put that failure all on Team Heard. I think that's crap in, crap out. I think they gave him a task. You and I disagreed on this yesterday, and I love that we disagreed, because this is the best part of lawyering, is when you disagree with someone you really like and you get to realize that way. Because you said he shouldn't have taken the assignment then. If he's like, this assignment is crap, he shouldn't have taken the money and walked with it. And I said, the team has to do a task. And he's like, if that's what you want me to do, I'll try it. It seems like they've worked together before.
But like these professional experts, their credibility hinges on this. And sometimes I think that it's one of the obligations of an expert to say, listen, you've asked me to draw a conclusion based on doing things that are not within my expertise and that are not, like, the conclusion you want me to draw is not an appropriate conclusion based on the data you want me to analyze.
Which is fair.
So I refuse. And I've had situations where I'm trying to hire an expert and the expert says, listen, I can't give you anything useful. Go away. I would love to take your money, but there's nothing useful I can, give you. So I'm not. And I think that's 150% the right thing. Like, that's an expert that I'm like, I will call you again. If that's an expert who's telling me, don't hire me because I am not an expert in this, I will figure out what they are an expert in and make sure to hire them for that. Because at that point, I know that this is somebody who, when they get up on the stand and they start facing these questions about you did a biased analysis, is going to be somebody who can punch back at that and say, no, I've got principles. I did this carefully. I love an expert like that. But I should let you go here. Court is just about to get back in session. So I'm going to try to jog in there. I will, I'll be streaming later to talk about sort of some of these impressions, what, if anything, we learn about jury instructions. And she's gotten into my head.
All right.
And
Again, Runkle of the Bailey on YouTube and on Twitter. I will give you shout outs. We will link you down in the description. Go back to court, because if they don't televise it, we need to know. If they do televise it, we're just staying here right now. So thank you, Runkle, for joining us. Go back to court. Thank you so much. All right. And that was Runkle. I'm going to see if court starts televising this. If they do, we're just going to stay on. And if they don't, we'll switch streams. Normally I switch to an afternoon stream. I don't know how much time we're going to have. So we're just going to stay here and see. What happens. If they start televising, we are going to stay here and go through jury instructions and what it means and what it is. If they just put on the white noise and go up to the bench, we're just going to see what happens. So, why not? We're just going to see what happens. Who needs lunch? Chat, thank you so much. I will have to message Dr. B. You see me looking up. My window is over here, and we're getting some stormy season through here. So thank you guys on the road to 550. Very, very much appreciate you. I would have normally split to the afternoon stream, but again, I don't know what the afternoon will hold in this case. And you've heard Runkle's opinion and mine. We are going to have some differences of opinion about whose fault it is with the experts. And did they ask him for a crap task? Though he is like, well, then the expert should have not taken the money. And I'm like, that is a very fair point. However, I also understand that people are going to take money. I am going to keep the court feed up and see if they resume. And I promised I would pull up that jury instruction. But first, I'm going to go to the super chats and try to get through some of them right now. Let's just keep the court feed. Oh, I'm pleasantly surprised. I was not expecting this, and I'm fucking thrilled.
Let's go ahead and start with jury instructions since they're almost all done.
Yes.
That would be helpful.
Yes.
Okay. I already have them in a potential order, but let's go ahead and go through them. Oh, one thing I'll do for the record
They
first.
should be going by number.
Plaintiff's 287, which is the same as defendant's 780T, is a corrupted file that we received from both of you. I guess it's corrupted on both of them. And nobody seems to be able to do anything about it.
Right.
So I think it might just be that it's in evidence. However, it's not going to go back to the jury because it's corrupted. Okay, does everybody agree to that?
Yes, Your Honor. Thank you. It's
Okay.
just an Eastern Columbia building video, so that's fine.
That's just, it's corrupt. Okay, do you have more exhibits to give?
Your mic,
Good.
Elaine.
Look at Jamie here.
Your mic. I love watching the judge work and watching how she does her work.
All right.
This is the nuts and bolts of lawyering.
All right, so these.
Different than the fun court stuff.
Jamie, to make sure.
This is the heart of it.
All right, it's defendants 393,
I'm going to see if there's a feed with a split screen.
821, 857, 857A, 883, 1859, 1905. Make sure that's nothing. It's the second page of that. 1050.
And if I lose you guys, we have a storm coming through. So I'm going to put this in real quick.
It seems to be a longer one. Hold on.
All right. And I just wanted to peek in on the gallery and see how many people we had
And
in the
I think
gallery.
that
I
is
find all
it,
this
correct?
distracting. So
All right, are you missing any other exhibits?
Runkle's back in the
Your
gallery.
Honor, I may approach.
Yes,
We
you have some? Okay.
today.
Let's
Yes.
go ahead and get those.
They're asking to approach because you don't just walk up through the well onto the bench. It's not an approach, have a conversation or a sidebar. They're just asking to approach to hand.
All right,
the
so
court
these were the
things, which is appropriate.
2 through, these, all right, so we have, okay, I think I I think this one's theirs. All right, so I have plaintiff's exhibit 1316 and 1317. Yeah. I still need 1301. 1301, does anybody have 1301? Plaintiff's 1301?
Was an Instagram post?
An Instagram post.
Judge's face.
We'll get it, Your Honor.
And then that 711A and 711B from today.
711A and 711B, the one without the metadata, and one with the metadata showing. It was the same pictures, but it showed the metadata.
I believe
It
that
was
was
the big
712A
reveal.
and 712 and 713A.
Yes,
I don't have those.
we just don't have them, 712 and 713A.
Understood. Okay.
Can I get them now? Trying to get all the exhibits together right now, so we have them all together so we can review them.
We're trying to get a stack. So they're trying to put together the thousands of exhibits that they have to make sure that not a single number is missing. So when it goes to the jury
Is
will
it
get a
David?
list of exhibits and what it is
So 120D
And then
was
the jury's
listed as,
going
you
to
had it
get
as an
a
evidence, but we
computer
do not have it in
that has
evidence.
all of the digital evidence on it. And then they're going to get a stack of photos and other evidence to go
All
through
right.
with a
Is that
list
all the
of
pieces of
the
evidence? Excellent.
I love the way she said excellent.
Good, okay, so we are very
Excellent.
close to getting all of that. I don't want to leave here until we have every piece of evidence with Jamie and everybody has reviewed it. so
No
we
one
don't
is
have to
leaving
do that
until I get my
tomorrow
evidence.
and
Kids.
waste time with that. Okay.
And I'm going to try to make that.
All right, so
that's
now I
making
think
me
we
too
can do
big.
jury instructions, correct?
Yes, yes, yes.
All right. Let me just go over the ones that we had a few issues with.
Yes. This is the interesting stuff because this is the stuff that
At the
matters.
first one I'm going to go over is the self-defense. There's two,
Interesting.
that would be number 28 and 29, correct? And I took those under advisement. Do you still have an objection to the self-defense? All right. So what evidence do we have in trial that would allow to have these two jury instructions?
A self-defense instruction
Sure,
in a
Your Honor.
defamation
So I
case.
think there's evidence in the record showing that, Mr. Waldman was Mr. Depp's agent, that, he was retained in connection with the UK litigation and with this litigation.
Who was that?
There's evidence that he engaged with third parties in that capacity, that he met with the Daily Mail with Mr. Depp, and that he believed Mr. Depp's version of events. And so I think all of that, is relevant evidence to a self-defense, that Mr. Waldman made those statements in self-defense on behalf of Mr. Depp,
All right. So you're saying if agency is found.
if agency is found.
We believe they're inappropriate, Your Honor. First of all, we have not been able to locate case law, but
We
I
found
would-
one
not
from
be any.
1887.
That might have been,
1887.
and I know I had seen one a
We said
while
it was a
back.
reversible error if you didn't give the self-defense one, so.
Well,
Reversible error means
I know
it's bad.
I'd taken a look at one a while back. I think, but I don't have a case site for you. I think it's a question of law as to whether it applies. So at a minimum, I think we should figure that
Question
out,
of
I
law,
guess.
not
But the
a-
reason we don't think it should apply
Question of law means the judge
is
decides not
these
the
were
jury.
statements that were made by Mr. Waldman in 2020. I guess it was before Ms. Heard's counterclaim. So if he's saying that
Oh.
It
he's
goes to the op-ed, I
The
think.
statements are
understood.
defensive
So if he's
with
saying
regard to
that
the op-ed.
it's this
Interesting.
lawsuit was a statement in response to the op-ed. Statements that were made a year and a half later by Mr. Waldman, and it doesn't, I mean, again, Your Honor, the key words are fairly and reasonably. So obviously both sides are going to argue defamatory implication and what did the op-ed really mean, and did it say these things? But saying, even under their theory, 2 years ago I became a public figure representing domestic abuse, to say that then it's fair for Mr. Waldman a year and a half later to make public statements that Amber and her friends roughed up the place and spilled a little wine, all the things that he said in those statements, that's not fairly and reasonably. Ms. Heard responded fairly and reasonably to Mr. Depp's case through her counterclaim. The parties can speak to each other in the
Is
courtroom here,
Waldman's
but
statement
saying that if someone makes a
a
statement
fair and reasonable
in an op-ed,
response
that then you can go and launch,
to
do whatever you
Heard's
want
statement.
for 2 years, say whatever you want. And
Ron Horn
obviously,
argues
there's
the
only
law
three
well.
statements that comprise the counterclaim. But as the evidence has shown, it was part of a pattern by Mr. Waldman. It was, it's the opposite of proportionate. It's the opposite of fair and reasonable response.
Okay.
Mr. Depp's opportunity for a fair and reasonable response, well, we don't believe it was either, but
Rottenborn
had the
argues
opportunity
the
to
law
file a
well.
lawsuit in this court.
Where was this
To
Rottenborn on
have Mr. Waldman be
cross-examination?
his attack dog and to say anything Mr. Waldman then says as his attack dog is somehow fair and reasonable and entitled to the privilege is inappropriate. And I do think that before Your Honor gives it, we need to confirm whether it's a question of law.
Okay.
Okay.
Your Honor, Mr. Rottenborn noted that this lawsuit was a response to the op-ed, but I think there could be multiple statements in response to the op-ed. So I think that's not dispositive of anything. And the statements were clearly a direct response to Ms. Heard's allegations on their face. And whether that response was fair and reasonable is a jury question.
I don't, what do you say is the matter of law? The privilege of self-defense is a matter of law?
I think it could be whether it applies.
Okay,
As a matter of law means the judge
I don't think it's
decides,
a
not
matter
the
of law. I
jury.
think it's whether or not
So
there
tonight
is
on
any
that.
evidence that a jury could find it being protected speech, not the weight of the evidence, but if there is any evidence. And I don't think it's my role
Decide.
to
Yep.
weigh that evidence as far as
It's the
how
jury's
long
role.
it was made afterwards.
I think it is, Your Honor. I mean, it can't be the case
She
that
just said
anytime there's an alleged this is why this doesn't come up often, because this just isn't given. If it were appropriate
Her
here,
face.
every time there's a defamation case, this would be an instruction. Even the person who's the
This is a
defendant in the
unique
case would
case.
say, well, all I said, I was responding to something that was said before.
So all your evidence that you say goes to the jury are just the statements? That's why this should be given?
Oh, danger.
That he made the
danger,
statements, that's the only evidence?
Danger,
Well,
danger.
I think
You gave me evidence of agency, but that's just agency. Do you have any evidence that of self-defense, that he actually said these statements because of what she said?
Well, I think there's
Danger.
circumstantial evidence, at least, that so it's agency. He's an attorney who was retained in connection with this litigation and the UK litigation.
That doesn't automatically give you self-defense, though, a privilege of self-defense.
Because they're still arguing he wasn't acting as Depp's agent.
That's-
So now
that's-
they
You have to
argue
make
both
them,
sides.
I have to have some evidence that the statements were made in response to the direct accusations
isn't.
of Ms. Heard. And just some evidence,
On their face, they appear to be a direct response.
not the statements themselves, but is there any other evidence?
No, because their evidence is
The statements
denying
fairly arose in
that he made the
response
statements.
to Ms. Heard's accusation.
Double-edged sword. This is a
Did
double-edged
anybody
sword.
testify that he made these statements in response to her op-ed?
Judge A.
No.
There isn't. There isn't.
Not that I'm aware of, Your Honor.
Because there isn't.
All right.
Because it goes against
Your
your
Honor,
theory.
just one small point there. There's no requirement that it be in response to the op-ed in
She just told you
particular.
there
The
was.
question for self-defense to apply is simply whether it's made in response to an allegation against Mr. Depp. And Mr. Walden's evidence is clear, I think, that he was responding to allegations against Mr. Depp, and he believed those allegations to be false. There was extensive evidence in the record on that, in fact, I think.
That he was responding to. So if it's not the op-ed, then we're really in murky ground. If he says, well, I was responding to what she said in 2016, that's.
Well,
Judge A.
what
Rottenborn.
Mr. Munez is saying is that you take it as a separate case. You take it as a separate case, their
They
claim
are
and then your
arguing
counterclaim. So your counterclaim is a
Jury
separate
instructions.
standalone case.
And Judge A is asking
Oh,
great questions.
So the standalone case doesn't, your claim doesn't deal with the op-ed. So they're saying in defense of your case,
When she's looking over here, she's
That's why
talking to
this comes
Heard's
in.
table and Rottenborn. When she's
But
looking over here, she's
he
talking
couldn't
to
have made
Depp's
it. He
table.
couldn't have made the statements in defense of our case because these are the basis for our case. So what he had to have been, what was he responding to if it wasn't the op-ed? And if it's not the op-ed, then we're really in murky ground because there's no, plus
He's
Your
right.
Honor, a couple points.
He's right.
To your point, there's been no testimony that he made these in self-defense to anything. Two, the defense doesn't apply. And this is, this is under the Haycock's case, 1958. It doesn't apply if we prove malice. So it has to be made in good faith and without malice. So it's coextensive. I could bring the case up if you want. Your Honor.
Jury instructions
So if
matter
the malice
so
inquiry
much
incorporates this.
because
This
it's
is
how
the,
the jury decides this case.
let's see, 200 Virginia 212.
Team Depp is
Haycox versus
asking
Wilcox
for an
Dunn.
instruction
Um,
that it's not
and it looks
defamatory
like
if it's made in
on
response.
page 8,
Team Heard is
sorry,
trying to keep it out.
231, they're discussing a
I think Team
Massachusetts
Heard might be
case.
right.
And
So
that
this
says,
is talking about defamation, not self-defense.
statements
and
made in an honest endeavor to vindicate one's
physical
character or
assault
to
of
protect
crimes.
one's interests are usually regarded as qualifiedly privileged, even though they are false, if they are made in good faith and without malice. So the malice inquiry takes care
I think
of
Rotten
this.
Born should win this.
And in addition, I don't think I need to remind the court, but for the record,
And if he was responding to the
Mr.
son,
Waldman was
they
not
don't
allowed to answer any questions about
get-
this. So to say, well, he could have been making it in defense of something, they could have let him answer questions and get that evidence on the record. They can't say, well, he could have been making it in defense of something now.
And when I say, just looking at your case, you're claiming these alleged defamation.
I'm going to keep trying
the three
to
we have
explain these
allegations
while we're talking.
Well, they're saying in response that they made them because of something she said that maybe is not the op-ed.
Then there's no evidence of what that is. She responds, she
But
was
could the
sued.
jury
She said
reasonably
she said
find?
2016 when she made her,
Mhm.
then 2018, she has the op-ed that have, a couple words that they're trying to turn into what we've just seen for the last 6 weeks. And then she responded to the lawsuit.
OMG,
So
Rotten Born.
it can't be the case that by trying to defend yourself in a lawsuit that was brought against you, if it's not the op-ed, then it's got to be her statements in the lawsuit. That somehow trying to defend yourself through judicially immune
Or it's the
statements in a
UK.
lawsuit entitles someone else to go out and
Chat,
say
y'all
whatever
are
they
already on
want
top of it.
and then try to veil
You're on
themselves
top
in
of it.
privilege.
It was the UK.
Counsel for Ms. Heard made a point of making clear that there was extensive allegations about Mr. Depp circulating. They repeatedly brought up the UK action, which was in fact the context in which I believe these statements were made based on the date. It was very close in time to the UK action.
Well, the
They
chat got
brought
there
up the
faster
Dan
than y'all
Wooten
did.
article. These allegations date back to 2016. These allegations are out there, and there's there's evidence, from which the jury could find that Mr. Waldman was acting in defense of Mr. Depp.
Chat,
We
y'all
were
got there
acting
so
in
fast.
defense against Ms. Heard's accusations. So what are Ms. Heard's accusations that would be defense?
Correct, because
that are
in the
evidence?
UK trial, they weren't heard.
Your Honor, there's been extensive evidence of the accusations
Son's
against Mr.
accusations.
Depp going back to 2016. For example, the Dan Wooten article that they raised in evidence prior to the op-ed,
Court sketch
which
artist.
included
Love.
the word wife beater, and was essentially,
But it has to be.
That's not Ms. Heard's
Ms.
statements.
Heard's statements. Right.
I don't believe that's correct, Your Honor. It doesn't have to be.
Against Ms. Heard's accusations. It
Ben
is.
Chu is
It is
trying to get in there.
correct.
That would be crazy, Your Honor, if
Ben
they
should
get a
keep saying
jury
People
instruction
Magazine.
because he was responding.
I understand that.
I mean, again, the number of allegations made by Ms. Heard, it's been very well documented in this case. You have the op-ed, and it doesn't have to be just, it doesn't have to be any one particular allegation. You have the
To have
op-ed,
a team
you
to
have
argue
People
jury
Magazine article,
instructions.
you have the republication of her statements through the wife beater and the Dan Wooten article. You have the fact that she was giving testimony in the UK action about these
Okay.
issues.
Well,
I'm
then would
riveted.
you agree that actual malice, you don't get the self-defense if there's actual malice in his statements? If the jury finds actual malice, then you don't get,
If the jury finds actual malice,
then it's not
that
protected
may
speech.
obviate the privilege, but that doesn't mean that the privilege is not applicable or a valid.
But the
jury
only way they
instruction.
can find in this case is if there is actual malice. This goes back to their defense, slap defense as well. The only way they find defamatory statements in this case is if there's actual malice. And it's unique to
Judge
this
just cuts the
case, I
heart of it.
understand that. But so if they find actual malice and defamatory statements, you
done.
don't have protected speech privilege.
And if there's no actual malice, they win.
Yes,
So-
correct. The same with
Correct.
this, that's why we're not
Correct.
Correct.
giving a jury instruction on the slap defense
Oh,
because there's no basis
That's
for
new
it.
news. Then that should be out. Then that should be out. I agree with you, Judge.
I mean, if the instruction is not being
Slaps
given
out
on
too.
the understanding that it's essentially moot,
Yes.
Which I agree.
Which
I
it
think
is.
was what happened with the slap defense as well. We found out after we went down that legal road, we found out that was moot as well.
Oh, interesting.
Okay.
So
So
it's
you
moot.
want me to
So that's
deny
not
it or
coming in.
withdraw it? I'll do either one.
if you don't mind denying, Your Honor.
Okay, that's fine. I'll deny.
All right. So what
That's
just happened is they were
Instruction
fighting for an
28
instruction,
and 29.
an instruction that they can't get to because there's actual malice in this
Nice.
case. They're also not getting the anti-slap or the
All
slap.
right, next one I have is the
defense.
republication
That's interesting.
one.
All right, let's get to the republication instruction. I will try to explain. There's a lot happening.
Okay,
They're arguing jury instructions.
so I see both of them dueling paragraphs
speak
for
to
the
this, Your Honor.
This is the
republication.
republication. Okay.
Yes, sir. And I understand last time we spoke
This is
that you
critical
added, you must
instruction.
determine whether any content that was added constitutes a republication. And you just would rather have just the 3 sentences as yours for republication. Is that correct?
Correct, Your Honor.
That didn't,
No,
well,
I
you
think
must
it's the
find
flip.
that she read, or you want to add that into it? I'm not sure. I'm just not sure how I'm reading it.
I think.
She's
I
asking if
think,
it's
and
either
I don't mean to
or,
put words in their mouth. I think
or
we
all
want the
told.
whole thing at the top,
Right?
And they want either or?
and they just want the 1 sentence at the bottom.
So either
Okay,
or.
that's correct.
And Your Honor, we talk about not going backwards. We went
No,
over
I
this on
understand.
Friday. Your Honor said that on page 92 of the transcript, I don't have a problem with the republished jury instruction. I just think it has to be accurate with adding the language. And
Right.
that language was on page 89. You said, but you also have to say, but adding content to it may establish republication. So that's what we did in the sentence that starts with merely linking.
Right.
It did say merely linking to an article does not amount to republication, period. And then we added
Republication is
directly from
Depp's
the transcript, but
strongest
adding
argument
content to it
on
may
defamation.
establish republication.
So this instruction
now
is really
now they're going
critical.
backwards. They just want you to strike the whole thing except the first sentence. And that's different from Your Honor's ruling on Friday and also doesn't fully capture.
No, it
the
doesn't
republication
capture the whole
doctrine.
legal argument.
And
doctrine.
if I may just make our argument for the record here,
I
Your
think
Honor.
what you did on Friday, but if you want to do it again, that's fine.
Okay, just very quickly. So I
Her
think the
face says
issue with
it's not fine.
republication is whether it reaches
Her
a new
face said,
audience,
"Not
which
fine, not
is
fine, not fine."
what we
And that's there.
what we propose. Well, it's included in their instruction, and that is basically the full extent of our
Yes, I
proposed
do.
instruction, and we believe it should be limited to that. Lakova is a case that they've repeatedly cited
No,
in
they're just
support of
arguing
this
instructions.
republication issue, and that's a case where
Which is real fun.
there was a defamatory New York Times article that was hyperlinked in a more recent New York Times article, and the court said that that's not directed at a new audience. It's the same party tweeting to the same audience, so there's no republication. And
I will get to
that's
this
not
when
the
they stop
case
talking.
here, where Ms. Hurd has retweeted a Washington Post article. So that, Ms. Hurd's audience on Twitter is different than the Washington Post. And so
But if she just retweeted a hyperlink, that's different. But in this context, and that's why I took the motion strike under advisement, once I
Because
got
she
it, there
added
was more
content.
content to it. And that's why I'm putting it in the jury instruction, because it is accurate that a hyperlink alone is not enough to reach a new audience. But I'm willing to, what I think would also add
This
to it
is a
though
big
is
deal.
after you must determine whether any content that was added constitutes republication. And
Yes, it's she
let's see, I would say
she
then
quote tweeted it technically.
you must determine whether any added content republished the op-ed to a new audience. I could say it that way. Or I could say, but adding content to a linked article may constitute republication. You must determine whether any added content was intended to reach a new audience. If you find it was intended to reach a new audience, it constitutes a
Ron
republication.
Born is arguing the
I could
law
say it
well
in that term.
here.
Add that to
I
the
think.
end of that paragraph.
I think that's fine if
Do you have
that's
any-
the court's inclination.
Do you have any objection to that?
I'm thinking, sorry, I'm
processing,
slow
Your
here.
Honor.
One more time.
Yeah,
Sure, okay. Let's see.
I wanna hear the
Let me see if I
language of
can
this.
Incorporate into it. Okay, so merely linking to an article does not amount to republication, but adding content to a linked article may constitute republication. You must determine whether any added content was intended to reach a new audience. If you find it was intended to reach a new audience, it constitutes a republication.
That's a good instruction for Depp. That's a good instruction for
I think
Depp.
we would prefer just to say, just
I bet
that
you
first
would.
sentence, merely linking to an article does not amount to
Yeah, I
republication.
bet you
but
would.
adding content to a linked article may
No.
establish republication,
No.
period.
Well, that's what you already had. This
No, because we had you must determine whether any added content that was added constitutes a republication. I think it'd be better to just delete the last
no,
two
no, no.
sentences than to add the sentence at the end.
Your Honor, I just want to note, I don't think that adding content is a requirement for republication. I mean, we've found a number of cases that when somebody repeats a defamatory statement, that they're as
Dude,
liable
that's
as
a
the
good
original
instruction for you.
defamer.
We're not
And,
going back. We're not going backwards.
Don't go backwards.
So
The judge
either
already
it's his
ruled.
language or my language. What do you want?
I prefer the court's language.
All right, then you're going to put my course line. Okay.
Your
Do you want
language,
us to do the
his
revisions?
language.
Because if you do it, we may have to just get one more time from you.
Okay.
We're happy to, or
Sammy, can you do it? You gave him to
We did.
Word format?
we did.
All right, can you do that?
So
The
Sammy's
only
gonna
other
edit.
thing I would note is I think the word retransmitted in the second line is misspelled. So
In the second line? Okay.
Okay,
We'll take
Rottenborn.
care of that.
So what is going on is they are arguing jury instructions. Jury instructions are what the jury is told about the law to decide the case. What you tell the jury the law is what allows them to find liability or not liability. It is a very big
We'll
deal.
get that done.
And this is them really
All right, takes care of that one.
negotiating
Next
the jury
one
instructions, and that is a critical
is, I
element.
think, instruction
Republication.
FF. Defamatory meaning, consider the publication as a
Ooh.
whole. And we had Julian answers here. And the defendant just has op-ed in
Big
it.
deal.
The plaintiff just has it as plain, which
It should be
I mean,
plain because there's a
it does say
counterclaim.
that it means you may not seize any word, phrase, or image. So it would appear that, so it could apply to both of them in that context.
The problem, Your Honor, is that we believe that because the counterclaim statements that the jury will be presented with are redacted, so the statements are in isolation, that there's a risk that as they're phrasing it, the jury may read the phrase, "You must read the statements in context as a whole," to say, well, we can't do that, so therefore there's no liability.
That's a fair.
We think
That's a
because
fair
it's-
concern.
It's impossible to read those statements
The
in the
counterclaim
context of the whole
statements.
piece.
Because the counterclaim
And so-
statements are largely redacted.
So that's number one. Number two,
I
the
don't think
op-ed
that's-
was all Amber's statements. So the whole
I
thing
understand
was
that.
her words. The counterclaim statements were Mr. Waldman's quotes
It's a
in
fair
another
concern.
article that we don't believe, well, that's not in evidence. So there's no point arguing about that other than you just have these one or two sentences from Mr. Waldman. So we believe that the jury's going to be confused if we give their instruction and say, we cannot read it as a whole, so therefore we can't, follow the jury instruction.
Okay. I can see your point.
I see your
with that.
point too.
Yes, sir.
I don't think there's anything in there's a lot of instructions here. I don't think there's anything that would indicate they can't find the liability if they're not able to take statements in their
I think
proper
Rottenborn's
context.
right on that.
In the context of the entire article.
No, I think Rottenborn's right
Just
on that.
thought it would be more appropriately phrased to be mutual, as opposed
Judge
to
A is
obviously
a boss.
applying only to one party.
Well, because yours says you must read the statements, which is true, but you also can take the content in the context as a whole, but you can take the context of the op-ed as a whole.
The
which is
jury
accurate.
instructions should be neutral. They
What I
shouldn't
could do,
signal
if you
who
want,
should
I could
win.
keep the op-ed up top for their claim, and then for your claim, we can, in determining whether any of the statements attributed to Mr. Waldman are false and defamatory, you must read the statements. I could keep that in there as a second paragraph. That
That's
way
fair.
they can just pull out, because it's accurate law also, that they just can't pull out the word hoax and say, okay, this whole statement.
Agreed.
That's fair.
Okay.
That's fine. Thank
Is
you.
that okay?
That's a fair resolution.
That's fine in concept. I guess I would ask if Your Honor does that to add a clause saying disregarding any redactions on.
Well, it says the
evidence or
statements
something.
themselves, statements, and there's, you must read the statements in context as a whole.
Right. So, but I think, could we say in determining whether any of Mr. Waldman's statements or whatever are false and defamatory, you must read the
Dr. B is
text
bringing in
of those
provisions
statements as a whole.
Since I haven't moved.
Text of those statements in context as a whole or something.
Well, that's kind of, you must read the statement in
You must-
context as a whole. I
You
think
must read,
that's-
can we say you must read those
She sure
statements?
said that's
in
why I wrote the
context
You
as a
op-ed.
must
whole?
read those
Because I just don't
statements
want
in
them to
context.
think that it's impossible for them to.
Any problem with just putting those instead of the?
I don't think we have a problem with that,
Okay,
Your Honor.
in determining whether any of the statements attributed to Mr. Waldman are false and defamatory, you must read those statements in context as a whole. This means you may not seize on any one word, phrase, or image, or consider only one
Fair.
particular statement, phrase, or passage in isolation. Does that
Fair,
sound
fair,
correct?
fair.
All right, we'll add that as a second paragraph. Keep Sammy.
Because it's a different circumstance to the different statements. And so it's fair to say that the different statements are treated differently. The Waldman statements are largely redacted.
All right, the next one I have.
The op-ed is not, and that is very, very fair.
is the objections and assertions of privilege.
Ooh, I wanted to see this one.
Which- 32.
Oh, I'm sorry, it's Depp 32.
They're not arguing semantics. They are arguing how to instruct the jury on the law, and it is very
new
much
instruction.
important. So semantics kind of
yeah,
feels
right,
like it's
right.
Yeah,
small
you have to-
This is
differences
the new one.
without
Do you have
meaning.
an objection?
We do.
These are differences with huge
The
different
objection, Your Honor,
implications.
is that the objections made by counsel during the course of trial.
Yeah, jury's not in the
we
room.
have
This
no
is the
problem with
very
something
important
on
part
that.
of legal.
But instructions, what they're trying to do is to direct the jury what inference to draw from Mr. Waldman's
You're
instructions not
trying
to
to
answer.
do that,
Well,
Ron
well, the only legal inference they can draw, they can't draw any inferences from that.
Correct.
Exactly, and that's my point. Is
Well,
that
that's
trying
what
to
this
argue
says.
it.
You may not draw any inferences from the fact that objection was made.
That's
Yeah,
fair.
but saying sometimes attorneys stated objections during the course of this trial and instructed a witness
Right.
and instructed a witness not to answer a question.
Not right on
Objections and
this one, Ron
instructions to
Born.
witnesses are not evidence, and you may not consider them in reaching your verdict,
Yes.
nor are you to draw any. So
It's an accurate statement of the law.
why do they need to be told this? I mean, I think this is
Because you've
risks
been
confusing
arguing
the
it,
jury.
bruh.
Well, because to be fair, the depositions, you wanted to keep in all those objections, when we usually would take them out, but you wanted to keep them in.
'Cause you
So I
wanted
want
a
to make
negative
sure the jury
inference.
doesn't have any improper inferences from leaving those objections in. You wanted to leave them in because show that, hey, I asked the questions, they
Yes.
weren't answered, fine.
That.
But you can't infer from that, oh, well, they're hiding something then, or it's attorney-client.
That.
Understood. I mean, just like you can't infer when someone takes the fifth in a criminal case. I get that.
Right, which
but-
I would give an instruction for.
Of course, I know, I understand
there
that,
would
but
be
I
an
think
instruction
I
for.
think that the
Elaine has already
jury
started arguing at Rottenborn. You're going
is
to lose on
entitled
this
to
one.
draw their own conclusions.
They
and
can't.
Not inferences. They're not entitled to infer anything from that,
legally
but I just think
can't.
that this risks confusing the jury and
No.
getting
You
the
want to
jury
argue it.
to think
No,
if they stand up in closing and say
Nope.
they haven't presented any evidence
they haven't.
that Mr. Waldman was doing this, then that's using this instruction as a sword. If they get up there and say they haven't,
And
you
if
understand what I'm
you
saying?
get up
They
there and
haven't
say
proven
they're
that
protecting
Mr. Waldman
him,
was acting as his
you're
attorney.
using
They
it
haven't
as a
proven
shield.
that Mr. Waldman was authorized to make the statements. Then they rely on this to hide behind that. And we're not allowed, and I'm not saying that we will, but I'm not going to say, you heard him instruct him not to answer, and you should infer that he was acting as his agent. I know I'm not going to say that, but if they're going to argue in
you,
closing,
Peter.
the converse of that.
They get to
then
argue that.
That's prejudicial, and makes this
All
inappropriate.
right, yes, sir, Mr.
They get
Rogers.
to argue
This is
that.
just an accurate statement of law.
It
They
is.
chose to play about 30 minutes of Mr. Waldman being
Thank you,
instructed
Peter.
not to answer. Without this instruction, that's prejudicial.
Agreed.
All right.
And it would also be
Accurate.
prejudicial if they're allowed in closing to say that we haven't presented evidence of anything about the parameters of Mr. Waldman and Depp's relationship. That's
That doesn't follow from this instruction.
does.
This instruction is simply saying that the jury is not to draw any inferences from the objections and instructions inserted by counsel. They can consider the evidence. They can consider whether evidence was presented or not. The instructions and objections are irrelevant to that question.
no.
All right, I understand your objections, but it is an accurate phrasing of the law. And I want to make sure that the inferences aren't taken against an attorney-client.
Yes.
Okay,
That's a good instruction. That's a fair
Can you deny
instruction.
over our objection.
You got it.
Um,
I mean,
and-
no, I can grant it over your objection.
It is
sorry.
being granted over
Freudian
there.
slip.
I meant grants. Yes, sorry.
Yes.
Can we get some direction for the arguments that they're allowed to make on closing on that, Your Honor? Because I don't
No.
think that's appropriate for them to
Oh,
point
no,
to a
don't
lack
try
of
to limit their
evidence when they didn't
closing.
allow Mr. Waldman to testify.
You chose to play it.
Pointing out that instructions are not evidence is not to say, there's no connection here between these issues, Your Honor.
No, I'm not going to do that. So we're going to do Depp 32.
Yep.
I just need to clean up the top part of it.
So they are arguing over the privilege instruction.
right.
And
Over
Depp's team
objection.
got a good instruction over the objection of Team Heard about the Waldman
All right,
deposition
then I have instruction
based on their own
JJ,
actions.
which is the
next.
model.
Right.
So why would I not give the model?
I don't know.
We believe you should. I think
Well,
I
got
think
that.
the only, looks like the
Model
only
jury
substantial
instruction.
difference is that they, rather than saying, as it's written, it says clear and convincing evidence
Oh.
that Mr. Waldman's statements, it's confusing and misleading to say that if you have found by clear and convincing evidence that Mr. Waldman's statements were made by Mr. Depp, we already have a principal agent instruction.
Right, if they find principal or agent, I mean, that would be the only basis for it.
Well, first of all, Your Honor, if liability is entirely vicarious, which I think is the position of the counterclaim plaintiff in this case. I don't think there's any evidence of direct liability. If liability is entirely vicarious, then I don't think there's a basis for a punitive damages instruction at all against Mr. Depp, because vicarious liability generally doesn't result in punitive damages as to the principal. Punitive damages are only applied where the person against which punitive damages are being assessed actually engaged in conduct.
So now we're
that was
arguing about
wrongful.
damages
And
instructions,
that's
which is
not
really
the way
interesting.
they've pled and sought to prove their case. I think that's the first.
So
point.
they're saying you're not entitled to a punitive damages instruction.
Well, I disagree with that, and there's no case law that they've cited in here on that, and I think that's going backwards. That's an argument that we've already, and I just think that Mr. Waldman's statements were made by Mr. Depp. I mean, I'd be okay with something
If they
that said
believe on
that
agency,
Mr.
if they
Waldman,
believe
while
agency.
acting as an agent for Mr.
Yes.
Depp, made statements with knowledge. I'd be okay
If you
with that.
find,
Is that okay?
if you
I
find,
think we would maintain our objection on that. On the basis previously asserted, Your Honor, and then what's the other? I'm sorry, could I have counsel's language again one more time?
Sure.
Yeah, if you have found by clear and convincing evidence that Mr. Waldman, comma, while acting as an agent for Mr. Depp, comma, made the statements with knowledge that they were false or so recklessly.
That's
I think
the
it's
malice.
So reckless.
Yeah, so reckless.
There's a typo there, sorry.
Let him finish.
Yeah, I mean, we do maintain the same objection, Your Honor, the principal liability, and we do have case law for that
I'll
proposition.
overrule that objection. We'll go ahead and, can you type that up real quick for me?
Sure.
And get that to me? If you email it to Sammy, we can print it
That's
out.
fair.
Yep.
Okay, you're in charge of that one. Okay. All right. That's fine. I think that was it, correct, as far as?
I think it was, other than. the
Yes.
form.
Perfect. Let's go to the verdict.
Verdict forms, and then we'll probably be done.
I'm typing it out.
If you can print those out.
Yeah.
All right, let me get the verdict. All right, I think with the verdict form, it was just the first page.
The verdict form is
Am I
what the
correct
jury
with that?
gets to decide. When they go to the end of this,
In the
it's
punitive
like when you flip
damages.
to the last page of a
And
book, it's like,
well,
what's the
punitive damage,
point?
You didn't have a response, right?
The
Didn't you
verdict
have-
form is the point.
I think there was just there was a comment in what we got from them that we changed.
Okay.
Today should be over
All right,
pretty
well, in
shortly.
the-
Verdict form's the last thing they needed to do.
Here.
So these are only, this is not all the jury instructions. These are only
All
the
right,
jury instructions they were fighting on.
I think it was in 1A, the statement was about Mr. Depp. I think the plaintiff wanted that out because we already have, the statement has a defamatory implication about Mr. Depp, and the defamatory implication was designed and intended by Ms. Hurd, which I think is,
If you look at the, I think it should track the finding instruction.
The jurors can't use their notes for
Which
defamation.
is
They
jury
absolutely can.
instruction C on
Okay.
page 4 of the
Ben
jury
Hughes
instructions.
relaxed 'cause he
and
trusts
that's
his
what the verdict
team.
form does.
okay.
They've really worked well together, just so
And
well
that
together.
was C, okay,
Yep.
okay.
Just, they
So
worked
the
so
way
well
it's been
together.
written tracks the
All
finding
right,
instruction.
tracks the finding instruction.
Yeah, we don't have a
Okay.
strong objection here, Your Honor.
Okay.
I thought it was
Verdict
maybe
form
cumulative, but
Is what the
It
jury
doesn't match the
writes on
finding
when they
instruction,
find
which should be
liability or not
clear
liability.
to
The verdict
jury.
form
So
matters a
We'll
lot.
keep that in.
that's fine.
And then the punitive,
And so
So
that
on
would
the
carry
last-
through to all of the.
oh, you withdrew all those?
We'll withdraw that, Your Honor. Their proposed language is fine.
All right, so the verdict forms as written are the verdict forms good to go, correct?
Well. are you-
What?
I'm sorry, did they withdraw the punitive?
They did, they
damages?
just did it.
So we're good with the verdict forms. What I have is the verdict forms, correct?
Okay.
Your Honor, I think yes, but I do just want to make sure, and
Yes,
I understand we
yes,
don't
but-
go back, but I just want to make sure that, for the record, we do maintain that the verdict form should state that the defamatory implication was false and not that the statement was false, because under the Pendleton case, that can, a facially true statement can still have a false defamatory implication.
And I think we had that on the record on Friday, but thanks for putting it again, it's fine. All right, so verdict forms are good. So we'll keep the verdict forms. Did you print out
Okay,
the other
verdict forms are good. And now they're going to go to the laptop.
No, you can print it out. That's how, yeah.
Okay.
So which ones are we missing then? We're missing which jury instructions? You're working on 2 of them, right?
32. I have 32 in FF.
32 and FF. And you have 1 jury instruction for me, right?
Yes,
All
they're
right.
editing it right now. It's JJ.
Okay, JJ is coming in. And did you do the other one yet or no? Here, I got that one. Here, could you guys do, Michelle, or could you, on Depp 32, could you take off disputed and send that to us too?
Yes.
Thank you.
So not
That would
disputed
just leave
anymore.
us- We'll get those 2 printed out, and then I'll tell you the order that I'm going to do them.
We don't
While I'm
know what
doing
happens with
that,
sanctions.
I do have the,
We don't know. They haven't read all the jury instructions, just the
laptop.
ones at issue. That might have already been ruled
I'd
on.
like to look at the jury evidence on these. They're gonna, they'll stay up here at the bench, but all we did was we put 2 files on here. There's no password for it. As soon as you open up, it doesn't have any internet, and there's just 2 files. One's plaintiff, one's defendant. They just click on those 2, and then they can watch all the audio and the video.
That's awesome.
Okay? So if you want to take a look and make sure, it's been downloaded to everything that we
That's
put
very
on
cool.
our website, which is all the evidence. We didn't receive any new evidence today for audio or video files, so that it's everything on there. But if you want to take a look and make sure that everything is there, you can do that. Also, all the tangible exhibits Jamie will have, except we need to get those other ones. So oh, you have them? Perfect.
Yes, if I may approach, I have
Okay, sure.
1301.
Okay.
Okay, so now they're dealing with exhibits, and I will just say,
And then,
for all of you that are here,
Your Honor,
period,
I
North
just
America,
would like some clarification.
Sure.
the text crew is available to you.
I understand that exhibit,
So is our membership community.
defendants exhibit 712 and defendants
I will be
exhibit
breaking this down more.
713 were initially moved into evidence in redacted format.
Correct.
Today,
So now they're going
we
over exhibits.
offered them and put them in an unredacted form, so that's the
712A and 7.
So you
and
just
then
want to
713A.
You just want to remove
I
the
believe Your Honor should already have those in unredacted form. I believe that's how they were provided to you all
Oh, they're in our
by.
binders down here?
I believe so. I will. Yes, so I believe those, you should actually have those in unredacted form
right.
from defendants.
Okay.
We have a few binders down here.
Yes, I think they would be in the binders. That's correct.
712 and 713. All right, we'll take a look at those. Yes.
So I can give you a copy. I was gonna make a proffer for the ones that.
Do you want to go ahead and make a proffer now?
Yeah.
Yeah.
Including 712 and 713.
How about your mic, big guy?
Copies of that.
Oh, you can? Well, that would make Jamie happy since she's down here.
Just
digging through
provide it to
binders.
her.
Right. So I can give you copies of that right now.
Okay, perfect. All right, now we have those in evidence. Okay, so are we
The
missing any
proffers,
more
again,
over here?
are
Or did you
for
find out
the
about the one
record
that you thought was in
only.
evidence?
So, Your Honor, defendant, I believe, excuse me, it's plaintiff's exhibit 120D. I believe actually Sammy and I had a number of back and forths about this exhibit. I believe
All
that
cases have jury
defendant's counsel
instructions.
provided a redacted version of that exhibit
All of them.
to the court, but
how the jury
based
decides.
off of our reading of the transcript, that exhibit was not actually offered into evidence.
Okay,
So they're going over
it's
the
not in
exhibits.
evidence then.
Not in evidence, Your Honor. I thought, and I believe
Do you not have a mic, my guy?
last week,
You gotta take disputed off.
We're just going to talk over you if you don't have. I'm just going to make up things that you're saying at this point. Because I cannot hear you.
so we can go back to the jury.
Okay, all right, so I just want to make sure, because it was checked off on somebody's list that it was in evidence, and I just want to make sure. I don't know, but it's not. We're good.
And
We're
then I heard the exhibits 711A and B. I'm not sure.
No, I think
Is that
711 was
an
wrong.
error?
It was 712 and 713.
Yeah,
So we're
they got
good.
that sorted.
So Jamie, are we missing anything else? Sammy, did you print out the ones that they sent you to? Hmm? The email, did you email Sammy the? He's just double checking right now. Oh, okay. we'll get that in a second. Let me just put these in the order.
And the judge is going through whatever they presented her. They are trying to sort it out.
Get that one without dispute on it. Okay, sure.
Okay. So we are still arguing jury instructions. The judge has it looks like two judicial assistants that work with her. Not surprised. She's the site judge. I don't know if all of the courts here have two judicial assistants. They might be research attorneys as well. So it's possible that they are the attorneys that work with the judge and do the research, because they were talking about pulling up case law for her. So it's very possible that her research attorneys, when I was a research attorney for judges, I was not in the courtroom every day. I didn't have a desk in the courtroom. I had my own office in the courthouse, but I would be in court when needed. And then I would meet with the judge in chambers and stuff like that. But it's very possible that her research attorneys sit there with her. So who are the people in the gallery seats? Well, they're the audience. This looks like a court sketch artist. This is Runkle, a YouTuber,
And
and
then
then
Sammy printed off.
audience.
On republication. I'm just going to give you a copy so make sure.
So they are going over
Okay, right, okay.
instructions.
And you have,
I
should
will
be
ask
receiving
Runkle.
your email soon.
I have no idea who this is.
FFJJ and 32.
Okay.
And those are exhibits.
So we
So
can
they're
put those
just
out too,
cleaning up the exhibit list.
Print
Did
those
they get to
out.
state that punitive damages can be awarded on the counterclaim? That's what it sounded like
So
to
you're
me,
sending
but I
FF?
want to hear these again.
Okay.
Because I was processing and talking and
Did you
answering
take the
an email.
disputed off the top? Thank you.
Question, if you just finished as part of the Johnny Depp team, how would you feel about your chances? Any glaring blunders? I think that Team Depp should be feeling pretty good. I think they moved the needle more than a lot expected them to. The law was not on their side, but the facts are. I'm going to do more of a Q&A, I think, for our members. When we don't, I mean, we've got 171,000 people in here, and I know there's a lot of questions. We do members only streams once a month, but I think we need to add one for the members. Members of this channel and over at Law Nerds Unite, which is also where my members only podcast lives, for I Have Thoughts, where I break down kind of my thinking, my behind the scenes, and sometimes how I feel about stuff if I'm pissed. That is where that lives, because on this channel, it really is my goal to break down what we're seeing happening and give you kind of my take, but I don't deep dive into my take on things. I really want to present it so you can deep dive into your take on things. I try to give you the information so you can form the opinion that's yours. I don't want to tell you what opinion to have. I just want to tell you what's happening. So,
Could you print me out another one?
did
of
Runkle explain what
AA?
happened in the gallery? No,
I
he
just-
said he
there's
was
a mark
out of
on
the
this
gallery.
one.
So they're still going over that.
Or at least email it to.
How is
just
the
email
law
that
not
one
on the
to
side
Sammy.
of Johnny Depp? The law of
Something in the
defamation
paper and just
is
doesn't look
very difficult for public figures, and the statements Amber Heard made are fairly broad. So the law was definitely not on his side going into this. Going into this, I was like, how do you even bring this to trial? How do you win this case? But once we got into the headline and we got into all of the other evidence, I was like, oh, this is why you bring it. And I think the facts are now on his side. I don't think the law is favorable to him. He has an uphill fight on the law, and that's not the truth in every case. Like in the Rittenhouse case, the law was on Rittenhouse's side with regard to self-defense. The facts were very difficult for him, but the law was on his side. In this case, the facts are very difficult for Amber Heard, but the law is not. And so if they can stick to the law and try to get the jury on that side, then they are, or the jury focused on the law, they have a better chance of winning. But it's very interesting. The Rottenborn did not ask about SA today when he asked about all the other types of assault or violence and abuse. Sorry, I meant abuse or violence. And I just think that it's a hard case. I can't wait to see closing. I think that Rottenborn argues the law very well, and I think that we will see him doing that. Here, I'm going to make this a little bigger because I can see the questions better. And he argues the law very well. And I think that we will see that in the beginning of closing tomorrow. What I expect from closing tomorrow is we are going to get Ben Chu closing on regard to the law, and Camille Vasquez closing with regard to the facts and the details. And then I think it's the same on the other side. We'll get Rottenborn closing as to the law, and then we will get Umbridge closing as to the facts, Bredehoft. So that is what we're going to get, I think, tomorrow. And then we will have Depp will close, Heard will close, Depp will rebut, Heard will rebut to the counterclaim. So that is it. I'm going to try to get to a few more questions as I can, and then we're going to get to wrap up a little early today, and it's my kid's first day of summer, and that is kind of welcome. You've been amazing during this entire trial. Thank you. If the jury comes to a decision quickly, would it be a sign for Depp or Heard? With the facts being on Depp's side, if they come to a decision quickly, I think it's either everyone loses or it's a Depp win. That's what I think if they come to a decision quickly. It could be nobody defamed anybody. But I think longer deliberation indicates you've got some people that believe Amber Heard, and that's where you might get into that territory of a hung jury. So we will be on verdict watch tomorrow, and it's going to be very interesting. Since the jury's comprised of mostly men, how will they read into Amber Heard makeup covering statements? I don't know.
A paper printout or an electronic copy from the court?
I think
All I have is a paper.
you will see people saying, I believe what I see.
You can scan
Okay,
it and
that's
do-
fine.
If you want to do
So,
electronic, that's fine.
There's a
And
lot
will
of
these be
photos.
posted on the,
Not until after I get
not till
them.
after, okay, wasn't sure. And
He's
then
asking when
they're
they'll be
read
public.
before closing.
They're read
so-
before close.
Yay! Read before closing's my favorite. So we will, when we resume court tomorrow, we will get jury instructions read in full, and then they will do closing. I was voting for jury instructions first. I'm very deeply invested at this point. This is oddly enthralling. It's great, which is surprising. I would think your running commentary really helps with understanding everything that should inherently be boring. That's awesome. Thank you. Luke, you're welcome. I find this fascinating. This is where you get the little details, and the power is in these details in court, and it matters. Do you think calling Johnny was a play against Amber's personality? It could have been. It could have been trying to force her onto the stand to get that cross in.
You want to take a look at that instruction and make sure.
It could
looks
just
okay
as easily
before I add
be
it to
that
the
both of these
stack.
parties wanted to have their final say. They have waited for this trial, and it could very well be that both parties wanted to have their say. So
Michelle, you said
it
the
could
actual
be.
malice one.
Let's see.
Yes.
Question: if you were on the jury, which side would you be on, Heard or Depp?
Sorry,
The
Jamie.
juries are instructed to wait until closing argument. So I would have questions, but I'd want to
Your
hear
Honor, was
closing
it,
arguments. They will not show the jury at all, and the
No,
jury's
I think
identity
it's
has been
fine.
sealed.
Does the court want to leave the, Heard C, Depp 7
No.
sort of things in
Those
there?
are I
Otherwise,
lost
we
my
can-
question. I want to get to
Oh, no,
this.
well, yeah, the numbers at top can stay. I
Okay.
just want to say disputed.
No, I don't think any of them say disputed.
Okay. No, the numbers, I
No.
tell the jurors to disregard the numbers in the
Okay.
heading.
The jurors fill
That's better
out
for the record if we keep it that way.
the jurors fill out a verdict form, and the verdict form is read into the record.
Okay,
And
so
we will see the verdict forms. I hope that they will be public by
Your Honor,
tomorrow,
can we get-
and we
sorry
can
to-
pull them up
to
and talk
bother,
about them.
Sammy, could we get one more printout of the actual malice instruction?
You didn't bring enough for the
Thank
class,
you.
Rottenborn. Why do you think Sammy has enough for the class,
We don't
buddy?
have actual malice.
So I think that we
Hey,
should
hey,
have
hey.
the verdict forms, and I will share those. I went over the verdict forms in the Maxwell case and in the Duggar case, and you will see them. It gives places for the juries to write it in, almost like a Mad Lib, like a judicial Mad Lib. It's kind of fun. And so if we get those, I will put those up on our Patreon and our member space to have a conversation and answer questions about, and then up on Twitter as well. So that's what I will do. Question: what is your favorite TV attorney lawyer? I don't know. I am having buffering issues.
All right, any objection to the republication?
Sorry. Buffering.
As typed?
No, Your Honor.
Okay. Put that in there as well.
Off the top of my
Is there
head, it would be.
typo?
I don't have one off the top of my head. Sorry. My wife watches you all day, every day, so I know she'll see this. She was diagnosed with ADHD in her 30s and is finally finding answers and struggles in her life. Love you, Tia. You are not alone. Adam,
Okay?
that's very
All
sweet.
right.
Yeah, Ben Chu has a very
Your Honor,
well.
I just have a very quick question regarding closing arguments, if we may.
Good.
Does the court have any objection to us playing very small clips of?
As long as they're in evidence, you can play anything, show any picture.
Well, that's my question. So
Okay.
obviously, depositions were by video, many witnesses, especially from Ms. Heard. Do you have any objection to us playing video depositions, portions
If
of?
it's not in evidence, it doesn't get.
No, of course, just what's in evidence.
There's no video depositions in evidence.
Oh, I see what you mean. Okay.
Oh, they want to
So-
play Heard's depo, but that's not in evidence.
The only thing that can be played to them is what is in evidence.
But their testimony, it's witness testimony.
Well, yeah, but depositions are witness testimony that you have during trial. That doesn't go back to the jury as evidence. And video depositions are the
You
same.
have to read the transcript.
That would give more weight to video depositions than witness
Well, so
testimony.
my question is a follow-up question to that. Obviously, this trial was televised, so there are
You guys nailed it. You
videos
asked
of
about this earlier.
Witnesses testifying.
No,
So-
none of that comes in.
Okay.
No, the four walls of this courtroom is what the jury decides this case in.
Okay.
Period.
And
No
just so
replay.
we don't have a problem tomorrow, also, we can't put in front of the jury written deposition or
That's
trial
correct.
testimony.
That's correct.
Understood.
Only things that are in evidence.
Understood,
But you
Your
can
Honor.
show pictures in evidence, you can show video that's in evidence.
Or audio that's in
Or
evidence?
audio that's in evidence, all of that's fair game.
But
You
no,
just-
no display of written transcripts either.
No written transcripts, just only items in evidence, and.
No, I'm on the same
Let her
page.
finish,
Okay, all right,
Lauren.
just want to make sure.
Thank you, Your Honor,
And
for
you
that
have-
clarification.
And you have 2 hours, right?
Right,
2 hours each, and two people over here and two people over there, is that what's going to happen?
Yes, Your Honor, we're going to split our closing, and then only one of us will do the rebuttal.
Okay.
Okay.
And that has to just be on the rebuttal case, correct?
Right. Right,
Just on the
We have
clock.
that down, right? We've gone
Understood.
through that a few times.
Understood.
Mr. Chu, do you have something
Oh.
on that?
We've gone through that a
Yes, I
few
just
times.
wanted to make sure we were all on
Wait,
the same page.
bro,
So
what?
plaintiff
Wait, what?
goes first,
Correct.
then the defendant,
Does-
counterclaim plaintiff.
Right, they do
Then-
their defense to your claim, and also they do their offense to their claim.
And then plaintiff,
Plaintiff gets to do their defense to their
and they
claim and
respond
rebuttal.
only with respect to the.
Rebuttal.
To the
their
rebuttal.
Rebuttal to their counterclaim
To the counterclaim.
only.
And so it goes 1-2, 1-2.
Yes.
And plaintiff gets 2 hours, they get 2 hours.
Total.
Is it fine if it's not exactly 1 hour
Oh,
for each?
That doesn't
That's
matter
up
to
to
me.
us.
No,
Okay,
as
thank
long as
you,
your
Ron.
time is just 2 hours, it doesn't matter how much.
How you
anybody does.
apportion it.
Thank you, Ron.
Okay?
If you wanted to shorten that to about 15 minutes apiece.
I would want to short it to 2 minutes, but that's not my take. I
We
gave you
got
2
pretty-
hours. I thought that
We
was
got
good.
pretty efficient at the end of this
Well,
case.
it's amazing how that happens, It's kind of like the physics, you make a circle and the people will fill that circle. Well, that's what happens. I made a circle. Okay, so let's go ahead, let me just go ahead and read into the record the order that I'm going to
Sorry,
give the jury
we froze.
instructions. I'll also read into the record the instructions that were
Sorry, y'all.
denied. And I will read the instructions that were withdrawn, just so we have a complete
Sorry, y'all.
record, okay?
They're just
All right.
reading into the
Here we
record the
go. All right,
instructions.
so for the jury instructions, I'll read them in the following order. Number heard I, number 3, number 10, 1, B as in boy, C as in Charlie,
They can't object
D
during
as in
closing. It's bad
Delta,
form. And
E
it
as
should
in
be reserved
Echo,
for only
F,
something that's egregious, really.
G, H,
Sorry about the
12,
buffering. This is why I split the streams.
13,
We're going to be done soon,
Y,
though.
FF, AA, BB, DD, that's David,
Yeah, we've got some
David,
storms
DD,
coming in, too.
TT, CCC,
CCC.
Z as in zebra, T, U, V as in Victor, K, L, 5, 6, 7, 32, 8, 9, 16, I, 30, KK, and JJ. All right, those are the ones that will be read to the jury in that order. Okay. The ones that were denied was instruction 22, 23, 24, CC, NN, both as in Nancy, OO, PP, RR, SS, S as in Sam, SS, 28 and 29 were the ones that were denied. The ones that were withdrawn,
Yep, and we'll see the numbers. They should be,
for the record,
On the
was
court.
instruction A,
there's a lot of instructions.
4,
Not all of them are long. Some of them are just a
11,
few sentences.
14, 15,
This can take about an hour to read
17,
in tomorrow.
19, 21, 25, 26, 27,
Oh, Aaron,
X
thank you.
as an X-ray,
It is fascinating.
31,
It's not always as much fun to
W,
do it.
EE,
Oh,
GG,
these clerks.
QQ,
These clerks have been working
DDD,
nonstop.
Q, 18, J,
This judge's courtroom
M,
seems to run so
N,
smoothly.
O,
It's been a pleasure to
P,
watch, truly.
R, S, H, L, L, U,
You guys have been more than generous. Thank you, though.
W,
More than
W,
generous.
XX, YY, ZZ, AAA, and BBB.
Therapy. My tricks are therapy to curb my emotions because I do. And there's been definitely times I've gotten emotional during this case about parts of things I've been talking about, stuff
I will
that's
get
happened.
you copies now.
But
I'll get you hand copies
therapy.
of the jury instructions I'm going to read in that order, so you'll have copies when you leave here, okay? And I'll give you copies of the verdict form
I should
as
also
well.
say I have boundaries
And you
on
can
the
have those
channel
while you prepare for
to
the
help with
closing
things not
arguments.
catching me sideways.
Other than that, if you could come up to see Jamie
They're
after I
done.
leave the bench, just to make sure you go through the exhibits and everybody okays the exhibits, so we don't have to do that tomorrow. And also if you can have
I'm
a
gonna take
look at
just a
the
few minutes to
laptop
answer
with Sammy, just
questions.
to make sure all your exhibits are there that are going to go back to the jury, okay?
Your Honor, one quick question
Okay.
about closing, make sure
Sure.
we don't have
Okay.
any issues tomorrow.
Oh, there's gonna be
Understand
issues.
the jury only sees evidence
Yes.
that they've seen in the trial. If that evidence is displayed through like a PowerPoint or whatever, are headings allowed? Or do you not want the jury to see any written text or anything other than just evidence?
I mean, I've seen PowerPoints in cases before in med mals where they have their
Headings are allowed.
other items up there, but I think in this particular case, I'd rather just have no
She's
writing.
like,
and
no
just have your
fuckery.
arguments orally.
That's fine. I just wanted to, make
Okay.
sure that there wasn't,
Just try to keep it clean.
or paraphrasing of witnesses or anything like
Okay,
that. It's just,
that sounds fine with everybody. Does anybody?
that's fine with me.
That's a good question, though. Are you going to have a PowerPoint?
Probably with evidence.
Okay.
You know.
Did you want me to have the big screen up as well for the PowerPoint?
I think so. Yeah, I think that would be great.
Thank you,
Okay.
Your Honor. Yes.
Okay,
Thank
good.
you.
We'll do that as well.
So no, the jury only writes on the
starts at
verdict form.
9.
They don't have to
Starts at
explain
9. Closings start at 9.
with jury instructions.
Your Honor, Mr. Nadelhaft has a proffer still on some
Oh,
things.
yes,
Does-
okay.
do you want to do
Bad
that now
side.
before we-
Yes, sure.
This is
As
his
does
side.
Ms.
Everybody
Myers.
wants to hear your preference.
As
don't
does
know
Ms.
about
Myers
bad
at the
side.
end of Mr. Nadelhoff's.
Yeah, okay. All right, they have one too.
So they're doing proffers. Proffers are reading something into a record. Thank you for turning your mic on. So they're reading into the record.
This will be shorter than the other day.
Thank God. They're reading into
Okay,
the record evidence they want to preserve for
This
the
is
record.
for metadata. On May 16th and May 17th,
This will be interesting.
2022,
This
the
didn't come in.
defendant attempted to introduce into evidence photographs from May 21st, 2016 that included metadata on the photographs. Ms. Hurd testified that the metadata was included on the photos by pressing a button on her phone. The metadata demonstrated the pictures were taken on May 21st, 2016, along with the times they were taken. The exhibits were defendant's exhibits 700 through 726 and are exhibits A through AA of the proffer. Tabs N and O of the proffer are now blank as defendants 712 and 713 were admitted with the metadata
Interesting.
on May 26, 2022. Mr. Depp objected to the metadata on the document, stating that the metadata was hearsay and there was no foundation for the hearsay. The court sustained the objection on the ground that the metadata was hearsay and that there was no foundation, and admitted the exhibits but redacted the metadata. And then separately, we have a proffer for Stephen Duders. On May 20th, 2022, Ms. Hurd moved to designate certain portions of the deposition testimony for trial of Stephen Duders, who was Mr. Depp's personal assistant.
Y'all, I'm just going to
Mr.
let you
Duders
know,
testified that
if
he
you
was
make
on
the
the
chat
Boston
political,
flight
you will
and
get
sat in a
heated.
seat facing Ms. Heard
This
and
is a
Mr.
place
Depp.
for
He
conversation
further
about this
testified
case.
that the day after the flight, Mr. Depp told him he wanted to, quote, smooth whatever issue, end quote, existed with Ms. Heard. Mr. Depp asked Mr. Duders to, quote, write a text, end quote, to Ms. Heard and to say, quote, whatever she needs to hear, end quote. Mr. Duders then sent a text message to Ms. Heard about Mr. Depp stating, quote, when I told him he kicked you, he cried, end quote. The testimony is contained in Exhibit A, Mr. Duders' deposition. Ms. Heard moved to admit the text message into evidence, arguing it was not hearsay under Rule
Jury needs to be
2:803,
unanimous.
which
7.
provides for the admission of statements of a party opponent and his agents. Ms. Heard argued Mr. Duders was acting as Mr. Depp's agent when he sent the text, and the text message was therefore not hearsay.
If it
The
can't
text
be
message
verified.
is, Exhibit B to the proffer. Mr. Depp objected to the text message as hearsay, arguing that although Mr. Duders was Mr. Depp's employee, sending text messages to Ms. Heard was not within the scope of the employment. The court denied the motion to admit the text message in testimony, finding that Mr. Duders was not acting as Mr. Depp's agent when he sent the text message. And I have copies to provide.
All right, fine.
This is not the
We can
longest,
add it
biggest
to-
trial in history.
Oh,
OJ
yes.
lasted 6 months.
We have a box for you.
The
All right.
Durst trial lasted,
Add
well,
that.
off and on with COVID, well over a year. So no, not the longest. 6 weeks is long, but definitely not the longest. It is not also, it is not the, it is
right,
not the
we'll
top
make them part of
grossing
the
trial
record.
of all
Thank you,
time.
sir. All right.
Just like
Yes, Ms.
Aquaman
Myers?
or Aquanet is not
Thank you,
the
Your
top
Honor.
grossing movie of all
On May
time.
25th, 2022, plaintiff intended to call Dr. Kim Collins as an expert witness in forensics pathology.
Oh, it got kept
Defendants
out.
objected on the basis that Dr. Collins had not been designated as a defensive witness and was designated only to rebut Dr. Jordan, which was defendant's forensic pathologist who had not been put up at this trial. Dr. Collins intended to testify as to whether Ms. Heard's descriptions of violence and injuries allegedly sustained by Mr. Depp were consistent with the photographic evidence at issue in this trial.
I was wondering what happened with that.
She also, for incidents where there was no
problem.
Photographic evidence, she would have testified as to what injuries she would have expected to see based off of the violence that Ms. Heard testified to. And finally, she would have testified as to her opinion as to the cause or as to Mr. Depp's finger injury and what she observed consistent, which was similar to what Dr. Gilbert testified to today.
All right, thank you. Any other proffers? Okay.
That's
All right.
interesting.
All right, so just don't leave here until you check the laptop and you check all your evidence and make sure we get your checkbox on that. and everybody's happy
TextEmily.com
with it,
from
okay?
your mobile.
Anything else for the court?
The judge is like, thank fucking God.
Really?
No,
You
thank
did
you.
it. You did it. You did it.
Okay.
Get it, Judge
Thank you, Your
A.
Honor.
She's
See you in
like,
the morning.
Ouch.
All right.
And my browser crashed. Hopefully there's still audio because my browser completely crashed. That's fun for me. Oh, thanks all. My browser crashed. That's super fun for me. with 180,000 of you in the chat. Not embarrassing at all. WAP. We are professionals here. I'm going to summarize what we saw, answer a few super chats. Obviously, when we stream for this long, this is why I've been breaking up the streams. Now I'm saying obviously. I'm now stuck in the obviously trap that we've been getting from Hurd's legal team. But when the streams aren't broken, I have been having that issue, just technology on my end. So apologies for that. I'm going to try to get to a few of your questions. I'm just going to go ahead and remind you, while I have all of you here, I will be trying to throw up a members only stream to answer your questions with just, less when we have time to kind of sit down and do it. If closings wrap up early, we might just break into a members stream and then be on verdict watch there. So if you want to join that, lawnerdsunite.com is where the members only podcasts live and everything. So let us get to this. What we learned right before all of my shit crashed was that there was a forensic pathologist who was going to testify to whether or not Hurd's injuries were consistent with the photos. That was evidence I thought would be coming in. It was blocked. The court denied it because it was designated. And this is the legal side of it. This is the strategy side of it. It was blocked because they had designated that witness as a defensive witness against one of Hurd's witnesses. Hurd chose not to call that witness, and then they didn't get to call their witness, but then Hurd's witness came back in, it sounded like, as a rebuttal witness. So there was definitely some 3D chess going on there, because then Hurd looped that witness back to a rebuttal witness where Depp wouldn't have the time to bring their witness. So they were able to offensively block an offense, not offensive like take offense, but offense like sports ball. They were able to block Depp's bringing in that evidence. Now, I think the jury is allowed to rely on common sense here. I think they can argue common sense, but that was a strategic win for Team Hurd by where they moved their witnesses around and were able to block a key witness for Depp, I think. When do the sanctions come up? We will see when the sanctions come up, if it's in the jury instructions tomorrow. Linz is saying that seems shady. It's not, though. That's strategy. And again, this is where Depp's team could have designated that witness otherwise, but it was designated as a defensive witness, and that was a technical block, and that's not wrong. Is there a time that for the jury to give a verdict? No. You heard the court. The court thinks it might be quick, and this is speculation on my part, but this is why I think that. Because the court was telling the jury as they were being dismissed today, if you need, you can take as much time as you need. You can take as much time as you need going into this afternoon or going into tomorrow afternoon, evening. We don't serve dinner. You can take the time you need on Tuesday, Wednesday, Thursday, but she didn't go further than that. And I wonder if she was indicating to the jury, that should give you enough time. That should give you enough time. That's not shady. That's this game. That is having your lawyers on top of their game. And this is something lawyers have to stay on top of. It's exactly like chess. You are not just playing the game. You are not just trying the case, but you are also playing your opponent. That is exactly how our system, it's an adversary system. That's how it's set up. It truly isn't shady. It is, I understand why it can feel that way, but that is part of the work. And whether, and the judge was like, the designation's the designation. So, or at least that's what it sounded like. Did Johnny risk taking the stand a second time to bait Amber? Possibly. And it got in some good evidence. It got in the evidence of those photos. I thought there was good evidence that came in and crossed for both Johnny Depp and Amber Heard, evidence we hadn't seen before that was powerful. Didn't the stats expert stress that it's the org he works for that accepted the money? Maybe he's just mad as Runkle that they made him do something that he couldn't do. I mean, no, he's hired out by his own company. I mean, technically, for a lot of things, my company gets paid, but also that then ends up my company pays me. I think that's more on the line of semantics. I'm sure you've covered this. Can you explain again what demonstrative evidence is? Demonstratives are not evidence. Demonstratives are showing the jury a chart, a graph, something that's not going to go back in evidence, but something that is, for an example, The testimony, what is said, is evidence. The demonstrative is just to help the jury understand what's being said. So that's why, and it's not evidence. What we also learned is that the judge is going to be very strict with, oh, let me try to pull back up and see if the court stream is still live. The judge is going to be very strict with, let me see, Sky News. The judge is going to be very strict with closing. Only evidence will be allowed to be played in closing. Okay, no, this is replaying earlier today is what I'm saying. So the court's going to be very strict with closing. The court is not going to allow them to bring in video. And you guys asked about this earlier today, and we didn't know what the judge was going to do, and now we do. They can't play video depositions. They can't play or replay video of the trial like we've been covering here. They can talk about testimony. They can't put up transcripts. They can only use things that are in evidence. And that's very interesting. So they're not going to be able to play, Amber Heard testifying on the stand from 3 days ago. That's not evidence for the jury to consider. They can play the audio that's been admitted into evidence. So Rooster Mateo, amazing how much the channel has grown since the start of trial. I don't have words for it. I've been absolutely blown away by the support and by the amount of people that are finding the channel. I'm going to go look at where we're at on that. It's just been absolutely bananas. I don't have words for it. I mean, Emily, share your screen. We are professionals here, and you got yeeted from your own stream. We're at 545, pushing towards 550. It's absolutely unbelievable to me. So thank you all for the support. Why isn't Ben arguing this? Isn't he the head of Team Johnny Depp? I think they had somebody assigned to jury instructions because Ben is the quarterback, and he's doing all the legal strategy and pitching in, and he's prepping for his closing tomorrow. I think he trusts his team. Watching Team Depp work together has been very cool. They absolutely seem to trust each other, and they work really well together. And that's been really, really neat. Will Johnny and Amber be present for closing arguments? They absolutely should be. They don't need to be present for the verdict, though. And I think they both will want to be present for the verdict. I don't know if that's a good idea. What, if anything, will be addressed with regard to the sanctions? When, if ever? We'll hear it in the jury instructions tomorrow. If the jury instructions go up online, I will try to pull them and give comment on them later today. But then we'll know. We'll know if we see it in the jury instructions. If we don't see it in the jury instructions, it can come up if the court rules on that post-trial. Are Amber Heard and Johnny Depp and witnesses now free to view and post on social media? The witnesses are free once they're released. So now every single witness is officially released. Johnny Depp and Amber Heard are not free to post on social. The court had said a few days ago, no posts till the end of trial. I think the end of closing is the end of trial. I think it would be good form for neither of them to post until a verdict comes in. And Johnny Depp and Amber Heard have been free to view social throughout the trial. And witnesses subject to recall were not. So now everybody is kind of free from that. I do have a PO box. It should be in the description. It's also in my links on Instagram, but it should be in my description. What are the chances of an appeal from Amber Heard if she loses? High. Do you think it's even worth it? Not on anything that I've seen yet. I think the judge has made rulings that I'm like, is that your ruling? But they've been fair on both sides. What's your opinion when comparing jury systems like the U.S. to judge-only systems like in Germany? I myself got the feeling that the U.S. system sympathies have quite a bit of influence. Yes. In the jury system, you definitely have a big play of members of the community and if they are sympathetic to you or not. So you can end up with things that are a legally wonky result because of the jury. We're all human. When you go through legal training, you are, I think, taught to parse that out differently than we normally learn. So sympathies play a huge bit. Human perception plays a huge bit. How we take in information plays a huge bit. But that is, I don't know if that is a good thing or a bad thing because I have not done a deep academic study of the both. It's just something to be noticed. But when people choose, when the law is the law, people choose bench trials to just have the judge decide. This is an issue of law. Can you just decide who's right and who's wrong in this dispute? And it goes much faster. Ruthless Dragon. I usually listened to Duggar trial updates. Last night I couldn't even bring myself. I don't really get into commenting on other YouTubers and others on the platform, but thank you so much for the compliment. I appreciate it. I tend to not comment on other creators, even when they comment on me. Does anyone else working from home feel compelled to take a lunch break when the judge does? Yes. Can we get a feel on the jury percentage, Amber Heard versus Johnny Depp? Runkle really gave us a good view on that today when he said they did not seem to be buying what she was selling today. They might just be done. But normally if the jury's done, and I'm going to address that comment in a second, but normally if the jury's done, but empathetic to you, like we're already on your side, you see them engaged. Like we've got your back. We're already on your side. That's not what Runkle was describing that he saw today. Did anyone notice Whitney's face? Whitney looked stoic. And I actually feel, I feel for Whitney. Whitney looked stoic and stressed. And this has to be very stressful for Whitney, and being pulled away from family and being put on the stand and then having somebody contradict your testimony. I feel for Whitney. What happened to the gallery? I missed whatever Runkle had to say. He said he had stepped out, and so he didn't quite know. Can jurors take their notes home with them? No, they are not supposed to decide anything until the end of closing. And a lot of judges will not let the jury notes leave the courtroom ever. I still don't understand what Camille was getting at with the spilled wine photo. I may have missed an explanation earlier. Shannon, those photos, the spilled wine photos, were introduced as different exhibits from different days. The photo is the same. That's what she was getting at. The photo is the same, but the defense introduced them as two separate exhibits from two separate incidents from two separate days. How much money does it take to put together a trial like this? Millions and millions. How is the money divided among the attorneys? It depends on the firm. It just, how the attorneys have their fee agreements depends completely on how their firm works. Amber Heard slipped on the stand or intentionally put on the stand that she had spent over $6 million on this case. I don't think she was exaggerating on that. I think that's probably a close number. I think Team Depp could have spent upwards of 12, if not more, millions on this case. This is millions and millions. A conversation about how money factors into justice in the US is a conversation for another day, but it's a conversation that needs to continue happening, because what happens when you don't have $6 million to defend yourself? In the Cardi B case, we saw that Cardi B spent over like 1.4 million, but it was not protracted litigation like this. But that's still, in a year of litigation, over $1 million. It's just a lot. Sarah said, still on Hughes' part, I'm neurodivergent in many ways. This is painful to listen to. So much misrepresentation and maneuvering. The experts will expert. DUI guy has been a bit extroverted in the gallery and tweeting things. I have not looked at his Twitter. I have not looked at Twitter, not just his, but Twitter today. I saw Whitney looking back at DUI guy and Runkle, and she was not happy about what they were saying to each other. I didn't catch any of that. Did you see Amber Heard admit she wrote the op-ed? We knew she wrote the op-ed. We knew that she wrote the op-ed. She admitted it on cross that it was about Johnny Depp and others. I think that the shit's out of the horse on her admitting about the op-ed. I also think the ACLU testimony was devastating for that. I think their argument needs to focus on malice. It has to focus on the malice element. I said I was going to pull up the jury instruction. I'm going to do that real quick. It's also in last week's podcast. The one of the jury instructions, not all of them. It's also in last week's podcast. So if you want my breakdown of this a little bit deeper, the Emily Show podcast is where you will find that. But let me just pull this up real quick, because I said I was going to pull up. I wanted to talk about that malice element. Let me see where it is. I've got to go because everything crashed. Now I have to go digging into the caverns of my notes. Best in-court reactions. Runkle at Whitney Heard looked appalled and then surprised, and then I didn't see it. Runkle looks like a kid in candy store. I will, when I go back and watch, because I'm trying to listen and process and watch. When I go back and watch, I will absolutely talk about that. Where is my jury instruction on defamation? I need to, we're going to control F ourselves to find it. Command F ourselves, I suppose. Because I want to get to malice. Can we get to malice, please? Why aren't you searching? Search yourself. Use the force, Luke. All right, where is our jury instruction? I'm almost there. I'm almost there. Let's see. Liability issues. There we go. Liability issues, public figure defamation per se. This is the malice element. I think they should hammer on the malice element. Hammer the malice element tomorrow. This is the malice element that the jury will have to decide. And the jury instructions will look like this. We'll pull up the actual ones when we get them, when they go public. But this is what they're told they need to decide. Did the defendant make the statement? Is it about the plaintiff? This is the element that matters. Did the defendant make the statement knowing it to be false? Or did the defendant make it so recklessly as to amount to a willful disregard to the truth? Are you just like, la, 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 whatever, to the truth? That is with a high degree of awareness that the statement was probably false. That is what Amber Heard's team needs to focus on. If you find, A, the headline wasn't her, is going to be their argument, and B, it wasn't false. It's the truth. There's no disregard to the falsity because this is what happened to her. She knows this is what happened. She believes it. False, false, false. So that is what's going on. That is the malice element, and that is what needs to be proven. So let's see. I'm going to try to pull this. I have to switch my screen so I can actually read. I remember when an hour and a half was considered a long stream here. I do too. And then it was like, do we do 3 hours now? And now we're like, are we at 5 hours now? Because we didn't break the stream. That sounded, well, we're just going to leave that alone. Can we take the money we send tomorrow and donate it to Children's Hospital LA? I can try to set that up on the I will look and see. We will do a charity stream. I don't know. I need to look and see what my obligations are with certain things for tomorrow, but we can do a charity stream for sure. And all of you, I absolutely encourage you to gift to Children's Hospital LA or a local children's hospital in your area. They were unfairly impacted. I hope that this case has positively impacted them with everyone doing it. But I would not encourage you to send money to me if you want to donate it, because YouTube will take a percentage of it. So if you want to donate, I would highly encourage you, instead of donating it to me, to take it directly to and if you want to put it in Depp's name, you can. I know a lot of people are doing that. There is a lot going on in the world right now that can use help. And there's a lot going on in the US right now that can use help. So there are plenty of places to do that. But yes, I think that is a fantastic suggestion. And I think it's great. I've played your live stream in the background for weeks delivering my mail route. Awesome. Thank you, Amanda. I love stuff like this. Thank you. Thank you. Thank you. Hopefully I'm not killing your battery. You mentioned Judge A allowing sidebars to reduce a chance of appeal. Are there consequences for a judge if the case is overturned? Ego crush is kind of severe when you get overturned on appeal. Judges don't like being overturned on appeal, and judges like to protect their cases. The biggest negative consequence is that if a case gets overturned on appeal is that the appellate court can say, go back and do it again. And then you have to go back and do it again. And retrials are a lot. The amount of transcripts they brought in today, retrials added, because then it's not just your deposition. It's not just the UK testimony. It's now another trial testimony. And it's like, but you said this here and you said that there and you said that there. Doing it all again is the worst. So protecting the case from appeal is helpful. And this judge might just be like, we're going to let everybody hear it out. We're going to take our time. And she did that. She did. Thank you for championing neurodiversity. You're welcome, Emma, mom of a neurodiverse trans daughter with the whole world to look forward to. I love that. I bloody love your coverage of this trial. Thank you. And you are welcome. And yes, the entire world. Thank you for spending so much time with us during this trial. I love being here with y'all. It wouldn't be the same without you. Thank you. If I do not get to all the super chats, I'm going to try to get to the questions. That is where my priority is. Has Amber Heard's cross rant regarding Johnny Depp and the witness is why she wrote the op-ed about him, not like a major thing. It is a major thing because she just leaned into it today on Cross, just leaned in to this is why I wrote it. Oh, okay. Leaned into that it was about him. Yep. Defense seems to be operating under outdated thinking that nobody knows how technology works. And the jury has a lot. I mean, it's reasonable that the jury understands the basics of metadata and the basics of, oh, those are the exact same time. Is it hard for lawyers on opposite sides to maintain friendships with one another? No. Have you ever had to work opposite a friend? I have worked opposite people I am friendly with and very collegial with, and it's such a pleasant experience. It really is. It's just a pleasant experience because you kind of work together and you do your job, and it's your job. And even though you're on opposite sides, you don't have to be a dick to be a lawyer. And you can do your job well without it being personal. Thank you for all your hard work and patience. You're welcome. I like trying to explain things. If this trial is over if this trial is over, it's over. Well, except for closing. And one or the other side wins, will that side who lost need to pay all the costs related to the trial lawsuit? If the jury awards it, the jury can award it or the jury cannot award it. So if the jury awards it, then yes, but the jury doesn't have to. Tricks Flicks, breakout stars. Did we have our Star is Born moment? Did we have our Star is Born moment? I feel like LawTube as a whole had its Star is Born moment. Couldn't it also be damaging press for her proven leaks? It could be damaging to her. The jury's going to get to decide. BB, what was the jury reaction when she said that all the witnesses came to testify? And I think that was for Runkle. I'm sorry. All caps are very hard for me to read. I don't know because Runkle's already gone back to court. But it sounded like from the beginning of cross, the jury was just not on Heard's side. So yes, I think we got a lot of super chats about her admitting about the op-ed. Runkle was very clear that he did not think the jury was favorable to Amber Heard at the end of today. So yes. Okay, those are I'm going to get to some of the newer things. We are going to wrap up. Well, we're not all the way done. We've got closing tomorrow. I will be checking in our members' spaces. You guys, we're over still 130,000 in the chat. I am sure there are other streams going on. If you want to go check them out, it is my kiddos' first day of summer. So while I hate to leave you, and I do love being here, I am going to go check in with them. I am going to check in with our member spaces. I am going to give a summary over on Instagram and the Tiki Talk Talks. I am going to be answering questions probably later today after a break. Haven't eaten yet. Food's here. We just haven't had a time to eat it. So I'm going to do that. You guys, thank you so much for being here. I'm going to spend a little time. Just Jay, I will just ask if you guys all roll over to Legal Bites' stream. Please don't raid. It can be on the YouTubes. Not all creators welcome raids, but it's welcome to go in and say hi, but just sometimes raid could have a negative connotation. So if you all go join and support, just all go join and support. But I know it can be distracting for creators when the chat just floods. So just not a raid. You're welcome to go support, but it can be very distracting for creators when the whole chat is like, vroom. It can feel very overwhelming. So just please be mindful and considerate, and I appreciate you. Thank you for being here. Thank you for being Law Nerds. Come join us over at lawnerdsunite.com. Don't forget to join the text crew. I will see all of you tomorrow morning, bright and early, for jury instructions and then into closing arguments. Court starts at 9 a.m. Eastern. Law Nerds, we are adjourned for today. You are the best community on the internet. Thank you. And thank you for choosing to spend this trial with me. It has been an immense privilege. I can't believe tomorrow's the last day, but I am not done. We have so much to do, and I hope we get to do at least a few Jury Watch Hangout streams, which will probably be Tuesday. I'm going to see if I can round up some folks to do a Jury Watch, or if the jury doesn't come back on Friday, but to do a Verdict Watch stream where we talk about some of the stuff that came in court and some of the stuff that didn't. And with that, I will leave you and say good night, good afternoon, and I will see you soon. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.